gathered today in this august chamber to discuss matters of national importance, specifically on whether or not to proceed with the impeachment trial of the Vice President against the backdrop of a recent Supreme Court decision. May you always remind us that public service is a sacred trust, that no one is above the law, and that the majority's final decision is anchored on principles of fairness to create a just society. May our decision be made with calmness and humility. More than this highly divisive issue, may our paths be guided by your light when we discuss important pieces of legislation aimed at uplifting the lives of Filipinos and bringing progress to our nation. In the noise of political conflict, be our peace. Lord, please guide us to a clarity of direction in the face of uncertainty, that honor may guide us, that truth shall prevail, and finally, that our nation may unite. Amen.
Thank you, Senator Estrada. Secretary will please call the roll.
Roll call of members. The Honorable Senator Aquino, Senator Cayetano Alan, Senator Cayetano Pia, Senator De La Rosa, Senator Ejercito, Senator Estrada, Senator Gatchalian, Senator Go, Senator Ontiveros, Senator Lacson, Senator Lapid, Senator Legarda, Senator Marcoleta, Senator Marcos, Senator Padilla, Senator Pangilinan, Senator Soto, Senator Tulfo Erwin, Senator Tulfo Rafi, Senator Villanueva, Senator Villar Camille, Senator Villar Mark, Senator Zubiri, the Senate President.
With 22 senators present, Chair declares the presence of a quorum. Majority Leader.
Thank you, Mr. President. Mr. President, before we proceed with the reference of business, may I just be allowed to acknowledge some guests from the gallery? Guests of Senator Risa Ontiveros, Justice Conchita Carpio Morales, Commissioner Ed Garcia, Commissioner Christian Monsod, Commissioner Feli Aquino, and Justice Adolf Ascuna. Guests of Senator Marcoleta, Mrs. Edna Marcoleta, Congressman Paulo Henry Marcoleta, Ms. Kathleen Marcoleta, and Commissioner Rowena Guanzon. Guests of this representation, Mr. President, may we acknowledge also Justice Efren de la Cruz, former Congressman Doming Rivera, Attorney Rebecca Chato, and the members of the body of Christ. We welcome all of them in this august chamber.
To the aforementioned guests, welcome to your Senate. Majority Leader.
Mr. President, this juncture, I move that we proceed with the reference of business.
Any objection? Hearing none, motion is approved. Secretary is directed to comply.
Resolution, Senate Joint Resolution Number 1, Joint Resolution upholding fidelity to the 1987 Constitution relative to the duties and responsibilities of the Bicameral Conference Committee with a view to ensuring transparency and accountability in the enactment of laws, introduced by Senator Soto III, Ontiveros, Lacson, Legarda, Zubiri, Pangilinan, and Aquino IV.
The Committee on Rules.
Proposed Senate Resolution 24, urging the proper Senate Committee to conduct an inquiry on the alarming level of credit card indebtedness among Filipinos and to recommend policy measures in line with constitutional principles of social justice and consumer protection to address the rising issue of credit card indebtedness and to promote financial literacy among consumers. Senator Villar C.
To the Committee on Rules.
25, resolution urging the proper Senate Committee to conduct an inquiry on the alarming rise of leptospirosis cases in the Philippines and to strengthen the measures for its effective prevention and control. Senator Villar C.
The Committee on Health and Demography.
26, resolution urging the proper Senate committees to conduct an inquiry on the social, economic, and public health impacts of online gambling operations in the Philippines, especially among the youth and minors, aiming to strengthen the regulations that will protect the youth and minors from exposure to online gambling and holding online platforms, operators, and promoters accountable. Senator Villar C.
The Committee on Games and Amusement and Youth.
27, resolution urging the appropriate Senate committee to conduct an inquiry on the proliferation of online job offer scamming activities with an end view of strengthening existing laws, rules, and regulations to combat fraudulent and deceptive practices. Senator Villar M.
To the Committees on Science and Technology and Labor and Employment and Human Resources Development.
28, resolution directing the proper Senate committees to conduct an investigation on the utilization of funds allocated for national flood control projects and related programs with the end in view of ensuring transparency, accountability, and the effective implementation of flood management strategies in light of worsening and recurring flooding across the country. Senator Aquino IV.
The Committee on Public Works.
29, expressing the sense of the Senate to urge the Executive Department to appropriate agencies to extend all necessary assistance in facilitating the voluntary return of former President Rodrigo Roa Duterte to the Philippines, Senator Marcoleta.
To the Committee on Rules.
30, resolution strongly condemning the illegal arrest and surrender of former President Rodrigo Roa Duterte to the International Criminal Court, Senator Marcoleta.
To the Committee on Rules.
31, resolution directing the appropriate Senate committee to conduct an investigation in aid of legislation into the reported abuse of flood control programs and related projects with the end view of adopting a comprehensive and effective approach to address the country's persistent and destructive flooding problem, Senator Tulfo E.
To the Committee on Public Works.
32, resolution congratulating Mark Magnifico Magsayo for his hard-won victory at claiming the World Boxing Council Continental America Super Featherweight title, Senator Ejercito.
To the Committee on Rules.
33, resolution commending and congratulating Yumer Marshall for his recent boxing victory, Senator Ejercito.
To the Committee on Rules.
34, resolution loading the immense contributions of Manny Pacman Pacquiao in the field of professional boxing, Senator Ejercito.
To the Committee on Rules.
35, resolution amending Rule 10, Section 20 of the Rules of the Senate by Senator Soto III, Ontiveros, Lacson, Legarda, and Zubiri.
To the Archives.
36, resolution directing the appropriate Senate committee to conduct an inquiry on the alleged anomalies and corrupt practices by the Bureau of Immigration in the processing of tourist visa extension of foreign nationals, Senator Marcos.
To the Committee on Accountability of Public Officers and Investigations.
37, resolution directing the Committee on Health and Demography to conduct a thorough review and evaluation on the implementation of RA 11223, the Universal Healthcare Act, Senator Ejercito.
To the Committee on Health and Demography.
38, directing the appropriate Senate committee to conduct an inquiry to look into the possible immediate action of the national and local governments to address the climate change crisis with the end in view of developing and implementing comprehensive urban and rural planning reforms, Senator Padilla.
To the Committee on Sustainable Development Goals, Innovation, and Futures Thinking.
39, resolution directing the appropriate Senate committee to conduct an inquiry into the alleged questionable investments of the GSIS, Senator Marcos.
To the Committee on Accountability of Public Officers and Investigations.
40, resolution directing the appropriate Senate committee to conduct an inquiry into the recent trade deal between the Philippines and the United States of America, Senator Marcos.
To the Committees on Ways and Means, Trade, Commerce, and Entrepreneurship.
41, resolution directing the appropriate Senate committee to conduct an inquiry regarding the update on the implementation of RA 10692 or the Philippine Atmospheric Geophysical Astronomical Services Administration Modernization Act of 2015 with the end in view of ensuring that the provisions of the law are satisfied and properly implemented, Senator Padilla.
To the Committee on Science and Technology.
42, directing the appropriate Senate committee to conduct an inquiry on the alarming rise in cases of babies being sold online and to identify and address the systematic gaps in the implementation of relevant laws and offices, Senator Cayetano P.
To the Committee on Women, Children, Family Relations, and Gender Equality.
43, resolution congratulating and commending Alexandra Alex Maniego Ayala for her historic achievements and outstanding contributions to Philippine tennis, Senator Cayetano P.
To the Committee on Rules.
44, resolution affirming the legally binding character of the international climate obligations and urging their effective implementation in light of the 2025 International Court of Justice Advisory Opinion, Senator Legarda.
To the Committee on Rules.
45, commending and congratulating Alas Pilipinas, the national women's volleyball team, for winning silver medal in the 2025 Asian Volleyball Confederation Women's Nations Cup, marking the country's best finish in the Asian level tournament in 64 years, Senator Estrada.
To the Committee on Rules.
46, commending and congratulating Alexandra Maniego Ayala for her runner-up finish at the 2025 Eastbourne Open and for making history in becoming the first Filipina to reach a Women's Tennis Association final, Senator Estrada.
To the Committee on Rules.
47, commending and congratulating pool player Carlo Biado for winning the 2025 World Pool Championship held from 21-26 to July 25 in Jeddah, Kingdom of Saudi Arabia, becoming the first Filipino to win the prestigious title twice, Senator Estrada.
To the Committee on Rules.
48, commending and congratulating the Strong Group Philippines basketball team for winning the championship in the 44th William Jones Cup men's tournament held from 12 to 20 July 2025 in New Taipei City, Taiwan, Senator Estrada.
To the Committee on Rules.
49, directing the appropriate Senate committee to conduct an inquiry into the delay and abrupt postponement of the final phase of the commissioning of the MILF forces and weapons, Senator Marcos.
To the Committee on National Defense and Security, Peace, Unification, and Reconciliation.
50, resolution calling for Senate inquiry into the quality, reliability, and accessibility of water services provided in areas covered by joint venture agreements between local water districts and private entities, with the end in view of developing an effective regulatory framework that safeguards consumer welfare and promotes transparency and accountability, Senator Tulfo R.
The Committee on Public Services.
51, resolution directing the Senate Committee on Migrant Workers to conduct an inquiry into the existing policies and regulations of the Department of Migrant Workers pertaining to the deployment of Filipino seafarers in high-risk maritime areas following several attacks on ships in the Red Sea, Senator Tulfo R.
The Committee on Migrant Workers.
52, resolution directing the Senate Committee to conduct an inquiry on the existing requirements and regulations of the Marina pertaining to the conduct of seafarers training and refresher courses with the end in view of adopting alternative methods to ease the burden of seafarers. Senator Tulfo R.
To the Committee on Public Services.
53, resolution directing the appropriate Senate Committee to conduct an inquiry on the exorbitant, unreasonable, and predatory prices for domestic flights with the end in view of reviewing the current rules and regulations related to the rates, charges, and fares of commercial airlines. Senator Villar M.
To the Committee on Public Services.
54, resolution directing the appropriate Senate Committee to conduct an inquiry into potential irregularities in the management and use of OWA funds with the end in view of ensuring accountability and transparency in the use of OFW's hard-earned money. Senator Tulfo R.
To the Committee on Migrant Workers. Majority Floor Leader.
Mr. President, at this juncture, the distinguished gentleman from the great province of Tarlac and Rizal, Senator Rodante Marcoleta, is seeking the floor to deliver his privileged speech. I move that he be recognized, Mr. President.
Senator Marcoleta is recognized to deliver his privileged speech. You may proceed, sir.
Thank you, Mr. President. Mr. President, I rise on a question of privilege. Today, I believe the entire nation awaits the disposition of the matter in regard to the impeachment complaint filed against the Vice President, Sara Duterte. In the light of the recent but unanimous decision of the Supreme Court, Mr. President, this decision was promulgated on July 25, 2025, declaring said complaint to be unconstitutional, void ab initio, violative of due process, and that the Senate in the first place did not acquire jurisdiction over it. Take note, Mr. President, it even said that the decision is immediately executory. But before I continue, Mr. President, let me put on record that the initial proceedings, impeachment proceedings conducted by the Senate in the 19th Congress have never been formally carried over to the Senate of the 28th Congress. I do not know, and I'm not aware, I cannot recall of any action so far taken by this august chamber to the effect that the initial impeachment proceedings, which were deemed to have been terminated at the expiration of the 19th Congress at noon of June 30, 2025, have been miraculously brought to life into the present Congress. That having said, Mr. President, I'd like to continue. Mr. President, the decision of the Supreme Court did not dwell on the intrinsic merits of the impeachment complaint filed against the Vice President. It zeroed in merely on the procedures and the processes taken by the House of Representatives. To repeat, it declared the whole impeachment complaint constituting the articles of impeachment to be unconstitutional, violative of due process, void ab initio. Simply because the rules of procedure in impeachment proceedings in the House of Representatives were never followed. And they violated the one-year ban on multiple impeachment complaints as prescribed under Article 11, Section 3, Paragraph 5, which says that no impeachment proceedings shall be initiated against the same official more than twice within a period of 1 year. Napakasimple po ng sinasabi doon, Mr. President. no impeachment proceeding should be initiated against the same person more than twice within a period of 1 year. Ilan po ang impeachment proceedings, impeachment complaints na ipinail ng House of Representatives? 4 po eh. The first one started in December 2. Sumunod po December 4. Meron pang sumunod na December 19 hanggang sa umabot po ng February 5. Yun nga pong ipinangangalandakan na impeachment complaint which was signed by more than 1/3 of the members of the House of Representatives. Nasunod po ba? Nasunod po ba ang tuntunin ng House of Representatives? Noon pong nag-require ang Supreme Court, Mr. President, tinanong po yung House of Representatives in connection with the 2 petitions filed by several parties before the Supreme Court. One of the items required by the Supreme Court is for the House to give the status of the first 3 complaints filed. Ano po ang sagot ng House of Representatives? Yun daw pong unang 3, the one filed in December 2, December 4, and December 19 were all archived. Nasaan po sa rules ng House na yun pong mga impeachment complaints na ipa-file ay archive? Wala po. Pwede po bang ipakita yung slide na kung saan ay makikita natin ano po ba ang proseso kapag may nag-file na isang impeachment complaint? Ayan po yung Rule 2. Ang sinasabi po sa Rule 2, Mr. President, hindi sa Rule 3, sa Rule 3. Rule 2, Section 3. A verified complaint for impeachment by a member of the House or by any citizen upon a resolution or endorsement by any member thereof shall be filed with the office of the Secretary General and immediately referred to the Speaker. Bakit hindi po nasunod ang tuntunin na ito, Mr. Speaker? Kailan po ni-refer ng Secretary General sa opisina ng Speaker yung impeachment complaint dated December 2, 2024? Kailan po ni-refer ng Office of the Secretary General yung impeachment complaint na i-file ng December 4? Wala po silang sagot. Kailan po ni-refer ng Office of the Secretary General yung impeachment complaint that was received on December 19? Wala po silang sinasabi. Kung titingnan po natin ang sagot ng Solicitor General in behalf of the House of Representatives, ang sabi po nila, the Secretary General diligently referred simultaneously all the impeachment complaints to the office of the Speaker on February 5, 2025. Immediately po ba yan, Mr. Speaker? December 2, December 4, December 19, at isinama po yung February 5, all of them were simultaneously referred to the office of the Speaker on February 5. 2 buwan po ang kanyang ginugol para lang i-refer sa office of the Speaker. Ano po ang immediate doon? Wala po. Wala po silang sinunod. Wala silang ni-refer at ni-refer nga po delayed. Nung ma-refer po, ang sabi po ng Solicitor General, the 4 impeachment complaints were included in the order of business doon po sa session number 36. You will note, Mr. Speaker, hindi po niya ibinigay bilang annex yung order of business in section number 36. Ang kanya pong ipinakita ay yung journal number 36. Bakit po? Sapagkat hindi totoo na yung 4 na impeachment complaints were included in the order of business. Mr. President, I have a copy of the order of business, session number 36. And I will deposit a copy to the office of the Senate Secretary for everyone to see and examine for themselves kung talagang in-include nila sa order of business. Wala po. Saan po nila in-include? Doon sa journal. Iba po yung journal sa order of business. Alam po niyo kung bakit lang nalagay sa journal, Mr. Speaker? Idinagdag po nila as additional reference of business. That is not the requirement of the Constitution. Pwede po ba nating makita yung slide, ano yung sinasabi po ng Constitution? A verified complaint for impeachment may be filed by the member of the House, blah, blah, blah. Ang sinasabi po rito, iba yun. Hindi po yun. Sorry po. Nakalagay po, in-include sa 10th session day. Yun po yung section number 36. Hindi po totoo yun. Ilang violations na po? Kanina po, in-archive po yung tatlong violations. Hindi po ni-refer sa Committee on Justice. Pangatlong violation. 6 na po. Ngayon sinasabi po, in-include po sa order of business. Hindi rin po. 3 violations na naman. 9 na po. At sabi po nila, yung session 36 is the 10th session. Hindi po. Bilangin po natin yung December 2. That was the date when the first complaint was filed, endorsed, and received by the Office of the Secretary General. December 2 is session number 26. Mr. President, bilangin po ninyo yung session number 26 up to session 36 na sinasabi ng Solicitor General. Yun po ang 11th session. That was not the 10th session. Ang 11th session is session number 35. Just for the record, Mr. Speaker. So ilang violation na po yan? Balikan po ninyo yung Rule 2 na nandyan po sa slide, Mr. Speaker. Ano po yung mode of initiating impeachment? Ganito po ang sinasabi ng rule of the House of Representatives. Impeachment shall be initiated by the filing and subsequent referral to the Committee of Justice. Ito po yung Sereno versus, Francisco versus House of Representatives. Verified complaint for impeachment filed by any member of the House of Representatives, i-refer po sa Committee on Justice. Verified complaint filed by any citizen upon a resolution endorsement by any member thereof, i-refer po sa Committee on Justice. A verified complaint or resolution impeachment filed by at least 1/3 of all members of the House, i-refer din po sa Committee on Justice. Bakit po ang ginawa nila nung makakuha sila ng higit sa 1/3, dali-dali po nilang tinransmit sa Senate? Ang pagkakakala po nila, Mr. Speaker, sapagkat ang pinagbatayan po nila ay yung Rule 4 na kung saan in Section 14 sinasabi po endorsement of the complaint resolution to the Senate. Ang sinasabi lamang naman po noon, Sir President, ay yung pamamaraan kung paano po i-endorse yung impeachment complaint that was signed by 1/3 or even more members of the House of Representatives. Hindi naman po sinasabi doon na hindi na sa i-refer sa Committee on Justice. Bakit po nakalagay dito sa rule? Kailangan i-refer din siya sa Committee on Justice, but they never did. Mr. Speaker, Mr. President. So ilang violations na po ito? You cannot use Section 14 in isolation of Section 2. Hindi po pwede yun. Binigyan po ba ng discretion, Mr. President? Was the House given the discretion to select, to withhold and select from among the 4 impeachment complaints, which will be the one to be transmitted in the Senate in derogation of the 1-year ban rule? Wala po silang discretion. Kung sila po mismo ay hindi sumusunod sa tuntunin. Bakit po ngayon ay napakarami pong nagsasalita? Na parang akala mo ay ang Supreme Court pa ang nagkasala, ang nagkamali. Samantalang ito po, napakasimple po ng tuntunin, hindi kailanman sinunod. Even the 10th session day na sinasabi nila, 11th session day nung ilagay po nila sa order of business, sabi nila. They never included them in the order of business. Wala po. Nasa akin po yung kopya. Ano ba po ang pagkakamali? Mr. President, ipakita po natin yung last page ng impeachment complaint. Pakita po sa slide. Ayan po, Mr. President. Subscribed and verified before me. Sabi po ng Secretary General. Saan ba yung kopya ko rin? Subscribed and verified before me on this blank day of February 2025. Wala pa pong date. Ito po ba ang verification, Mr. President? Hindi po. Ang verification po ay nakasaad po sa mismong tuntunin ng House of Representatives. Balikan po natin ang Section 3. Ano po ang sinasabi? Section 3, Paragraph 2. An impeachment complaint is verified by an affidavit that the complainant has read the complaint and that the allegations therein are true and correct of his personal knowledge or based on authentic records. At the very least, yun ang dapat na ilagay po. Nakalagay po ba sa verification dito? Ng Secretary General ng House of Representatives? Wala. Ito po'y parang jurat lang sa isang affidavit. Sinasabi lamang po dito, kilala niya yung nagsipirma sa isang dokumento. Na ang dokumento ay naglalaman ng 32 pages. This is not the verification required under the rules of impeachment by the House of Representatives. Ang totoo po, kung balikan po natin ang Section 14, nandyan po sa slide. Isinulat na po sa tuntunin kung ano po ang dapat kopyahin nila para magkaroon ng tunay na verification. Hindi pa po nila kinopya. Mr. President, ito po yung contents ng verification na dapat sana yun ang nilagay nila sa complaint. We, sabi po rito, after being sworn in accordance with law, depose and state that we are the complainants in the above entitled complaint or resolution of impeachment, that we have caused the said complaint resolution to be prepared and have read the contents thereof, and that the allegations therein are true of our own knowledge and belief on the basis of our own reading and appreciation of documents and other records pertinent thereto. Kokopyahin na lang, Mr. President. Hindi pa nakopya. Mr. President, alam mo po, nung ako'y grade 4, yung teacher po namin, binigyan po kami ng isang short quiz. I-drawing ninyo kanya yung Bicol region. Siguro po 1963 yun, Mr. President. Yung Masbate, hindi pa kasali sa Bicol region. O hindi, kabisado ko naman po sapagkat mahilig po ako sa social studies, Mr. President. Meron pong dalawang nangungopya sa akin. Yung isa nasa likod, yung nasa kaliwa ko. Yung nasa likod po, nakopya niya pong tunay yung aking drawing. Pinagalitan siya pero ipinasa po sapagkat nakopya niya po yung aking drawing. Yung isa po, nangopya na nga, hindi pa niya nakopya. Ang kinopya po, Masbate. O wala po. Hindi po siya nakapasa. Ano pong ibig ko sabihin dito? Kukopyahin na lang eh. Alam po ninyo sa mga litigation lawyers, practicing lawyers worth their salt. Wala ka lang certification of non-forum shopping, i-dismiss ka ng Supreme Court. Paliwanag po yun. Hindi subscribe yung complaint mo, dismiss ka kagad. Mahigpit po ngayon eh. Ito po, this is an impeachment complaint. You are removing the second highest official of government. Yun lamang pong verification. Sablay na po eh. Ano pong nakalagay dito? Section 3, Paragraph 3. An impeachment complaint required to be verified which contains a verification based on information and belief or upon knowledge or information and belief or lacks proper verification, katulad po nito ngayon, shall be treated as an unsigned impeachment complaint. So pwede pong tratuhin pala ngayon sapagkat wala pong verification. It may be treated as unsigned impeachment complaint. Paano ba yun? Pagkatapos magsasalita po ang napakarami. Alam po ninyo kung, Sir President, kumbaga po sa nagluto ng sinaing, pasensya na po kayo kung kinakailangan ako po'y gagawa ng pagkahalin tulad, ano. Ang impeachment complaint po ay parang sinaing na niluto ng House of Representatives. Hilaw po eh. Hilaw na hilaw. Ano po yung hilaw sa Bicolano, Mr. President? Hilaw din po yata. Sa Bisaya, hilaw din po. Sa Kapampangan, magadto, Mr. President. Sa Waray po, matagudtod. Sa Ilonggo po, lagdos. Sa Ilocano, marakusol. Sana po tama ang aking pagkaka-pronounce. Ang dami pong nagsasalita, Mr. President. Doon lang po sa House of Representatives, isa pong bagong pasok doon. Ngunit patagal na pong nagserbisyo sa ating bansa. Naging senadora, naging Secretary of Justice, naging chairman ng Human Rights Commission. Alam po ba kung ano sinabi niya sa isang panayam? Ito po, nakuha ko. Harap-harapan na tayong niloloko. Kakaibang korte ito. Sana sa palengke na lang final ang impeachment case. At least doon, may nagtitinda ng totoo. Sana po, magtinda po siya ng matagudtod na kanin dyan sa Samar. Baka may bibili kaya. Pwede kaya siyang pumunta dyan sa Pampanga po para magbenta ng magadto na kanin. Kung may bibili, baka sakali. Pumunta kaya sa Panay para magbenta ng lagdos na kanin. Wala po siguro, Mr. President. Baka ngayon dagan dingding, hindi pa patusin. Huwag pong ganun. Ang dami na pong nagsipagsalita. Samantalang hindi po nila nakita. Ang dami, kayo po nagsimula ng mali. Hindi naman po sinasabi ng Korte Suprema na kailanman ay huwag kayong mag-impeach, huwag na kayong mag-file. Ayusin nyo lang po eh. Yun lamang po ang gustong mangyari dito. Ayusin nyo. You want to impeach the Vice President, do it in the right way. Hindi naman po tinignan ng merito eh. Ang sinasabi yung proseso, hindi po nyo sinunod eh. Sinasabi na nga, walang impeachment complaint bukod sa isa. Laban sa isang opisyal sa loob ng isang akalain mo namang 4 po kagad ang ipinay. Pagkatapos yung 4, i-consider mo na isa. Hindi naman po yata tama yun, Mr. President. Mr. President, gusto ko pong basahin isang parte ng official statement of the Integrated Bar of the Philippines and the Supreme Court's decision in Duterte versus House of Representatives, August 1, 2025. And I quote, "Disagreement with the court's reasoning is neither unwelcome nor unexpected. Dissent is not foreign to a democracy. It is essential to its survival. But to incite public repudiation of its authority, or even just to call for its outright defiance, erodes the very foundation of the legal order. Such actions disturb the equilibrium of powers and imperil the integrity of our democratic institutions, especially when appropriate legal remedies remain available within the framework of our constitutional system. If every adverse ruling becomes an invitation to disobey, the law ceases to be a constraint on power and becomes its casualty. The Constitution does not require agreement. It demands adherence." Ang sinasabi po ng mga ibang kasama natin, magpapile pa naman ng motion for reconsideration. Bakit hindi natin hintayin? As I said, Mr. President, if you are a practicing lawyer worth your salt, you are confronted with the unanimous decision of the Supreme Court. In a firm voice, it says this is unconstitutional, void ab initio, violative of due process, and the Senate never acquired jurisdiction over this. and it is immediately executed. Parang sinasabi niya sa'yo, wala ka ng room mag-file niyan. Is anyone expecting that even one soul of the members of the Supreme Court will reverse himself? We cannot depend our action, Mr. President, on the fortunes of litigation. Naalala ko pa nga po doon sa kaso ng Francisco versus House of Representatives, the former Chief Justice, Renato Puno, in his separate concurring opinion, naalala ko po ang sabi niya, with the possibility of 2 impeachment complaints reaching the Senate, the good Chief Justice said that the Senate, in the exercise of its primary jurisdiction, can decide the question of whether or not the 1-year bar rule has been violated or not. The Senate can even decide if on its face the impeachment complaint has no legal basis. At ang sabi pa po niya doon, Francisco versus House of Representatives, sabi pa niya ron if the Senate finds that the 1-year bar rule is violated or that the impeachment complaint has no legs to stand on, that will be the end of the entire controversy. He was saying that let's give all the remedies available to the House and the Senate because of their primary jurisdiction. But when the case is ripe for judicial determination, it was the view of the former Chief Justice that the Supreme Court at that time, and only at that time, when it can speak with great moral authority in order to compel the loyalty, the respect, and the obedience of our people. Mr. President, when the Supreme Court negates the actions of a co-equal branch of government, it does not assert its superiority. Instead, it upholds the supremacy and the dominance of the fundamental law of the land, the Constitution. And so the Supreme Court has already spoken. The last arbiter of law, it says the complaint is unconstitutional, is void ab initio, is violative of due process. The Senate never acquired jurisdiction over this. It is immediately executory. On that note, Mr. President, I respectfully move that the impeachment complaint be dismissed. I so move, Mr. President.
Majority Floor Leader.
Mr. President, before, Mr. President, we act on the motion of the distinguished gentleman from the great province of Tarlac and Rizal. Mr. President, the motion is not among the privilege motions listed under our Rule 32, Section 90 of our rules. Therefore, Mr. President, it is debatable and may be subject to clarificatory questions. Nonetheless, Mr. President, our movant, Senator Marcoleta, has the floor, and Mr. President, subject to his consent and with his magnanimity, clarificatory questions on the motion may be entertained. In fact, Mr. President, we have some members of the Senate who wanted to interpellate with the permission, Mr. President, of the...
What is the pleasure of Senator Soto, our distinguished Minority Floor Leader?
Thank you, Mr. President. If the distinguished gentleman from Tarlac favor me with a few questions, I will be gladly accepting his favor. And if the Senate President will allow me, after a few questions, I will make my own manifestation to that effect.
The gentleman may proceed. Should Senator Marcoleta so allow it?
Yes, Mr. President.
Thank you, Your Honor. Thank you very much, Mr. President. Thank you. So, listening to the privileged speech of the distinguished gentleman from Tarlac, the basis of your motion to dismiss is the Supreme Court's decision, which is now pending appeal by virtue of the MR or the motion for reconsideration filed last Monday by the House of Representatives, is it not, Your Honor?
The question whether is it
Yes, your
Subject
basis
to
for
appeal.
your motion to dismiss is based on the Supreme Court decision that the so-called impeachment is unconstitutional, based on their decision.
Yes, Mr. President, Your Honor, that's very, very clear and categorical.
Correct. The Supreme Court decision, Mr. President, although immediately executory, is not yet final, thus appealable. Ngayon, naka-apela na. Marami nagtatanong, kung naka-apela na, ba't tayo nagmamadali? Na-dismiss ito sa atin. So may I ask the gentleman, what will happen if we prematurely dismiss the case and the Supreme Court subsequently grants the MR and reverses its own decision?
The question, Mr. President, is speculative.
Yes, yes. May I have a speculative answer, Mr. President?
We cannot speculate. We can only guess, second guess, because on the basis of our experience as a practicing lawyer, Mr. President, ito pong ganitong klaseng desisyon, talaga pong wala na pong kaduda-duda na kahit po mag-file pa tayo ng motion for reconsideration. We are hoping against hope. It is as if we are wishing for the moon. Palagay nyo po, palagay nyo lang po merong isa na nag-reverse. Hindi rin po ma-overturn eh. Kasi po ang kailangan po ninyo ay 8 ang mag-reverse. Sa inaakala po ba ninyo, meron kayong makukuhang 8 na pumirma doon sa unanimous decision na babaligtarin po nila yung kanyang sarili. Kaya napakahirap pong mag-speculate, Mr. President.
I will accept the answer of the gentleman, but I have done my research, Mr. President. And to remind everyone, the reversal of the Supreme Court's own decision is not impossible, even in landmark cases. In the case of Labogal, Bilaan Tribal Association Incorporated versus Victor Ramos, GR number 127882, December 1st, 2004, questioning the constitutionality of Republic Act 7942 or the mining law, the Philippine mining law. The Supreme Court granted the MR, reversing and setting aside its earlier ruling. And also, Mr. President, just a few days ago, the Supreme Court reversed its own ruling on the definition of a stockholder. This is the case of Lily Lopez versus Lolito Lopez with GR numbers 25497-957-58. So may kasabihan po tayo, ang tumatakbo ng matulin, kung matinik ay malalim. Kaya dapat siguro pag-isipan muna natin kung tama ba na bago magdesisyon ang Supreme Court, basta ibasura na natin ang kaso na ito.
Unang-una po, Mr. President, gusto kong malaman, yung po bang mga kasong sinabi nyo, unanimous decisions po ba lahat?
I am not sure about that. But one thing I can say is that if there is a mistake, a unanimous decision could become a unanimous mistake.
Wala pa pong nangyaring gano'n, Mr. President. At saka po tayo, pag nananakbo, ako po ay nakasapatos at saka sa kalsada kaya hindi po ako matitinik.
Well, Mr. President, there's always a first time. Regardless of whether it's unanimous or not, unanimous decision does not bar an appeal or a reversal, Mr. President. That is one thing for sure. Now, secondly, where is the ball, Mr. President? Or meaning the impeachment case itself? Is it in the Senate? or in the impeachment court? Didn't the impeachment court throw it back, remanded, returned to the House of Representatives? So what are we dismissing in the Senate kung wala sa atin ang kaso? Can we continue hearing the case and dismissing it without the impeachment case in our hands? Can we throw the ball out when the ball is not in our possession? Siguro naman dapat magkaroon tayo ng tinatawag nating sense of proper sequencing of moves. Nasaan po ba yung impeachment case?
Mr. President, kanina po sa aking clarificatory statement, ang sabi ko nga po, yung ginawa pong initial proceedings noong 19th Congress Senate, yun po ay nangyari sa panahon po ng 19th Congress at lahat po yun ay naisantabi lahat sapagkat natapos nga po ang termino ng 19th Congress on June 30, 2024. Kaya po natin sinasabi, Mr. President, na dinidismiss na po natin ngayon sapagkat tayo po ang nasa lugar na sinasabihan ng Korte Suprema nung sabihin niyang ito ay immediately executory. Sino pong mag-i-execute nun? Hindi naman po i-execute yun ng House of Representatives. Maliwanag naman po na tayo lamang ang tinakdaan ng kataas-taasang hukuman na gumawa ng paraan para isantabi na po ang usaping ito sapagkat napagtibay nga nila na ito'y unconstitutional, void ab initio, at wala na po tayong jurisdiction para dito.
Thank you, Mr. President. Your Honor, thank you. But as I said earlier, not because it is immediate and executory does not mean it's not appealable. Now, to continue, Mr. President, I hope you don't mind. I will be posing a question, but then I will be doing a manifestation based on this question that I will be posing. So I'm certain that the gentleman from Canal Rock has read the 97 pages ruling of the Supreme Court to come up with this motion. So the question is, must we agree on the statement of the decision of the Supreme Court on page 3, page 56, as basis that the one-year ban has set in? With that question, allow me to proceed with my manifestation with your permission, Mr. President. For the benefit of our colleagues, my colleagues, the last paragraph of page 3 states that, quote, since the 19th Congress terminated, the 3 impeachment complaints became enacted upon, end of quote. Again, this was reiterated in page 56, second paragraph of Roman numeral 5. It says, quote, the House of Representatives, however, was unable to act on the first 3 impeachment complaints because of the adjournment of the 19th Congress. To continue, for constitutional purposes, the first 3 complaints were effectively dismissed. In both instances, Mr. President, the Supreme Court was referring to the February 5, 2025 adjournment. But they have, erroneously believed that the said adjournment is the same adjournment with the sine die adjournment that ends a Congress. It is not. February 5 did not terminate the 19th Congress as stated in the decision. The sine die adjournment of the 19th Congress was on June 13, 2025, wherein the last session day was last June 11. Mr. President, and for the information of the public, there is a world of difference between adjournment versus adjournment sine die. Sa atin, pag nag-adjourn tayo for the Christmas break, nag-adjourn for the Easter break, nag-adjourn for the election period, nothing dies. The treaties, bills, resolutions, anything filed continues. It is never archived. Well, perhaps the lawyers of the ponentes did not realize that, or they were not familiar with the rules of Congress. As I said, this is a world of difference. Now, this is a transcendental case. Ang laking constitutional issue. Wala man lang oral arguments, or at the very least, a consultation with some members of Congress or members of the bar na nakakaintindi ng rules ng Congress regarding the procedure. In that matter alone, Mr. President, kasabihan ninyo mga lawyer, falsus omnibus, falsus unos, falsus omnibus. Mistake in one, mistake in all. In that manner, they wouldn't have decided based on their unfamiliarity with the legislative process. May mali agad eh. Pati ba legislative rules natin gusto nilang palitan? Ganun ba yun? Maybe not everyone may appreciate the importance of the legislative calendar of Congress. But us, it is a big deal. That's why I'm stressing this point. Concurrent joint resolution pa nga when we approve this calendar, only to be misinterpreted and used erroneously in this case. Nag-adjourn daw yung 19th Congress. Kaya na-archive lahat. Now, may kinopya lang, kopya, mali pa. Sabi nga kanina ng ating distinguished gentleman from Tarlac. Hilaw. Hilaw yung complaint. Hilaw din yung decision. In addition to this factual error, Mr. President, it can be seen in the website of the House of Representatives that the 3 impeachment complaints were referred to the Committee on Rules and were consigned to the archives on February 6, not February 5, as claimed in page 78 of the decision. Nag-housekeeping lang ang House, kaya in-archive, hindi to end the Congress. This archiving were not the results of the ending of the 19th Congress, but because of the fact that the 4th complaint were already filed and transmitted to the Senate. Eh dito pa lang, Mr. President, pilit na patunayan na barred ang 4th complaint. Kapag ayaw, may dahilan. Kapag gusto, may paraan. Now, to continue, Mr. President, and this is very much related. The Supreme Court, by the way, if it is wrong, if the complaint done by the House of Representatives was wrong, we cannot correct a wrong with another wrong. The Supreme Court essentially amended the Constitution by removing the 3rd mode of filing of impeachment complaint. This 3rd and speedy mode was enshrined there for a reason. In times that there is an urgent need to impeach a person who is influential and powerful, and may use his position to evade the law. The third mode, which is the fastest way, was provided in the Constitution. Why don't you ask the authors of this provision in the Constitution? Constitutionalists or CONCON delegates Munsod, Ascuna, Sarmiento. So, Mr. President, continuing, if the Supreme Court is now changing the meaning of initiating, then at the very least, please apply it prospectively. However, they are applying this new ruling retroactively, which is a violation of the doctrine of operative facts. Kung ganito kanilang kagustuhan, at susundin natin basta-basta, apektado din dito yung nakaraang impeachment, the impeachment proceedings. In the words of retired Supreme Court Senior Justice Antonio Carpio, I quote, "The said Supreme Court decision practically voided the impeachment proceedings against former President Joseph Estrada and former Chief Justice Renato Corona." Pag gusto talaga, may paraan. Pag ayaw, may dahilan. Pero wag naman sana pati sa mga ganitong bagay that will ultimately affect future impeachment and legislative rules and proceedings. Sa atin yun eh. I've read that the basis for the retroactive application of the new definitions because the Senate now has not acquired jurisdiction yet. Mr. President, ano tawag natin doon sa nag-constitute kayo as an impeachment court? Nag-robe pa kayo? You even sent out summons. Ano yun? June 9, the Senate President took his oath. June 10, nag-convene an impeachment court. Ni-remand to the House of Representatives. Tapos yung issue of the summons to the defense. Ano po tawag doon? Hindi nag-convene? Baka hindi nabalitaan ng Supreme Court na hindi nag-convene. Kaya naisabi nila yan. So, now, just an observation. I will try to shorten this, Mr. President. Just an observation, Mr. President. Well, not only myself, but several lawyers mentioned this to me, including my godson, former Senate President Aquilino Pimentel III. Naguluhan sila sa pagkakasulat ng desisyon. It is incoherent and some parts are off topic, sabi nila. Para bang pinagtagpi-tagpi, basahin niyo mabuti. Uli, ang daming gagaling ng mga abogado rito, basahin niyo. It even quoted the entire Article 11 of the Constitution, not only once, but twice. It seems there were two ponentes. Parang dalawa author dito. Well, that is there in my observations. Just an observation. So, Mr. President, the personalities in this present impeachment case is of no moment to me. The Vice President is a friend of mine. The former President, President Duterte, has been my friend since 1988. Everybody knows that. What I'm pointing out is the danger of outright dismissing the impeachment proceedings by virtue of a decision that is not yet final and still pending appeal. Justice Leoded himself said, Mr. President, I quote, "The Supreme Court is not perfect. Citizens and academics certainly have the right to call attention to the fallibility of the courts." Tama po yun. There is no perfect institution. Even Supreme Court ka, pwede mag-commit ng grave abuse of discretion or culpable violation of the Constitution. A case decided unanimously does not mean that it is infallible. For all we know, It is a unanimous mistake. That again can be corrected by setting aside and reversing prior pronouncements. Again, they have filed, the HRP has, the Office of the Solicitor General has filed the MR last Monday. So, in this regard, we shall wait for the resolution of the MR. Please, let us allow and give chance to the Supreme Court to rectify its decision, which contains clear and blatant errors. For their sake and for the sake of future proceedings, let us not dismiss forthwith. And in that light, considering the motion of the gentleman to motion to dismiss, I move to table the motion to dismiss. A motion to table has a higher precedence than a motion to dismiss. Thank you, Mr. President.
Mr. President, may I have a quick reaction to the manifestation of the gentleman?
The gentleman may do so if he so desires.
Mr. President, in the answer of the Solicitor General in behalf of the House of Representatives, there was already a categorical admission that the three initial complaints prior to the fourth one were dismissed because they were all archived. As I have said, archiving is not part of the rules of impeachment of the House of Representatives, but they just did it. Palusot lamang po yun, Mr. President. Paano mo i-archive nang hindi mo susundin yung tatlong steps na sinasabi ng sarili nilang tuntunin? These are not baby steps. These are constitutional steps. At kanina po ipinakita yung slides na yung inclusion in the 10th session day is constitutional. The referral to an appropriate committee is constitutional. There was no referral to any committee. Ang ginawa po nila, tinransmit nila sa Senate without requiring themselves to observe another provision of their own rules. This is to refer to the Justice Committee, where the Vice President might probably be given at least a modicum of right to defend themselves. That is what we call due process. Wala po eh. Inakala po nila na kapag may 1/3 na or more, ay pwede na nilang huwag gamitin yung Section 2 ng kanilang rules. Hindi po nakalagay yun eh. So hindi na po kailangan na i-distingue pa natin yung adjournment and sine adjournment. Kasi inadmit na rin po na in-archive nila kahit na wala po sa tuntunin. Kanina sa manifestation, tinanong din po. Kung wala tayong jurisdiction, paano yung unang initial proceedings? Pwede po yung initial proceedings ninyo will be considered under the doctrine of operative facts. Hindi pa po na-declare na wala pang jurisdiction ang Senate at that time. Ngayon lang po nangyari. Kaya po yung ginawa ng Senate of the 19th Congress, tama pa rin po eh. Wala pa pong declaration noon. Kaya lang, ang kagaya po ng aking clarification na sinabi, all these initial proceedings conducted in the Senate of the 19th Congress were not officially transmitted to the 20th Congress, where I myself belong, a Congress of different composition. So yun po ngayon, naharap tayo ngayon sa issue na talagang tayo lamang po ang gagawa because there is no other agency of government that will execute that decision of the Supreme Court. Only the Senate. So may I go back to the first question, to the original motion, Mr. President.
Mr. President, if I may.
Majority Floor Leader.
Thank you, Mr. President. With the indulgence of my colleagues, Mr. President, our Senate Minority Leader, Senator Soto, and first movement of the motion, Mr. President, Senator Marcoleta, may I respectfully appeal, Mr. President, of our and remind Mr. President, our colleagues of our concurrence during our caucus held last week that we will debate on this and talk about this and discuss this matter, Mr. President. But if the minority leader would continue to insist his motion, Mr. President, we have no other choice but to dispose with the motion of the minority leader, considering that it takes precedence, Mr. President, with the motion of Senator Marcoleta.
It is the understanding of the chair that during our all-member caucus, which the chair announced in plenary, that it was agreed unanimously by all the members that we will be discussing, debating, and acting on the Supreme Court decision on a date certain. And this was the date certain that was agreed upon in caucus. Maybe hear from the distinguished minority floor leader if there has been a change in that position given on that date when we had an all-member caucus.
Mr. President, I, as a matter of fact, concur with what you said. But during that time when we discussed it, there was no MR filed. There was no motion for reconsideration filed by the House of Representatives or the Solicitor General. So it becomes a different, it develops into a different scenario now that there is a motion for reconsideration. Because again, my question was not clearly answered when I said, what happens if we move to dismiss as what? As a Senate or as impeachment court? I think that is one of the questions that is going to be posed by another member of the Senate, and we wish that you could recognize them to continue debate on this matter before we decide. But again, my answer is that there was no motion for reconsideration when we agreed to decide on August 6 on the motion to dismiss. That's why my motion is not against the motion to dismiss, Mr. President. It is merely a motion to table the motion to dismiss, which you may be able to take up on the floor even tonight or tomorrow. A motion to table is alive always in parliamentary rules, and you may take it up anytime. Then we can take up the motion to dismiss after that, Mr. President. Thank you.
We note the intent of the distinguished minority floor leader, but the chair would therefore like to make some points known before we act on the motion.
Mr.
What is the
President,
pleasure of the majority
yes,
floor leader?
Mr. President, upon conferment with the minority leader, Mr. President, he is amenable, Mr. President, for us to continue with the discussions and debate on this particular topic, Mr. President. And so with that, Mr. President, may I move that we recognize the distinguished gentleman from Cavite, Senator Panfilo Ping Lacson, to ask his questions, Mr. President.
Well, first, Chair would like to thank the
Thank you,
magnanimity
Mr. President.
of the distinguished minority floor leader in order for us to be able to continue with the debates. The gentleman from Cavite, Senator Lacson, is recognized for his interjections with leave, of course, of the gentleman who has the floor, Senator Marcoleta. You may proceed, sir, if Senator Marcoleta so desires.
Thank you, Mr. President. This is not an interpellation. Rather, this is a manifestation to be followed by a parliamentary inquiry.
The gentleman may proceed then.
Mr. President, I've been diligently reading and reviewing the rules of the Senate since I've been out of this august chamber for 3 years. Nowhere in our rules can I find a provision on a motion to dismiss, as submitted by the honorable gentleman from Tarlac. Neither is there a supplementary application of the rules of court to offer a space for such motion to dismiss, except perhaps in the committees performing their legislative inquiries in aid of legislation. Obviously, we are now assembled in plenary, not as an impeachment court, but as a legislative body, and I cannot relate to a motion in this plenary to an issue that involves a collective decision that falls solely and exclusively under the jurisdiction and authority of an impeachment court. Having said that, Mr. President, my parliamentary inquiry is addressed, of course, to the Senate President. Mr. President, how do we deal with the pending motion? I refer to the motion to dismiss. Shall we even take it up or deal with it? Kasi wala po sa rules natin. Paano wala tayo pong guidelines? Kasi wala po sa rules natin yung motion to dismiss. So anong guidelines ang susundin natin in addressing the motion to dismiss submitted by the Honorable Marcoleta? Assuming arguendo, Mr. President, that the motion is voted upon and adopted by this body, what if, Mr. President, the Supreme Court reverses itself when it rules on the MR filed by the House of Representatives through the Solgen? Shall we also backtrack and reverse ourselves in dismissing the impeachment case? I pose that question, Mr. President. Thank you.
Thank you, Senator Lacson. To respond, we were faced with this question, but the very people asking us to wait right now were the very same people who were telling us before to ignore the pendency of a case in the Supreme Court precisely regarding this impeachment complaint. They were egging the Senate, even if we were on recess, to precisely proceed with the trial in spite and despite the pendency of cases in the Supreme Court. And the chair, with an abundance of caution, same with us good senator right now, decided to afford the Supreme Court time during the recess to decide on the matter. And when they did not, the Senate, in accordance with its duty, convened the impeachment court when we resumed session, given that we cannot conduct impeachment proceedings that have not yet begun yet during the recess. To answer the query with respect to motion to dismiss, this was actually done, although not via a motion to dismiss, but a motion to archive in relation to the impeachment complaints of then President Estrada and Ombudsman Gutierrez. In fact, in the case of Ombudsman Gutierrez, it was our distinguished minority floor leader himself, acting as majority leader, I believe, who moved that the case be archived, given the resignation of then Ombudsman Gutierrez for being moot. In the case of President Estrada, the case was likewise archived for being functus officio, given that EDSA DOS happened and a new president was sworn into office. Your Honor, I believe the chair believes that we will have different interpretations of the effect of the Supreme Court decision. But ultimately, as I discussed with the majority leader earlier, once a decision is made by the Senate and the period to seek a reconsideration of that decision put to a vote has expired, the next logical step would be to archive so that it will be made part of our records. It is the position of the chair, subject to the wisdom of the plenary, Your Honor, that given the Supreme Court decision that the Senate never acquired jurisdiction over it, that the proceedings and the articles of impeachment were null and void ab initio. Indeed, there might not even be anything to dismiss, and the procedure would be more properly to archive, similar to what we have done in the past, so that these proceedings will still be made part of the Senate's records. But we will cross that bridge once we put it to a vote, Mr. President.
I go
Your
back
Honor.
to my previous question, Mr. President. Anong gagawin natin sa motion to dismiss? How do we deal with it?
May
We
I
are in
answer,
plenary
Mr.
as a legislative body. We're not an impeachment court. So yun ang tanong ko po, Mr. President. Yun ang essence ng aking parliamentary inquiry.
The predisposition of the chair is what I stated, but subject, of course, to the wisdom of plenary. Maybe here from Senator Marcoleta, with respect to his ideas, given that he is the proponent
Mr.
of the
President,
motion.
it is true that the motion to dismiss is not part of our rules. But it is part of our rules po yung pagiging suppletory application po ng rules of court. In the rules of court, yung korte po can motu proprio dismiss a case kung wala pong jurisdiction. And considering that the rules of court has become part of our rules, that's why I use the motion to dismiss. Pag wala pong jurisdiction, halimbawa, sa isang korte, collection case po ito, 5,000 pesos po yung pinal niya, dinismiss po ng court kahit hindi pa sumagot yung kalaban, Mr. President, kasi ang jurisdiction po ng korte hanggang 3,000 lang. Ganun po ibig sabihin nun. Minsan po, wala pong, hindi po verified yung complaint, dinismiss. Sa motu proprio, talagang dinidismiss. Paano po kaya kung sinabihan pa nga na the Senate didn't acquire jurisdiction over the case? Mas lalo po sigurong dapat nating panindigan na talagang i-dismiss na po natin, Mr. President.
Senator Lacson is recognized.
Again, I refer to our rules, Mr. President. Wala rin po ako makitang supplementary application sa rules of the Senate pagdating sa plenaryo. Pwede pong gamitin ito sa mga committee hearings,
Sa impeachment.
inquiry in aid of legislation. But we are not there. We're here in plenary. Maski po basahin natin na 100 beses ang ating rules of the Senate, wala pong supplementary application sa ating rules. Thank you, Mr. President.
The point of Senator Lacson insofar as that is concerned is well taken. Senator Pangilinan.
Just on the point of
Is recognized.
suppletory, the rules of court being suppletory. Mr. President, the rules that are suppletory presupposes that there are no rules of the Senate or the Senate impeachment court. In other words, in the absence of a standing rule or provision of either our Senate rules or the Senate impeachment court rules, then we refer to the rules of court as suppletory to our rules. But in this case, the Senate impeachment court has a specific rule, resolution number 39. Upon presentation of the articles to the Senate shall specify the date and time for the consideration of such articles. Unless the Senate provides otherwise, it shall continue in session from day to day until final judgment shall be rendered, and so much longer as may in its judgment be necessary. In other words, as an impeachment court, of course, not as a Senate in plenary, but even that is now being debated because this representation believes the sole power to try and decide impeachment cases is the impeachment court and not the Senate in plenary.
Mr. President,
Majority Floor Leader.
Mr. President, next to interpellate, Mr. President, on the list of this representation is the distinguished gentleman from Taguig and Pateros, no other than Senator Alan Peter Cayetano. I move that he be recognized, Mr. President.
If I may, Mr. President, with the indulgence of the good gentleman from Taguig and Pateros, yung akin po ay
the lady may proceed.
susog doon kay Senator Lacson ng mga punto.
But, Your Honor,
It's
the
not an
chair-
interpellation yet, Mr. President. I follow up point to the point of Senator Lacson. If the SP
lady may
and
proceed.
the gentleman. Thank you, Mr. President, and with the indulgence, as I said, of the good gentleman from Taguig and Pateros, nabanggit na rin po, Mr. President, pareho ni na Senator Lacson at Senator Pangilinan, yung usapin ng tayo ba, Senate or Senate impeachment court ba? So this is a point of inquiry, actually, a brief point of inquiry, Mr. President, related to the motions at bar now. The question presented to the body is related to an ongoing impeachment case, which is within the jurisdiction of the impeachment court. Should we not first have the newly elected senators take their oaths as senator judges and convene as an impeachment court? I note, Mr. President, that the Supreme Court decision is not yet final. As colleagues have mentioned, a motion for reconsideration has been filed by the House of Representatives, and the court itself, the Supreme Court, has given 10 days for the Vice President to comment. So yung point of inquiry ko nga po, Mr. President, hindi po ba dapat pasumpain na muna ng presiding officer with us convened as an impeachment court, yung mga bagong halal na senador para makapag-convene po tayo bilang impeachment court at i-treat yung mga motions at bar. Salamat po, Mr. President.
Noted and entered into the records. What is the pleasure of the Honorable
Just a very quick intervention. Very quick, Mr. President. With the
Pangilinan?
permission of
Yes,
our
you may
Mr.
proceed, sir.
Yes, Mr. President, and we place this on record after reading the ruling, the decision of the Supreme Court. Mr. President, the Supreme Court referred to the Senate Impeachment Court repeatedly. And therefore, it is the Senate Impeachment Court that was also impleaded. It is the Senate Impeachment Court that may, if it opts to, file a motion for reconsideration. And therefore, this motion to dismiss, we believe, should be forwarded to or tackled by the Senate as an impeachment court.
Your Honor, just on that point, the parties mentioned in the case is not the Senate Impeachment Court, but the Senate. And the dispository section of the decision makes mention also of the Senate. If I may quote, consequently, the Senate did not acquire jurisdiction to constitute itself as an impeachment court. That's the decision of the court in Duterte v. HOR.
Mr. President, and we will go back to the earlier manifestations
The
of...
mic, please.
We will go back to the earlier manifestations of the minority leader. Yes, the Supreme Court ruled that we have no jurisdiction. Yet, the decision is flawed in terms of the facts on procedure, the one-year bar, and on due process. This is at least, of course, our assertion. And therefore, should we not wait for a motion for reconsideration to be resolved before we proceed and vote on the matter that has removed from the impeachment court jurisdiction? Should we not at least assert the power and the prerogative under the Constitution of the Senate Impeachment Court in terms of the exclusive jurisdiction, number one, and the sole power to try and decide?
That is what we will be deciding and voting upon this afternoon, Your Honor.
Thank you, Mr.
Senator
President.
Cayetano is
Yes,
recognized.
please,
Thank you, Mr. President. The distinguished gentleman, Senator Marcoleta from Tarlac and Senador ng buong bansa. Sir President, initially I wanted to speak pagbotohan na po. But very interesting po yung question na bringing up ni Senator Lacson. But aside from that, Mr. President, masyadong mabigat yung crossroads na hinaharap ng ating bansa. And remember, assuming we do nothing today, I am 101% sure that on February 6, 2026, an impeachment case will be filed against the Vice President. Maybe against other impeachable officers too. So I think it is very important that mahimay natin yung desisyon, yung sentimento ng institusyon na to, mailabas hindi lang sa social media at sa traditional media ang mga puntong nagsasaliwa, meaning pong parang hindi nag-uusap eh. So at least here we disagree, but whether we listen to the minority leader or to Senator Marcoleta, we agree to listen to each other and to examine each other's points. So I just like a few minutes on some very important matters. Let me start by the accusation that because of this decision, masyado nang mahirap at wala nang mai-impeach. So may I ask Senator Marcoleta if he would give me the honor of asking him a few questions and allowing me to interpolate on 2 or 3 topics. The first one is whether or not naging imposible na mag-impeach under this decision.
The gentleman may proceed if Senator Marcoleta will so allow it.
Yes, Mr. President.
Mr. President, sabi po nung iba, imposible na daw mag-impeach ngayon dahil sa desisyon.
I
Hindi
see the
po.
decision before you. I approached you last week. You've been studying it. I see your radio program. Mukhang 10 beses mo na nabasa yung decision at apparently, Mr. Senator, you also listen to criticism. So kung ano rin yung sinasabi ng iba, pinapakinggan mo rin. In your view, may I take note first, Mr. President, that I am glad that the Senator made a distinction na he is for the rights of everyone. He was adopted by PDP and ran with a particular party, but he is not a member of the Duterte bloc. Am I correct there?
Technically speaking, Mr. President, I am not a member of the PDP, but I admit that I was adopted and I ran in unity with some of the parties of the PDP candidates at the time.
The point I'm going at is like, I was a cabinet member in the Duterte administration, but I have not talked to the Vice President. I ran as an independent in 2022, so I speak now as a senator and not as a partisan. I assume the same, Your Honor.
Yes,
that
Mr.
you're
President.
giving your own personal opinion as Senator Marcoleta, not as a partisan. Of course, I assume that for everyone here, no? Regardless of our position. So, Mr. Senator, sa iyong paghimay ng desisyon, sa tingin mo ba imposible na ngayon mag-impeach ng isang impeachable officer?
Hindi po, Mr. President.
So naging napakahirap ba mag-impeach ng isang officer?
Hindi ko po alam kung bakit mahirap po sa kanila, Mr. President. Ang importante lang po, ilagay lang po sa tamang proseso. Napakasimple po kasi nung kanilang mga tuntunin, iniisip ko, sundin lang yung mga tuntunin. Ang problema po, isa man sa tuntunin, wala pong sinunod. Kaya po humirap ng humirap para sa kanila.
So, Mr. President, I'm glad you mentioned tamang proseso. I think the way the Supreme Court said it in page 95 of the decision, there is a right way to do the right thing at the right time. The problem, Mr. President, is sinasabi po nung iba, may decision na sa former decisions, meron ng definition ng initiation, and many of us here were not mere spectators there. I mean, Senator Soto, I think, was in the impeachment court, di ba, of Senator Estrada, Senator Laurentu. Senator Kiko was still on the, we were together kay Senator Corona. Senator Cheese and I and Senator Miggs were in the House during the prayer 1/3 to the Senate articles of impeachment, di ba? So, hindi po tayo stranger sa mga pangyayaring ito. Ang punto ko, Mr. President, Senator Marcoleta, kung hindi nagsabi ang Supreme Court ng specific na dapat sundin, pwede kong ma-interpret na baka naman masyadong mahirap. Baka naman kahit anong i-file kung gustong protektahan, hindi na siya ma-impeach. Paano na yung accountability? But is it true, Mr. President, that on page 93 of the decision, the Supreme Court actually narrated what has to be done for a valid impeachment complaint?
Yes, Mr. President.
Allow me to read. 1, the draft article of impeachment or resolution should be accompanied by evidence when made available to members of the House, especially those who are considering its endorsement. 2, the evidence should be sufficient to prove the charges in the articles of impeachment. 3, the draft articles of impeachment and their accompanying evidence should be made available to all members of the House of Representatives, not only to those who are being considered to endorse. Impeachment is an act of the entire House, which requires a qualified minority of only 1/3 of its members to be transmitted to the Senate. However, the House of Representatives is a deliberative assembly where each member should be allowed to represent the views of their constituents. Let me stop there first. Mr. President, may problema ba yung number 1 na yung articles of impeachment kailangan may ebidensya?
Wala pong problema doon, Mr. President.
Hindi ba ho baliktad? Kung walang ebidensya, may problema.
Tama po.
Kasi kung walang ebidensya, ano yon? Tapon mo sa Senate, bahala na si Batman. So, precisely tama ang Supreme Court that even if 1/3 endorse or file, dapat may ebidensya na. Let me go to the second part.
the evidence should be sufficient to prove the charges in the article of impeachment. Mr. President, tama po ba na iba po yung sufficiency at iba din po yung quality or yung burden of proof, di ba?
Opo.
So halimbawa po sa piskalya, hindi po kailangan sa piskalya beyond reasonable doubt.
Probable.
Kailangan lang that there is probable cause that a crime was committed and there is probable cause that the accused committed that crime.
Yes, Mr. President.
So in the same manner, hindi sinasabi dito sa 2 na kailangan mo ipresenta sa mga congressman lahat ng testimony, lahat ng ebidensya. Ang kailangan lang, if you assume the evidence to be true, it will be enough to convict.
Tama po.
Because if not, then sayang lang ang oras natin sa Senate. Kung may articles of impeachment ka, walang ebidensya or may ebidensya pero yung ebidensya is not sufficient to prove the charges, either the Senate will be a kangaroo court and convict without evidence or we will be wasting our time. So wala rin problema sa number 2, Mr. President.
Wala po, Mr. President.
Number 3, ang sinasabi lang ng number 3, kahit na pumirma yung 1/3, kailangan ipakita pa rin sa lahat ng Kongreso. Isa po sa hinanakit po yun nung bata ako dahil ako po'y payat nun at hindi katangkaran. Parati akong saling pusa sa basketball, baseball, volleyball, dahil hindi po ako ganong kagaling sa sports. Sa Congress ba, hindi ba tamang rule to? Na kahit wala ka sa majority, kahit wala ka sa qualified minority, kapag ka may impeachment, merely being elected as a representative of the district or of the party list, dapat ipakita man lang sa iyo yung articles of impeachment at saka yung ebidensya.
Tama po kayo. Wala man lang po akong nakita sapagkat ako po hindi isinali sa pakakitaan ng...
So naiintindihan niyo po kung paano maging saling
Hindi ko nga
pusa.
po alam na meron na po pala. Hindi man lang kami binigyan eh. Kaya nung tinanong ko po yung aking mga kasama, kayo pala binigyan, bigyan nyo nga ako ng kopya. Para nabasa ko. Wala rin kami. Paano nyo pinirmahan? O hindi naman namin binasa ng pinirmahan na. Basta meron lang binigay ng mga signature pages. Doon lang kami pumirma. So
Well,
hindi nyo nabasa? Hindi.
God and the world has a way of correcting itself because now I have the privilege of serving the people here, not as a saling-pusa, and definitely, Your Honor, as chairman of the Senate Blue Ribbon Committee, is not a saling-pusa here in the Senate. In fact, you are an esteemed neophyte with a very powerful committee. So, again, number 3 is just a simple walang saling-pusa rule, which is very good. Number 4, respondent have the opportunity to be heard on the draft articles of impeachment. Hindi ko na po babasahin dahil mahaba, pero basically ang sabi ng Supreme Court dito, hindi naman kailangan pumunta doon ang Vice President. Pwedeng through pleadings. Meron po bang masama dito, Mr. President, na kapag may na-impeach, bigyan man lang siya ng kopya at pasagutin muna siya sa House bago siya pasagutin sa Senate? May masama po ba dito?
Wala pong masama, Mr. President. Ang totoo nga po, sinasabi nga na dapat i-repair po lahat ng impeachment complaints kahit na yung pinirmahan ng 1/3 o higit pa, i-repair sa Committee on Justice. Yun po ang paraan siguro para magkaroon man lang ng pagkakataon ng Vice President, kahit na by pleadings lang, makasagot siya.
Yeah.
Pero hindi nga po ibinigay.
Before I go to number 5, just because I like your answer, Mr. President, one thing that guides me, no? So I've in coming to my decision with this, I follow 2 books. One, the Bible, which is of course a covenant between God and people, tayo, and the Constitution, which is a covenant among the Filipino people and the government, no? Alam mo, both books talk about due process. Ang Panginoon, nung kinain ni Adam at Eve yung prohibited fruit, nagtanong muna siya, ba't kayo nagtatago? Hindi nag-accuse, nagtanong muna, pero alam na ng Diyos. So ang ibig lang sabihin ng due process, sabi ng desisyon ng Supreme Court, magtanong ka muna bago ka humusga. So Mr. President, I was thinking, what if naging masyadong emotional yung eleksyon ng huli? And one-third of members of Congress ay naging anti-administration At ang kinahaharap natin ngayon ay isang impeachment labang kay President Marcos. At pag siya'y na-impeach, magiging presidente si Vice President Sara. I wonder if all of us in this room and out of this room will still have the same paninindigan. I hope I will. I'm not judging. I am just saying, Mr. President, what helps me is those two books, but also to put myself in the opposite side, to put myself in that position. What if, so I'm looking, I see my good friend, former Senate President Subiri, shaking his head. So natanaw ko tuloy si Senator Kiko. What if Vice President Lenny and Senator Kiko won in 2022? And what if ang ini-impeach ngayon ay si Senator Kiko? I hope yung decision ko to support this decision would be the same.
Tama
Because
po,
the Supreme-
dapat walang pagkakaiba.
Wala saan pagkakaiba. So number 5, a reasonable period of time determined on the basis of complexity of charges must be given to all members of Congress. Kasi lumalabas po, yes, tama si Senator Soto, ibang mode yung 1/3. Pero lumalabas po mismo sa pleadings, mismo sa sinabi ng House of Representatives, wala pang 3 oras. Yung
Wala po.
ibinigay sa mahigit 200 na pumirma, samantalang ang complaint is a few hundred pages. Tama po ba?
Mahaba pong pahina lahat ng sinabi sa akin, Mr. President, at hindi po nila na kayang basahin sapagkat wala nga silang kopya. Humihingi po sila ng kopya bago pumirma, ngunit wala pong ibinigay. Yun po yung sinabi sa akin ng mga ilan sa aking mga kasamahan doon.
Yung number 6 po, Mr. President, madali kasi kailangan yung impeachable act is an act done while they were in their present office. So wala naman pong problema dyan. Meaning, kung may nagawa si Senator Cruz nung konsyal pa siya, pero ngayon Vice President na siya, hindi naman siya pwedeng impeach base sa ginawa niya nung konsyal siya.
Tama po.
So madali po yon. Number 7, at the very least to accord the opportunity to be heard under the requirement of due process in the procedure under Article 11, Section 3, Paragraph 4, after the draft articles of impeachment and required proof arrived at. Letter A, the House of Representatives should provide a copy of the draft articles and its accompanying evidence to the respondent and give her an opportunity to respond within a reasonable period. May problema po ba dito?
Wala po.
Kapag ka ganito kabigat, natatanggalin mo ang isang impeachable officers, tama po ba yung surprise?
Hindi po.
Parang, eto yung wag mo nang tignan, 1/3 naman kami, sa Senado ka na, sa Senado ka na mag-reply. Letter B simply states that all members, again, it's the walang saling pusa. So, Mr. President, in other words, it is not true that it is now too difficult. Sundin lang yung page 93, 94. Whether it's February 6 for the Vice President or if anyone wants to file an impeachment against anyone, magagawa to at any time.
Tama po, Mr. President.
Let me reverse my question, Mr. President. Dapat ba maging madali mag-impeach ng isang officer? I'm asking, of course, your opinion that I value, Mr. President.
Depende po sa ini-impeach na opisyal. Pero kinakailangan po hindi dapat magmadali. Kaya dalawa po kasing bagay yun eh. Kailangan po siyang mapagbigyan ng due process niya at gaano man po karami yung ebidensyang inaharap sa kanya. Bigyan natin siya ng pagkakataong makasagot. So maaari pong mahirapan ng konti, tumagal ng konti. Ngunit kailangan po natin ibigay lahat ng proseso sa ini-impeach at sa mga nag-i-impeach.
I value your answer on due process, Mr. President, and that's my second point. But if you would just also accept, or maybe I can put on record, I'm of the personal view, hindi dapat maging madali mag-impeach ng isang impeachable officer. Bakit po? Unang-una, iilan lang po sila sa ating bansa. Ombudsman, member of constitutional commissions, President, Vice President, Supreme Court. Hindi dapat madali dahil it's an extraordinary remedy in extraordinary circumstance not to penalize them. but para protektahan ng ating bansa at para nga po alisin sila sa equation if they will damage our country. So, the difference po with this impeachment sa iba, at least the impeachment of President Estrada, President Arroyo, and again, may I be sensitive especially to my friends here, no, who are of that administration, was with us, against us, or like Senator Jinggoy and Senator JV. Yung feeling kasi doon is that if there was another day na hindi na-impeach, magagamit yung opisina na yon. Kasi presidente pinag-uusapan. Ganon din sa Chief Justice, na habang nandun ka, ma-impluensyan mo yung korte. Pero pag pinag-uusapan mo Vice President ngayon, wala naman siyang hawak na departamento, wala siyang hawak na agency, wala namang police, militar, NBI, Coast Guard, whatever under sa kanya. Yes, we should hold her accountable kung may ginawang mali. Dapat i-impeach pag may ginawang mali. Pero it's not true that today and tomorrow matters that much. Because wala naman siyang opisina na magagamit not only to cover her tracks or to damage the country. Di ba? In fact, I doubt kung walang perpetual disqualification yan, baka iba ang suma natin ngayon. But I don't want to go to the political aspect. The point I want to make, Mr. President, is para tayong nag-Goldilocks, pag gusto natin yung i-impeach natin, so nung time na yon na gustong impeach si President Erap, padaliin natin. At kung hindi, walk out tayo. Oh. Kung kakampi mo si GMA, pahirapan natin. Kung kakampi mo si Duterte, pahirapan natin, di ba? So, in that point, I see why the Supreme Court, they made a statement nag-statement sila about history. Sabi ng Supreme Court, ito po, sa page 94, we understand our history. We have learned that in the past, momentary desires to do what is convenient and concede means to ends have inadvertently created precedents that weaken the succor of law for those who dissent, or those that are society's margins, or those who have fallen out of grace from the powers that be. We have learned that the clash of political interests in the past, often disguised by noble intentions, have obscured the need to address the real problems of corruption, inequality, poverty, and disempowerment faced by our people. Kung ito lang po ang sinabi nila, Mr. President, sasabihin kong hindi ba namumulitika yung korte? But sinabi nila to after page 93 na iniisa-isa nila paano mo i-impeach . So parang ang tinuruan na ang Senado at saka House, gusto nyo impeach ang Vice President o sino man, sundin nyo lang to. Wala na kayong problema. So I think in that sense, Mr. President, it's a balanced decision. Ang question, Mr. President, yung tanong ni Senate Minority Leader, former Senate President Soto, operative fact, Mr. President. Mr. President, may I venture to answer the question of Senator Soto nung tinanong niya, ano to? Diba? Ano to yung nag-robe, etc. Nasagot na po kasi ni Sara Geronimo yon. Nung sinabi niya kay Coco Martin, there was never an us. There was never an us. Sinabi kasi ng Supreme Court na void ab initio to. But I have a reason, Mr. Minority Leader, former Senate President, and Senator Ping, why I bring this up. Because I agree with Senator Ping na ano ang i-dismiss natin. Because ang sinasabi ng Supreme Court, and that goes to my last point, for your consideration, Senator Marcoleta, sabi ng Supreme Court, there was never an us, ibig sabihin, void ab initio. So wala tayong i-dismiss. So theoretically, if we do not do anything today, we are following the Supreme Court decision. Except, yeah, that's why I'm agreeing with you. So agree with me when I'm agreeing with you, Mr. Senate President, and Senator Ping. However, human nature is that if we do not do anything, people will say it's pending. And we do have the 1 year one filing bar. So the Constitution did not intend that every single day of your life as ombudsman, as vice president, president, may nakatutok sa yung impeachment. So it is also fair to the vice president that we dispose of this. The question now is, if it is void ab initio, why did the Supreme Court not apply the doctrine of operative fact? In my research, two reasons. One, hindi po bringing up ng House of Representatives ito. Bringing up po to ng House of Representatives later on in the MR. Number two, there is a rule that kapag ka magkakaroon ng injustice or may ma-oppress, hindi pwede yung operative fact. So since my finding, please correct me, Senator Marcoleta, if I'm wrong. Since my finding po ang Supreme Court na sinircumvent yung 1-year bar, hindi ka ngayon pwede mag-operative fact kasi para mo ni-reward ngayon yung circumvention. Am I correct sa
Yes, Mr.
pagkaintindi?
President, because the doctrine of operative fact is based on equity and fairness. Wala pong equity talaga eh. Hindi po sinunod ang mga tuntunin. So, sa umpisa pa lang, nagpalusot na, kaya hindi po pwedeng gamitin yung operative fact.
I see former Secretary Jeremiah Bellica in the crowd. Sa ease of doing business na si Majority Leader and si Senator Ping, I think were the sponsors, di ba, or the authors of the law. I don't know kung, ang alam ko, covered ang Congress dun eh. So kapag ka 10 days, at kasi ministerial yung sabi ng Supreme Court eh. Kapag ka nag-file ka ng impeachment, yung 10-day, 3-day, ministerial yon. So even if you do not consider it archived, if you apply the ease of doing business law that Secretary Jeremiah Bellica used to very much push in government, you would come to the same conclusion. My point is, Mr. President, we'll never come out with a perfect decision. People will disagree. That's why I agree with the statement of the IBP na ang kailangan sa Constitution ay hindi agreement, kung hindi adherence. The North and South of the United States did not agree on slavery. That's why they fought a civil war. Because they had to see who will adhere to this Constitution, who will treat this piece of paper as a living soul and a covenant of this country rather than just a piece of paper. And grabe po ang devastation sa United States. Buti po tayo nagdidebate lang. Buti po tayo yung dugo ng ating mga bayani ay minsan lang po inalay at ngayon nagdidebate na lang tayo sa desisyon na to. Pero kung hindi natin susundin ang Supreme Court decision and we will court a constitutional crisis, we will tear the Constitution apart because, Mr. President, this is going to second to the last question. May option ba tayo not to follow the Supreme Court?
Wala po, Mr. President.
So it's for academic discussion and for criticism, for enlightenment, and trying to influence the court na masama decision nyo. In accordance, I respect the opinions for those who think na masama yung decision. But in actuality, as an institution, we have to follow, hindi po ba?
Tama po, Mr. President.
Is the gentleman a member of the Commission on Appointments?
Wala pa po yatang ini-elect.
Hindi, kasi may decision ng Supreme Court kung paano hati-hatiin yung membership ng CA. Kung hindi rin natin susundin yung decision ng Supreme Court sa impeachment, wag na rin natin sundin sa CA. What about sa sweldo ng mga senador? Di ba, sabi sa konstitusyon, sa mga batas, hindi tayo pwede magpasa ng batas na makikinabang tayo.
Tama po yun.
So kung disagree tayo, wag na rin natin sundin dahil mas mataas na sweldo yon.
Kailangan po kasi palagi nating isasaalang-alang kung anong sinasabi ng desisyon ng Korte Suprema at hindi yung sarili po nating nilalayon o ang sarili nating interest.
Correct ko ba? Especially when we disagree. Madali kasi magsang-ayon pag we agree eh.
Tama po.
Maraming magsasabing nag-uusap tayo through microphone but we agree on many things. But mas mahirap when we disagree.
Tama po.
Mr. President, so since we disagree slightly on dismiss, would the movant, the distinguished senator, consider na ma-amend yung motion that the Senate obey or follow or anong tamang salita na acceptable sa minority, the Supreme Court decision? Because if the motion is to obey the Supreme Court, so if the Supreme Court reconsiders, the motion still carries, then we will follow. If they don't, we will still follow. And right now, sabi naman nila, it is immediately executory. So as far as I'm concerned, it doesn't exist. But I agree with the gentleman, there's some action that is wanting eh. Kung
Tama
hindi, it's there floating in the air. Anyway, I'll leave that as a question. There might be some people who want to interpellate, Mr. President, but may I offer that solution? We are allowed to amend, to propose an amendment to any motion if the movant agrees.
I am amenable to an amendment, Mr. President, like moving it to send it to the archives. Like we will have the same result, if that is the case. And I will be pleasing Senator Soto if I do that.
What is the pleasure of the Honorable Soto, the distinguished Minority Floor Leader?
Thank you, Mr. President. It grieves my heart to disagree. I think I'd rather call for the previous question, a motion to table. It has the same effect, and you can bring it up anytime. But we did not say that we did not follow the Supreme Court decision. It will not. It will not say that we archived, as the interpretation of the Supreme Court is kung ano yung word ng archive. Iba yung archive nila eh. Hindi pa nga adjourn, archive na sa kanila eh. Hindi ba? Hindi pa tapos yung session eh. Hindi naman ganun ang archive sa atin. Sa kanila ganun. Iba yung rules ng Congress eh. Iba yung kaysa sa rules nila eh. So, hopefully, baka pwedeng we can find a middle ground between the proposal of Senator Alan Cayetano and my motion to table, which has a higher precedence than the motion to dismiss.
But Mr. President, that is not consistent with the immediate character of the decision. The decision says it is immediately executory. A motion to table, hindi po immediate yun eh. Kaya sabi nga ni Senator Cayetano, somehow there should be some action. The people are waiting for some kind of a closure before this chamber. Because that particular decision is directed to no one but to the Senate, Mr. President.
Sir President.
Before the chair recognizes any member, the parliamentary status is that a motion was made by the Honorable Marcoleta, which he is willing to amend, and a higher order of precedence motion was made by the Honorable Minority Floor Leader. Both are pending, and to afford time for both the Minority Leader and the original movant to perhaps consider and find a compromise as agreed upon earlier, can we proceed with the interpellations and interjections, manifestations, if you will,
Yes,
of the
yes.
other members who had manifested to so interject and make known their position through a manifestation or interpellation?
Yes, Mr. President.
Thank you.
Therefore, I withdraw the call for the previous question, and then allow that to proceed. But then again, just a point of information for our colleagues. The Supreme Court has just received a motion for a TRO for the Senate not to take up this particular case. It was filed yesterday by the former Associate Senior Justice Tony Carpio, also Ombudsman Conchita Carpo Morales, Commissioner Heidi Mendoza, religious leaders, former military and public servants, Ms. Sheila Magno, students and the youth and the academe. They have filed a TRO with the Supreme Court, and we are awaiting something to that effect. It might come out today, and then we are, again, inuunahan natin. So hopefully, yes, we can proceed, Mr. President.
Thank
I
you,
have
thank
no
you,
objection.
Minority Floor Leader. Your manifestation is duly noted. Senator Cayetano,
Sir President, let me agree
wind
with...
up.
Yeah, let me just agree with both you and the Minority Leader And of course, thank Senator Marcoleta for his openness. Ang intention ko lang naman po in proposing an amendment, wala pa yung actual words, no? But, Mr. President, kasi kung pwede, pag bumoto tayo, dahil mabigat po yung pagbobotohan natin at most of us have dug in already sa legal opinion natin sa boto natin. So kung mali ang framing kung ano pagbobotohan, mahirapan din tayo lahat. So meaning I don't mind if I vote for or against the proposition, at least malinaw kung anong pagbobotohan ko. So like I would vote to follow the Supreme Court decision. I'm thinking whether I'll vote to dismiss because the Supreme Court said it did not exist, void ab initio. But I don't want to vote against it because if I vote against it, it is live. And precisely the Supreme Court said immediately executory. No? So let me yield the floor para dun makapagtanong yung iba. But I'm hoping some of us can come up with language that will be acceptable. We might not have a unanimous vote, but at least klaro kung anong pinagbobotohan natin. Thank you very much, Senator Marcoleta.
Mr. President, just a point of information.
Senator Pia Cayetano is recognized for her point of information.
Yes, thank you, Mr. President. I'm happy to be corrected. We have on the floor, I don't know, maybe 5 or 6 previous majority floor leaders. Senator Alan was a majority floor leader. The minority floor leader was Senator Soto was a majority floor leader. Senator Kiko was a majority floor leader. Senator Subiri, former Senate President, was also a majority floor leader. I hope I didn't forget anyone. Lauren was a majority floor leader. So on that note, I just want, so again, I'm happy to be corrected, but the rules, to my knowledge, do not limit us to a particular kind of motion. Rule 31, the title is Precedence of Motions, so it lists the motions that take precedence. Rule 32 is the privilege motion. It doesn't mean that we cannot have a different motion. So just put that on the table so that those who want to be creative can continue this discussion later on when we get to that point that we are deciding if we will rephrase, if we choose to look for a more appropriate wording. But I'd like to include this in everyone's for everyone's consideration, that there doesn't seem to be a limitation on what kind of motion we can present to the body. Thank you.
Thank you very much, Senator Cayetano. Mr. President, at this juncture, may I move that we recognize the distinguished gentleman from Davao, Senator Bato de la Rosa.
Senator De La Rosa is recognized. What is your pleasure, sir?
Thank you, Mr. President. I just would like to make a clarification, Mr. President, that it is very clear to me during our caucus, we have agreed that today, on this date, we are going to tackle this Supreme Court ruling, and we have to debate on this, and we have to decide on this today. It was not part of the agreement that whenever the House of Representatives file a motion for reconsideration, ay ma-install yung ating plano to decide today. So, bakit nagbago yung usapan, Mr. President? I'm just asking.
Your Honor, the Senate is a collegial body and decides everything by dividing the House. The current parliamentary status is that we have 2 motions that have not yet been acted upon. One has precedence over the other. Pinahintulutan ng dalawang movement na magpatuloy muna yung pagdedebate. So darating po tayo sa punto, matapos ang debate, na pagbobotohan natin yung dalawang motion po na yan. Ayon sa precedence ng rules natin. Majority Floor Leader.
Mr. President, just very quickly.
Mr. President,
Very quickly.
Is this already your...
Just an interjection on the point raised by Senator De La Rosa.
Mr.
Majority Leader.
President, if I may appeal, Mr. President, to distinguished gentleman from Pampanga, Mr. President, because next to interpellate is the distinguished lady from Iloilo, Mr. President,
quick
Senator Risa, and
manifestation.
then it's his turn, Mr. President.
Just a quick manifestation,
The
Mr. President.
gentleman may proceed for his quick manifestation.
Because it has been referred repeatedly about what we agreed on in the caucus. Mr. President, we agreed to decide on this matter. And if the decision is to lay it on the table, that is a decision of the Senate in plenary. In other words, we didn't agree on deciding that we will decide on a motion to dismiss. We didn't agree that we would decide on holding it in abeyance. We said we will decide.
Your Honor, that's precisely what the chair said. We will be
Thank you.
deciding on these pending motions at the proper time after debate. Senator Ontiveros is recognized for her interpellation and interjection if Senator Marcoleta so desires.
Yes, Mr. President.
Salamat po, Mr. President. In lieu of an interpellation of the good gentleman from Tarlac, I will be seconding a motion, Mr. President, preceded by a brief manifestation. Earlier, Mr. President, Senator Marcoleta said he refuses to speculate on reversal. But the good gentleman's own position is based on his own speculation that the SC will not reverse its decision. A tabling of the motion to dismiss, which is what I will second in a few minutes, Mr. President, a tabling of the motion to dismiss by the Senate today is not defiance of the Supreme Court. Wala pa nga po kasing final na decision. Kahit ang Korte Suprema po, iniintay pa ang comment ng VP. That is why I will be seconding the motion of the minority leader to table the motion to dismiss the impeachment complaint until the decision of the Supreme Court has attained finality. Tama po. We should exercise extraordinary prudence in this matter of transcendental importance. Still, I also wish to also take this opportunity to express my thoughts at this crucial moment for our chamber. Mr. President, I agree and I continue to respect the Supreme Court. Hindi po magbabago iyan. But, Mr. President, hindi naman po ibig sabihin ng respeto ay pananahimik. Lalo na kapag inisip natin kung gaano kalaki ang nakataya dito. Magkaiba rin yung rumerespeto at yung bulag. Kaya naman, I will not be choosing silence, nor will I be turning a blind eye in the face of clear and unmistakable injustice. I am encouraged by the words of brave professors of the UP College of Law who in 2010 issued a sharp critique of a Supreme Court decision, Vinuya versus Executive Secretary, which said, the court cannot regain its credibility and maintain its moral authority without ensuring that its own conduct, whether collectively or through its members, is beyond reproach. So, in the context of the SC decision, Duterte versus House of Representatives, I believe we need to shed light on some concerns which former justices and constitutional framers themselves, some of whom are here this afternoon, Mr. President, have underscored. Una, the Supreme Court decision was based on critical factual errors. At binanggit na rin po ito ni Minority Leader. And this has since been pointed out by no less than retired Senior Associate Justice Antonio Carpio. For example, the decision said that the February 5 impeachment complaint was transmitted to the Senate without a plenary vote in the House. A simple check of the records, specifically House Journal number 36, shows that this is false. Walang haka-haka. Those official records are plain for anyone to see. Sabi tuloy ni retired Chief Justice Renato Espuno, na siyang chairman ng Philippine Constitution Association, the Supreme Court was faced with a famine of facts necessary to make a decision invulnerable to constitutional assaults. Pangalawa, actions already taken under a prior and valid interpretation should be recognized as legally effective. Yan naman ay mula kay retired Justice Adolf Ascuna. The House of Representatives was operating under the regime of the legal doctrines in Francisco and Gutierrez, which held that the initiation of impeachment proceedings begins from referral. Kung unconstitutional pala na sundin ang legal doctrines, in the words of Justice Ascuna, that is legally unfair. Paano nga naman unconstitutional kung sinunod lang nila ang patakaran ng mismong Korte Suprema? Dagdag pa po sa isang desisyon nitong 2020 lamang, Madreo versus Byron. Sabi ng korte na kung may pagbabago sa doktrina at interpretasyon ng batas, dapat prospective ang aplikasyon nito. At ang pangatlo at huling punto, mistulang nadagdagan ang requirements sa proseso ng impeachment na hindi naman nakasaad sa ating saligang batas. These new limitations, Mr. President, are not found in our fundamental law. Wala yan sa konstitusyon at kontra yan sa accountability. One disturbing example, sabi ng desisyon, kailangan daw na isumite na ang bawat ebidensya laban sa opisyales sa pag-file pa lang ng complaint sa House. Dapat ba naka-attach na ang bawat bank slip, public record o testimonya ng witness na ihaharap kahit wala pa silang proteksyon ng Senate Impeachment Court? Ang tanong tuloy ng marami, realistic ba yan? Paano kung ang impeachment ay laban sa mataas na opisyal na kayang-kayang magtago ng ebidensya o manakot ng mga potential witness? Bakit humaba yata ang checklist ng proteksyon para lang sa impeachable officials? Samantalang ang taong bayan na nagtatanong, na naniningil ng pananagutan, sila pa ang pinahirapan. Sila pa ang nadagdagan ang requirements. Ayon sa Korte Suprema, an official facing impeachment does not stand to lose fundamental constitutional rights such as life, liberty, or property. Hindi buhay, kalayaan, o pag-aari ang inihahabla sa impeachment. Kung ang usapan naman ay due process, hindi pat ang mismong impeachment trial na nga ang mismong venue para doon. Maririnig ang dalawang panig. May ebidensya, may magdedepensa. That is due process. So what are we afraid of? At dahil nandito rin po sa gallery ngayon, Mr. President, ang isa sa mga constitutional commissioners na si Christian Monsod, di lalo po akong confident na mag-take exception sa isang sinabi kanina ng good gentleman mula sa Taguig at Pateros na dapat mahirap ang proseso ng impeachment. Kontra po doon ang pananaw ng Constitutional Commission kung mababasa po natin ang records ng deliberations ng komisyon, partikular sa panig ni Commissioner Regalado. Muli, patuloy nating nirerespeto ang Korte Suprema. Pero pwede mong respetuhin ang isang institusyon habang nagtatanong at pinag-uusapan ang kanyang desisyon. In Firestone Ceramics Inc. versus Court of Appeals, the court conceded that it is not infallible. Should any error of judgment be perceived, sabi nila, it does not blindly adhere to such error. In this jurisdiction, rectification of an error more than anything else is of paramount importance. In the 2010 letter that I mentioned earlier, the UP law professors said that the position of the Supreme Court as the final arbiter of all controversies requires competence and integrity completely above any and all reproach. A breach of these values, the professor said, does violence to the primordial function of the Supreme Court as the ultimate dispenser of justice. And the UP Law Dean who led that letter to the Supreme Court, walang iba po kundi ang nagsulat ng desisyon na ating pinag-uusapan. Dear Mr. President, dear colleagues, I believe this decision is of the highest public interest, whose consequences will echo through time and history. Maraming taon mula ngayon, pag-aaralan at hihimayin ito ng lahat. Mula sa mga estudyante, mga journalist, mga political analyst, mga academics, at higit sa lahat ng ating mga kababayan. One day, and this day will come, history will judge all of us based on our actions today, August 6, 2025. When history comes to remember, let's hope we stood where it mattered, that even in the face of doubt, we did what was right and just. With deep respect for the Supreme Court and all institutions of our country, Mr. President. I therefore second the motion to table the motion to dismiss the impeachment complaint until the decision of the Supreme Court has attained finality. Salamat po, Mr. President.
Mr. President, quick
Noted
reaction.
and entered into the records. Senator Marcoleta.
Mr. President, unang-una, yung sinabi ko pong speculative, sapagkat it was not based on my own speculation. It was based on my long practice as a litigation lawyer. Wala pa po akong nakitang isang unanimous decision. Ewan ko lamang po kung merong magbo-volunteer ngayon na abogado in the last 40 years na sinasabi ang isang unanimous decision na ang karakter niya ay sinabi na ab initio, void ab initio, unconstitutional, violative of due process. Maybe if we can speculate that all the members of the Supreme Court after the filing of the motion for reconsideration will resort to their will resort to the worst angels of their nature. Maybe, baka ganun lang. What do we expect? We expect that 8 of them will reverse themselves altogether? Kung sakasakali naman po na in-archive natin or whatever word is applicable at sinabi, under miraculous circumstances, sinabi ng Supreme Court, we are all reversing ourselves. E di continue natin. Anong problema? Pero kagaya po na sinasabi ko kanina, Mr. President, ang pagkakaluto nga po ay hilaw eh. Ipinipilit po ngayong ipakain sa Senado ang isang bagay na hilaw. Eh paano? Sinabi po ba ng Supreme Court na wag na kayong mag-impeach? Hindi po. Binigyan po tayo ng guidelines. Alam po ba ninyo kung bakit binigyan na ng guidelines ng Supreme Court kung paano mag-impeach? Kasi po, Mr. President, if you recall, the Supreme Court issued a notice on July 8, 2025, requiring at least 11 information from the House of Representatives and the Senate. The Senate made a manifestation na wala po kaming maibibigay sapagkat lahat po niyan ay makukuha ninyo sa House of Representatives. Alam po ba ninyo na 4 sa hinihingi ng Supreme Court ay nandun po sa puso ng due process? Ano po yung hinihingi? Sinabi lamang po ng Supreme Court, pwede bang ibigay nyo sa amin kung lahat ng miyembro ng House of Representatives ay binigyan ninyo ng kopya at kailan? Pwede bang ibigay nyo sa amin ang timing kung kailan nyo ibinigay at binigyan, kung paano nyo sila binigyan ng pagkakataong mabasa yung impeachment complaint? Pwede nyo bang ibigay sa amin kung every article of impeachment ay nakalagay doon ang mga dokumento na nagpapatibay ng artikulo? Pwede nyo bang ibigay sa amin kung nagkaroon sila ng pagkakataon talaga na mabasa yung impeachment complaint? Alam po ba ninyo kung anong sagot ng Solicitor General in behalf of the House of Representatives? Ito po yung sagot nila. It is the position of the House that these matters pertain to its internal proceedings, which have always been regarded as beyond the jurisdiction and scrutiny of this honorable court. Sa Tagalog po, wala po kayong pakialam dito sa amin. Yung inihingi po ninyo, kami lang po yun. Para tinatanong lang naman po eh. Binigyan nyo ba ng pagkakataon sila na mabasa? Bakit? Mahirap po ba sagutin yun? Ano pa po sinabi? This is especially because the matters referred to, the preparation, circulation, and perusal of the impeachment complaint, as well as its attachment, are not governed by specific constitutional provision or the House rules. So dahil po wala sa Constitution at wala rin po sa House rules, ano po yun? Wardi-wardi na lang. So ibig sabihin talaga, kaya po pala ang dami kong kasama doon, wala talaga silang kopya. Ako nga po hindi nabigyan eh. Bakit hindi po kinakailangan bigyan lahat? Baka sakaling, malay po ninyo, baka pumirma ako, hindi ba? Ito yung tinatanong po ng Korte Suprema. Kaya lang po siya nakapagbigay ng additional guideline sapagkat isip-isipin nyo, sasabihin sa Korte, wala nang pong masamang tinapay ang Korte. Pwede po malaman namin kung talaga nagkaroon ng pagkakataong mabasa man niya lang, ma-appreciate ang bawat dokumento na nakasalig dyan sa impeachment na yan. Para sa ganun, ay boboto siya sang-ayon sa kanyang sariling kagustuhan. Matibay ang gusto ng Korte Suprema. Gusto niyang makita na lahat ay dumaan sa kayusan. Hilaw nga po Mr. President. Kanina ko pa po pinaiintindi, hilaw. Ba't hindi po kayo magluto ng mas masarap na kanin? Para sa ganun po, hindi tayo mahirapan. Maghintay na lang po kayo ng 6 months. Pwede naman Ba't pinipilit po natin ng isang bagay na hilaw at pinipilit niyong ipakain sa atin? Mr. President. Sabi ko po kanina, Mr. President, I am ready to amend my motion. Kung kinakailangan po, that will be consistent on the respect accorded to the Supreme Court. Kaya lamang po, kailangan nating umaksyon. Sapagkat kagaya po ng nalalaman natin, naghihintay ang taong bayan na kailangan magkaroon po ng closure ito sapagkat kapag ito will be hanging on the balance, baka hindi po mabutihin ng ating mamamayan. Yun lang naman po ang pinakapunto rito, Mr. President.
Thank you, Senator Marcoleta.
Mr. President.
What is the pleasure of the minority floor leader?
Thank you, Mr. President. Caution is the word simply being put forth by this representation, Mr. President. Because again, sabi nga, wala pa raw siyang nakita. The distinguished gentleman from Tarlac, with due respect, said wala pa siya nakita na unanimous decision ng Supreme Court na baliktad. No? Again, I said, there's always a first time. Bakit ko sinasabi ito? I will quote the Supreme Court themselves. In De Pedro versus Romasan Development Corporation, GR 194751, July 1, 2015, I quote, Supreme Court nagsabi nito while the Supreme Court's decisions are immediately executory, they are not considered final until the lapse of the prescribed period without a motion for reconsideration or upon denial of such motion. Sila nga mismo nagsasabi na hindi final Ano ba naman ang masama na maghintay tayo na kung final na? For all you know, I might vote on the motion to dismiss. Hindi ba? If there is such a motion, because according to Senator Lacson, it does not exist in the Senate. It exists in the impeachment court. And what I'm being told is that it should be the defense, the lawyers of the defense who should pose that motion to dismiss, not a judge. I agree with Senator Lacson. There is no such thing as a motion to dismiss in the Senate. In the impeachment court, yes. Thank you, Mr. President.
Hindi po ba inamid na natin, Mr.
By the way, just one last point. Why did the Supreme Court ask Sara to comment? Kung final and executory na yan, bakit si Vice President Sara was asked to comment by the Supreme Court just a few days ago? Di ba? So, ibig sabihin, talagang pakikinggan pa nila. At baka sakali makita nila, dahil yung mga abogadong nakapaligid sa kanila, nagbigay sa kanila ng mga maling figures at maling impormasyon.
Mr.
By way of point-
President, kaya nga po nag-i-speculate tayo rito Hindi natin alam kung anong iniisip ng Supreme Court. Pero sa ngayon, sinabi po niya, immediately executory at tayo lamang po talaga ang pinagsasabihan niya. At tungkol naman po sa motion to dismiss na minodify ko na kung ayaw po ninyo, wala po akong magagawa. Pero may I invoke Section 135 of the Senate Rules. Ang sabi po rito, if there is no rule applicable to a specific case, the precedents of the Legislative Department of the Philippines shall be resorted to. So ang dami po nito Dito po magkakaroon ng motion to dismiss dito. Lahat po ng precedents, kahit na wala po tayong specific rules, ay observe po natin ang Section 135 ng ating rules. Pero dahil inamend ko na nga po, kung pwede na po yung motion to archive, which is consistent to the immediate execution of the decision of the Supreme Court, address to this august chamber. Bakit naman po pinipilit pa nating i-delay based on speculation, based on the fortunes of whatever the Supreme Court will decide later on, which is based on impossibility.
Noted and entered into the records.
Mr. President. Just
What
for,
is the pleasure of the Honorable Cayetano?
Just 1 minute, Mr. President. Just for the information of the body, there's actually a Supreme Court case about the power to dismiss a case. Ito po yung Velasquez Jr. versus Lisondra Land 2020 case. Ang sabi niya, in order for the court or an adjudicative body to have authority to dispose of the case on the merits, it must acquire jurisdiction over the subject matter. It is axiomatic that the jurisdiction over subject matter is conferred by law and not by the consent or acquiescence of any or all of the parties or by erroneous belief of the court that it exists. Thus, when a court or tribunal has no jurisdiction over the subject matter, the only power it has is to dismiss the action. So Supreme Court na mismo nagsasabi na pag walang jurisdiction, it does not exist. So sabi ng Supreme Court dito, void ab initio yung articles of impeachment. Pag tinitingnan natin rules natin, the impeachment court is triggered by an articles of impeachment. Kung walang article of impeachment, walang court. So yes, it's true na it is a fact, not an operative fact. It is a fact na nag-robe tayo, nandito tayo. It is not an operative fact na meron tayong jurisdiction doon. Lastly, Mr. President, sa Rule 39, Section 4, judgment not stayed by appeal. Judgments in actions for injunction, receivership, accounting, support, and such other judgments that are now or hereafter be declared to be immediately executory shall be enforceable after their rendition and shall not be stayed by an appeal. Some may say this is for injunction, receivership, etc., and not for the impeachment court. Ang point ko lang, Mr. President,
Your Honor,
meron naman tayong...
This is a case for injunction.
Yes.
Filed by the Vice President against both the Senate and the House.
Thank you for that clarification. But even if it was not, Mr. President, that is why if we... The gentleman from Tarlac already said he's amendable. So kung halimbawa something like we move to act upon the Supreme Court decision and archive the case. Kasi yung Supreme Court decision, when you act upon, ano ba sabi niya? Immediately executory, ano ba sabi niya? Void ab initio. Ngayon, kung halimbawa na-reconsider at biglang sinabing tuloy, wala rin naman na epekto yon sa motion na we act upon the Supreme Court. Then at the proper time, someone can say here, we will act upon the latest decision of the Supreme Court. Diba? So I'm just saying this in the spirit, Mr. President, na pag nakaboto tayo, at least klaro kung anong pinagbobotohan, because some of us might not vote for the motion to dismiss just because we believe there is no such thing as a motion to dismiss. But I don't think that's our point. Our point is lagyan ng katahimikan to for a few months. February 6, game na ulit.
Noted and entered into the records. Majority Floor Leader.
Thank you, Mr. President. Next to interpellate, Mr. President, is the distinguished gentleman from Pampanga, but the gentleman from Pampanga is yielding the floor to our Deputy Minority Leader.
Yes, what is the pleasure of the Honorable Ontiveros?
Thank you, Mr. President, and to the good gentleman from Pampanga. Gusto ko lang pong bigyan ng point of information, sagot dun sa tanong ng good gentleman mula sa Tarlac, that in fact, the Supreme Court has reversed a unanimous decision in a lot of instances before. Dalawa lang po ang ibibigay kong halimbawa. League of Cities of the Philippines versus COMELEC. Original decision, 2008. Reversal on motion for reconsideration 2009. Isa pa pong halimbawa, International Service for the Acquisition of Agri-Biotech Applications Inc. o ISAA et al. versus Greenpeace Southeast Asia. Original decision, unanimous, December 8, 2015. Reversed unanimously on MR din, July 26, 2016. So, hindi lang po tulad nung sinabi ni Minority Leader na there's always a first time, it has happened before. So, yung ganitong klaseng milagro na hinahanap, posibleng mangyari din po dito sa kasong pinag-uusapan natin. Malay po natin. Salamat po, Mr.
Noted.
President. Salamat
Mr.
sa good
President,
gentleman
may I
from
know
Tarlac.
from
And
the
entered
good
into the
senator,
records. Senator Marcoleta.
may I know from the good senator if these decisions are bank decisions or divisions?
Yes, Mr. President, unbanked decisions po.
Well, you have to cite the
I would gladly
jurisprudence.
cite the GR number po bang hinihingi, Mr. President?
Pagka sinabi pong bank, lahat po ng members ng Supreme Court, 15 of them, unanimous.
To
Kasi po,
reiterate what I...
baka division lang yan, dahil 5 lang yun. Hindi po
No,
bank
Mr.
yun.
President, to reiterate what I already said, mga ano po ito, mga reversal ng unanimous Supreme Court decisions.
Yes, but I am
At sa
asking for
dalawang
qualification,
halimbawang
Mr. President,
binigay ko
whether
po
these are
on
bank
MR.
decisions or decisions by a division. And whether or not they
Mr.
were
President,
characterized
sinabi
by,
ko rin na po kanina,
Sandali
unbanked
po.
decisions po ito. Ay, hindi po.
whether or
I am
not the
replying to the
decisions
question.
are characterized by the following qualifications. 1, unconstitutional, void ab initio, violative of due process. All these are present in those jurisprudence and cases as you cited.
Mr.
President.
Mr. President, bagamat para itong yung pinag-uusapan natin kaninang operative facts, kanina simple lang yung tanong eh. May kaso na po ba na ang Supreme Court sa unanimous decision ay ni-reverse ang sarili nila? Ngayon may dinadagdag na tanong. Pero sige po, yung League of Cities of the Philippines versus COMELEC, the Supreme Court in its original decision in 2008 unanimously declared the cityhood laws unconstitutional. I will have to get more information po on the ISAA reversal of unanimous decision. Pero malinaw na mga sagot na po ito dun sa original na tanong. So the original assertion na hindi po natin alam kung na-reverse na ng Supreme Court ang sarili nila sa original na unanimous decision has fallen by the wayside. Kasi the Supreme Court, as I said already earlier, has reversed a unanimous decision unbanked in a lot of instances before. Yun lamang naman po, Mr. President.
Noted and entered
Salamat
into
po.
the records. Majority Floor Leader.
Yes, Mr. President, may I move that we recognize the next interpellator, the gentleman from Pampanga, Senator Kiko Pangilinan.
Yes,
So
Mr.
move, Mr. President.
Senator Pangilinan is recognized and may proceed. Should the gentleman, sorry, sir.
Yes, Mr. President.
Yes, Mr. President, this is not an interpellation, but with the permission of the gentleman from Tarlac, we will just make a manifestation.
The gentleman may proceed.
Thank you, Mr. President. Mr. President, marahil marami ang nagtataka o nagtatanong ano nga ba ang pinakapunot dulo o debate na pinag-uusapan dito sa Senado. Tatlong sa probisyon ng saligang batas. Tatlong kapangyarihan ng tatlong sangay o tatlong governmental entities. Yung kapangyarihan ng judicial review ng Korte Suprema, yung sole power ng House of Representatives to initiate impeachment proceedings, at yung sole power ng Senate bilang impeachment court para litisin at pagpasyahan ang isang impeachment case. Narito tayo ngayon, nagdedebate dahil yung judicial review power ng Supreme Court ay pinawalang bisa ang sole power ng House of Representatives para ito ay mag-initiate ng impeachment proceeding, at pinawalang bisa rin ang kapangyarihan ng Senado bilang sole having the sole power to try and decide impeachment cases. Dahil dito, saan tayo tutuloy? Merong na ring mga ruling ang Korte Suprema kung paano natin iha-harmonize o ihahambing ang mga nagtatalong probisyon ng saligang batas. Sinabi ng Korte Suprema sa kaso ng Civil Liberties Union versus the Executive Secretary, pati na rin sa Francisco case versus HOR, the Constitution is to be interpreted as a whole, and one section is not to be allowed to defeat another. In this case, the judicial review should not be defeated. The sole power of the House to initiate should not be defeated. And the sole power of the Senate to try and decide cases. All mandates, all duties, all constitutional powers that do not belong to us, that was given to us, not by any whim, but by the Constitution, all of whom here sworn to uphold and defend. Kaya ano ang way forward? Sabi nga, may mga minungkahi, si Justice Ascuna, hayaan sa MR, payagan sa motion for reconsideration, payagan na magkaroon ng operative facts doctrine para yung anuman ang pinagpasya ng Korte Suprema sa kasong ito should apply prospectively, number one. Pangalawa ay sa pamamagitan ng MR pa rin ay mabigyan ang House of Representatives na maituloy ang kanyang kapangyarihan to initiate, and at the same time, mabigyan ang kapangyarihan ng Senado to try and decide the case. Kaya habang naririyan ang MR, baka sakali, at nangyari na nga, na the Supreme Court has reversed itself, even in a unanimous decision. But even assuming it does not reverse itself in this case, the Supreme Court may modify its ruling. And therefore, if it modifies the ruling, assuming that it modifies but does not reverse itself, should we not await the resolution of the motion for reconsideration before we vote? Today, we hold it in abeyance or we table it. Mr. President, if I may add, the SC, the Supreme Court, hindi niya binanggit. Binanggit niya nawalan ng jurisdiksyon ang Senate Impeachment Court. Pero ang ibig sabihin nun ay pinawalang bisa, ginawang void ab initio ang mga kilos at pasya ng Impeachment Court. The convening of the Impeachment Court was voided. The majority decision to remand the complaint to the HOR was voided. The summons by the Impeachment Court were all voided. Which brings us to the question, who now is deciding the impeachment case? Now that all the decisions of the Impeachment Court have been voided. It's a tricky question, Mr. President. But if I were to be an impeachment court judge, I would argue that we have to, in the MR, in the motion for reconsideration, intervene and uphold the impeachment court's exclusive power to try and decide the case. Why? Because it is the constitutional duty to do so. It is the order of the Constitution. We are not defying the judicial review powers. We are upholding the sole power of the Senate to try and decide impeachment cases. But, having said that, sabi nga, it is our view, and this is shared precisely by former Supreme Court Chief Justice Panganiban, former Chief Justice Puno, former Constitutional Commissioner and Justice Ascuna. They have seen, or they have read their decision, and they too have said that the Supreme Court erred on a matter of facts. And if the Supreme Court erred on a matter of facts, how can you be right with the law if you are wrong with the facts? And if you are not right with the law, why will the impeachment court and the Senate, for that matter, decide on the matter today? Why not wait for the motion for reconsideration? Siguro naman, hindi natin binabangga ang Supreme Court, hindi natin binabangga rin ang House of Representatives dahil meron ding prinsipyo ng parliamentary courtesy, meron ding prinsipyo na kinakailangan natin bigyan ng respeto ang co-equal. We are a co-equal to the House of Representatives. Ano na lang ang magiging repercussion na ito ang House of Representatives nag-file ng motion for reconsideration, hinihiling nila sa Supreme Court na baguhin ang ilang mga findings of facts, baguhin ang kanilang naging desisyon, habang pinangunahan ng Senado ang House of Representatives at sinabi, wala kaming pakialam sa inyong motion for reconsideration, i-dismiss namin ang kasong ito. I think, out of courtesy for a co-equal, we should respect the House of Representatives. In the same way, if the Senate would, at a future time, file a case before the Supreme Court and seeks a motion for reconsideration in a matter that involves the House, we would like to think that the House will not act to have the case dismissed pending the MR out of respect for a co-equal. Sana, pag-aralan natin ng husto ang pagpasya ngayong hapon. Sabi ko nga, the findings of grave abuse by the Supreme Court, thereby removing or taking away from us the jurisdiction, na wala tayong jurisdiction, that jurisdiction was not acquired on the basis of facts that are flawed, where then is the grave abuse? I don't know what the ruling will be. Perhaps they will say, yes, there was no grave abuse of discretion on the part of the House because of the 1-year bar, which was not actually, the fourth complaint was not bar. I don't know. But whatever it is, hintayin na lang naman sana natin. Respetuhin naman natin ang ating co-equal. Why the convening of the impeachment court is the way to go? Dahil pag tayo ay bumoto ngayong hapon o ngayong gabi na i-dismiss ito, aksyonan ang impeachment complaint, we will be acting without legal authority dahil wala naman sa atin yung impeachment complaint. Wala namang kapangyarihan ang Senado in plenary, ultra vires, without legal authority, ang magiging desisyon natin. One final point. In the Corona impeachment trial, nang himasok, nag-TRO ang Supreme Court para sa mga bank accounts. Ano ang ginawa ng Senate Impeachment Court? Bumoto 13-10 para respetuhin ang Korte Suprema. I did not vote in favor of the TRO or respecting the TRO. But the Senate, as an impeachment court, voted and we respected it. Because it was the Senate Impeachment Court that decided. It was not the Senate. It was the Senate Impeachment Court that, seeing perhaps that we needed to harmonize the power of judicial review, the power of the Senate as an impeachment court, to have the sole power rather to try and decide cases, seeing that the Senate in impeachment court decided to harmonize the conflicting provisions of the Constitution. I think we should as a Senate Impeachment Court, do the same. Kung ipagbobotohan na respetuhin ng Korte Suprema para walang constitutional crisis, so be it. But it ought to be the Senate Impeachment Court that asserts its sole power to try and decide impeachment cases. Yun na lamang po, and I associate myself with the motion of the minority leader that we lay on the table the matter of the impeachment case and action.
Just a point of information, for the record and for the information of the body. Chair confirms the manifestation earlier of Senator Cayetano with respect to Section 4, Rule 39 of the Rules of Court that says that decisions of the court are not immediately executory unless the decision says so. In this case, the decision specifically stated that it is immediately executory. Number two, again, just for the record, the Supreme Court itself, through its spokesperson, after the House filed their motion for reconsideration, reiterated the immediately executory nature of the decision of the Supreme Court. And finally, the Supreme Court's own internal rules states that the entry of judgment shall be the date such decision or resolution becomes executory unless the court directs its immediate execution. I'm quoting and citing AM number 10-4-2-20 rather SC, specifically section 16, rule 16 rather, section 1. So there are conflicting authorities with respect to the opinions raised by the various members. Senator Marcoleta, what is your pleasure?
Just a quick reaction, Mr. President, on the manifestation of Senator Pangilinan. In the exercise of the Supreme Court's judicial review, wala po siyang dinidefeat doon. Hindi niya po kinukuha yung sole power of the Senate to try and hear impeachment cases. Hindi rin po niya kinukuha yung exclusive authority ng House to initiate impeachment. Dito po sa desisyon na ito, kung kinakailangan ulitin po o ulit-ulitin pa, ang sinabi lamang po ng Supreme Court, yung process, yung procedure hindi natupad. Ang dami po niyang hiningi, kagaya po ng binanggit ko na, ayaw pong ibigay. Yan naman pong mga tuntunin ay hindi naman po sinunod. Katulad nga po nung immediate referral, yung pag-refer sa Committee on Justice, yun pong pag-include sa order of business at pag-archive, mali din po sapagkat hindi naman po 10th session day yun 11th session day. Katakot-takot na paglabag po ang aking pong inihayag sa hapong ito. Wala naman pong gustong magpatibay at o kaya sansalain o kaya sabihin na mali ang aking sinasabi. Andito po yung kopya ng order of business na pinagbasihan ng Solicitor General na kung saan sinasabi po niya na yung 4 na impeachment complaints in-include daw po sa order of business. Tingnan po ninyo, wala kahit isa. Ang ginamit po nila ay journal, hindi po yung order of business na kung saan ginamit lamang po na additional reference of business. Ngayon po, yung operative fact na sinasabi natin, hindi rin po pwedeng mangyari yon sapagkat ang pinakabasihan po noon ay equity and fairness. Paano po yung fairness dito? Sari-sari nga pong violation, kaya nga ang paghahanilin tulad ko na nga, parang nagsaing ng kanin, talagang hilaw po Bakit ipipilit natin? Ang alternative lang po, Mr. President, gawin po natin na tama. Iluto po natin ng tama para hindi tayo magkahirap-hirap dito. Isip-isipin po ninyo, sinasabi ng ating Constitution, isa lamang pong impeachment proceedings ang pwedeng i-initiate sa isang opisyal ng gobyerno at hindi po pwede ang 2 beses sa loob ng 1 taon. 4 na beses po ang ginawa nila. At kunwari, in-archive po yung 3 para lamang palitawin na isa lang ang nabuhay. Nasaan naman po yung katwiran? Kung sarili pong tuntunin, ayaw pong sagutin, ayaw pong talimahin, pagkatapos ipipilit po natin, sapagkat nag-MR sila, ano po ang kasaysayan ng MR? Sabi ko nga po, napakasimple po nung one year ban rule ng Supreme Court. And the Supreme Court is not even obligated and expected to conduct a microscopic, a forensic and scientific scrutiny of this provision, where the pertinent language and the relevant meaning is as clear as daylight, Mr. President. Ano po yung gagawin? Hihintayin po ba natin kung ano ang magiging kalalabasan po ng MR na sa akin pong palagay, hindi po speculation, sabi ko nga po. Unanimous decision and bank decision ab initio unconstitutional, violative of due process, immediately executory. Sino po kaya kahit isa man lang na miyembro ng Korte Suprema ang magtatangka na i-reverse niya yung sarili niya? Yun po yung speculation dito. Ngayon, nakikinig po ang taong bayan, Mr. President. Nakadepende po ba ang action natin? Doon po ba nakahang ang gagawin natin sa isang motion for reconsideration na sa aking palagay, matibay po ang aking palagay sapagkat this is borne out by my experience of more than 20 years of legal practice, Mr. President. Yang ibig lang sabihin nung immediately executory, sige, pwede kang mag-file ng MR. But you are wishing for the moon. Sumusuntok ka sa hangin. Yun po ba ang basihan natin? Kaya hindi tayo makapag-desisyon, Mr. President? Sana mayroong mas matibay sanang desisyon. Meron sanang mas matibay na katuwiran. Hindi yung pong nakasalig po sa hangin. Nakasalig po kung puputok ang bulkan o hindi. Hindi po yata gano'n ang gawain ng Senado, Mr. President. Tinangka ko na nga pong i-amend. Kung ayaw po ninyo yung motion to dismiss any other language that will put to rest this issue in obedience and in complete respect to the last word of the Supreme Court, it being immediately executory, Mr. President.
What is the pleasure of Senator Aquino? I saw him raising his hand earlier. Senator Aquino seems to be yielding to Senator...
Yes, Mr. President, may we recognize Senator Lacson, Mr. President?
Thank you, Mr.
With the
President.
permission of Senator Aquino, Senator Lacson is recognized.
Thank you, Mr. President. Gusto ko lamang pong itama ang misimpression that may have been created by the interpretation of the Honorable Marcoleta do sa Section 135. Sabi niya, yung supplementary application of the rules of court. Basahin ko po yung Section 135, Mr. President. If there is no rule applicable to a specific case, the presidents of the Legislative Department of the Philippines shall be resorted to. And as supplement to this, the rules contained in Jefferson's Manual, Riddick's Precedents and Practices and Hin's Precedents. Wala naman po ako nakita doon sa enumeration na rules of court. Di ba po sabi ng mga abogado, di ba yung expressio unius est exclusio alterius. What is expressly included excludes all others. So wala naman pong rules of court. Kaya gusto ko pong itama yung medyo hilaw pong interpretation ng ating Honorable Marcoleta. Maraming salamat po, Mr. President.
Noted.
Mr. President, may we recognize Senator Bam Aquino has been waiting for his turn to interpellate the gentleman from Tarlac.
Senator
So moved,
Aquino
Mr.
is
President.
recognized and may proceed.
Maraming
Should
salamat.
the gentleman allow it.
Maraming salamat, Mr. President. This is a manifestation, not an interpellation, Mr. President. At kanina pa ako nakikinig.
The gentleman may proceed.
Marami po sa mga puntong nabanggit na ng mga kapwa nating senador ay sumasang-ayon po tayo at tama, no? Napag-usapan na po ang independence ng Senado, kung gaano kahalaga ang papel na ginagampanan natin sa ating bansa, sa checks and balances ng ating gobyerno. At alam rin naman po ng mga kasama natin na sa caucus, sinabi ko rin po na ang posisyon ko ay dapat mag-convene ang impeachment court at doon magdesisyon kung ano ang mga susunod na hakbang pagdating po sa impeachment case. No? That's known to everyone. I've said that in the media. Mr. President, in our history, nagkaroon po ng mga panahon na ang Senado ay nag-assert ng kanyang independence bilang isang co-equal branch of government. Nangyari po yan many times. I remember in the 90s, Kahit po ang executive, at that time, President Cory Aquino, nagnais na manatili ang US bases dito sa ating bansa. Yung Senado, nanindigan. Kahit puro kaalyado, kahit puro kakampi at kamag-anak nasa Senado, nag-decide pa rin yung Senate to assert its independence and to do away with the US bases. Nangyari po yan many times in our history, Mr. President. Kaya palagay ko, yung role ng Senado napakahalaga pagdating sa pagpapanatili ng checks and balances. And Mr. President, marami tayong tungkulin. May tungkulin gumawa ng batas, may tungkulin sa pagbuo ng maayos na budget, may tungkulin ng oversight, pero meron din pong tungkulin pagdating sa pananagutan or accountability. At yun po yung sole power to try and decide all cases of impeachment. Ang posisyon ko, Mr. President, at nabanggit rin ito ng iba nating mga kasama, ay mahalagang i-assert natin ang ating independence. Mahalaga po na itong papel na ginagampanan natin sa ating Constitution ay pahalagahan po natin. Mahalaga po na manatili ang independence ng ating Senado bilang isang co-equal branch of government. Mr. President, posisyon ko rin po na nagsimula na ang impeachment proceedings. Nag-robe na po, nagsimula na, merong summons na binigay, may response na po si Vice President Sara. Kami pong mga bago, may mga robe na rin po pero hindi pa po nadudumihan. Hindi po magagamit, no? Ang posisyon ko po, mag-convene ang impeachment court at doon natin i-decide ang mga bagay-bagay na ito. Mr. President, may dalawang bagay rin na nailabas, no? Na hindi pa siguro na pag-uusapan. Let me read, Mr. President, Article 9, Section 3 of our Constitution, Accountability of Public Officers. In case the verified complaint or resolution of impeachment is filed by at least 1/3 of all members of the House, the same shall constitute the articles of impeachment and trial by the Senate shall forthwith proceed. Wala pong dagdag po dito. No? Dito po sa gallery, kasama ho natin dalawang framers of our Constitution. Nandito po si Professor Ed Garcia at si former Chairperson Christian Munsod. Kanina po, nagbubulungan kami. Sabi ko, nung ginawa nyo to, bakit parang ganun kasimple? Simpleng-simple lang, ito lang. At sabi nga po nila, noon daw, 1/2, 2/3, binabato 1/2 sa deliberation, nag-end up sa 1/3. At yung desisyon ay dahil sa kabilisan. Dahil mahalaga daw na mabilis, pag may 1/3, members of the House ang pipirma, mabilis na pupunta po sa Senado. At ito po, tinatanong ko sa kanila, dahil sila po yung nagbuo ng ating Constitution. You know, many times, Mr. President, umiikot tayo sa ating bansa. I-bring up ko lang po yung free college law. No? Marami ko sa atin dito nagtulungan para sa batas na yan. Meron kaming nakausap na eskwelahan. Ini-explain sa akin yung opt-out provision. Kung paano sila nag-charge ng mga estudyante dahil sa opt-out provision. At sabi ko sa kanila, mali ang interpretasyon ninyo. Yung interpretasyon ninyo, wala yan sa aming intensyon. Ang intensyon po namin, libre ang kolehiyo sa mga kabataan. At nung nag-argumento po sa akin, ang sabi ko, mas alam ko yan kasi ako ang nagbuo ng batas na yan. Mas alam namin yan dahil kami ang nagsulat ng provision na yan. In the same sense, Mr. President, the framers of our Constitution, mas alam po nila. Mas alam nila kung ano yung intent ng ating Constitution. Wala pong labis, walang dagdag. Many times, Mr. President, tinatanong tayo, usually pag campaign time to, tinatanong kami, Mr. Senator, hindi ba dapat merong educational attainment requirement yung pagiging senador? At sinasabi ko po lagi, wala, kasi wala po yan sa ating konstitusyon. Wala pong dinagdag, wag tayong magdagdag nang wala pong nakasaad po dyan. So gaya po niya, no, binabanggit ko lang po dito dahil na pag-uusapan, may mga dinagdag na mga procedure. Alam ko po, siguro, tama po ang sinasabi ni Senator Marcoleta, baka maganda naman ang intensyon ng Supreme Court. Pero aminin na po natin, wala po yung ibang mga bagay dyan dito po sa ating konstitusyon. Pangalawang punto, ito po, hindi rin po nagpag-uusapan pa. Nabanggit po dito, wag na tayong lumaban kasi matatalo rin naman tayo. No? Of course, Mr. President, it is improbable, aaminin ko po yan, very improbable na magbago ang Korte Suprema with 15 votes. But it's not impossible. Improbable at impossible, magkaiba po yan, firstly. But secondly, Mr. President, may mga panahon na kahit alam nating matatalo, kailangan pa ring lumaban. Tayong lahat po dito, dumaan po dyan. Ako po, dumaan rin po dyan. Kahit mukhang mahirap, kahit mukhang matatalo, kailangan lumaban pa rin. Tumayo tayo sa sarili nating paa, mag-assert tayo ng ating independence, ipahiwatig natin yung ating saloobin bilang isang grupo, ipakita ho natin na co-equal branch of government tayo, na meron tayong punto de vista, at kahit matatalo, kahit sa kaduluduluan ng lahat, rerespetuhan rin naman natin ang Supreme Court, mahalaga na mailagay pa rin kung ano ang nasa saloobin ng ating grupo. Mahalaga pa rin na malagay natin kung ano talaga ang posisyon ng Senado pagdating sa ating independent nature and being the sole authority to try and decide impeachment cases, kahit po matatalo. So para sa akin po, hindi katanggap-tanggap ang posisyon na dahil matatalo rin tayo, huwag na tayong lumaban. Paminsan-minsan po mahalaga na ilagay naman natin ang ating posisyon kahit alam po natin na hindi pabor sa atin ang mga bagay-bagay. Thank you, Mr. President, and we'd like to thank Senator Marcoleta for his time.
Thank you, Senator Aquino. Noted and entered into the records. Senator Marcoleta.
Mr. President, I thank Senator Bam for his manifestation. Totoo nga po na yung binasa niya sa Article 11, Section 3, Paragraph 4, na sinasabi nga naman, in case the verified complaint or resolution of impeachment is filed by at least one-third of all the members of the House, the same shall constitute the articles of impeachment and trial by the Senate shall forthwith proceed. Ngunit, Mr. President, this cannot be applied in isolation of Paragraph 8 na nandito rin po sa the same Section 3, Article 11. Ang sinasabi po sa Paragraph 8, the Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. Kaya po ang sinusunod ng House dapat yung rules of procedures in impeachment proceedings. Pero kagaya po na sinabi ko, imbes na sundin po nila, sila po yung gumawa nun eh. Eh hindi naman po nila sinunod. Kaya po ang nangyari, pinagsabihin ng Korte Suprema, ganito ang pag-file. Nagbigay nga po ng guidelines. Pangalawa po, yung kanyang sinabi na nakapag-umpisa na po kayo eh. Kanina po, kinwalify ko yun before I proceeded in my speech. Sabi ko po, the initial proceedings conducted by the Senate of the 19th Congress were not formally carried over into the Senate of the 20th Congress. Wala po talaga eh. I cannot recall, sabi ko nga, and there is no action taken by this chamber, Mr. President, sapagkat ang alam ko, all these proceedings were already deemed terminated at the expiration of the 19th Congress at noon of June 30, 2025. And they cannot be miraculously bring forth to life in this Congress where both of us now belong because this Congress is of different composition. Yun lamang po ang qualification doon, Mr. President.
Quick rejoinder, Mr. President.
Senator Aquino is recognized.
Yes, Mr. President. Babanggitin ko lang po yung isang na banggit ni my co-gentleman from Tarlac, Senator Marcoleta. Mr. President, may Section 4, may Section 8. Di ba? Ito po ba'y meant to reflect each other or not? Maganda pong matanong yung mga framers of the Constitution. Sila po yung nandoon nung nabuo po ito. At malalaman natin yan kung meron pong oral arguments. Kung ibubukas po ang mga argumento sa publiko, pwede po magsalita yung framers of the Constitution, at doon po, sa posisyong yon, malalaman natin ano ba talaga ang intensyon ng mga gumawa ng ating Constitution. And Mr. President, pwede pong mangyari yon if we are able to table this matter and allow for these oral arguments to happen. Mr. President, hindi po ba maganda rin kung ang Senado mismo magsama-sama at magsabi sa Supreme Court, baka magandang magkaroon ng oral arguments dito po sa kasong ito. Yun lang po, Mr. President. Thank you.
So we
Majority Floor
can
Leader.
continue, Mr. President, with the list of senators wanting to interpellate and make a manifestation. At this juncture, Mr. President, may we recognize the distinguished gentleman from Isabela and Davao, Senator Rafi Tulfo, for his manifestation. So move, Mr.
Senator
President.
Tulfo is recognized for his manifestation.
Thank you, Mr. President. This is not an interpellation, but a short, very short manifestation. In line with what Senator Pia Cayetano said earlier, that we can be creative in our motion today, and correct me if I'm wrong, if I've heard it right, what Senator Pangilinan from the minority said, that we're not defying the decision of the Supreme Court. So may I propose that instead of dismissal, we just dissolve this impeachment court? Because in the first place, per the decision of the Supreme Court, sinasabi na wala naman talaga tayong jurisdiction over dito sa articles of impeachment. So mas maganda siguro, i-dissolve na lang natin to para we're still in line with what the Supreme Court said. Thank you, Mr. President.
Noted and entered into the records.
Mr. President,
Majority Leader.
next and last but not the least to interpellate the distinguished gentleman from Tarlac is the lady from Taguig and Pateros, no other than Senator Pia Cayetano. I move that she be recognized, Mr. President.
Senator Pia Cayetano is recognized for interjections and/or manifestation. You may proceed, ma'am, if the gentleman will so allow it.
Yes, Mr. President.
Thank you, Mr. President. With the permission of the proponent, Senator Marcoleta, I would like to
Yes, Mr. President.
make a few observations and then perhaps ask His Honor's opinion on these matters.
Please.
Thank you. So, Mr. President, I'm reading directly from the case Duterte versus House of Representatives. Page 95. It states, the subsequent filing of the articles of impeachment under Article 11, Section 3.4 against Vice President Sara Z. Duterte and its transmittal by the House of Representatives to the Senate of the 19th Congress is considered to be a separate and distinct mode of initiating the impeachment process. The articles of impeachment are declared barred by Article 11, Section 3.5 of the Constitution. Likewise, they are unconstitutional and are deemed null and void ab initio. Consequently, the Senate did not acquire jurisdiction to constitute itself into an impeachment court. This decision is immediately executory. It shall be deemed served on petitioner and release upon publication the Supreme Court website and receipt of the parties of their digital copy in accordance with AM number 250516 SC, or the guidelines on the transition to electronic filing in the Supreme Court. So, I read this into the record, Mr. President, because I'd like to emphasize a few key phrases. The Senate did not acquire jurisdiction to constitute itself into an impeachment court. I'll start with that one, and then the second one is this decision is immediately executory. So, pag sinabing the Senate did not acquire jurisdiction to constitute itself into an impeachment court, and yet the fact remains that we did constitute ourselves into an impeachment court, then what are we supposed to do? Because the Supreme Court tells us that we did not acquire jurisdiction. As most lawyers, well, all lawyers should know, when the Supreme Court tells another body, usually it's the lower court, or sometimes it's a government agency, and the case was by our accepted rules elevated to the Supreme Court. They tell them you have no jurisdiction. The only thing you do is, what do they call it? There's a term, you have residual powers. And those residual powers basically simply allow you to dispose of the case as per instructions of the Supreme Court. Is that the understanding of His Honor?
Yes, Mr. President. Actually, residual powers apply also under Section 135. Yun po yung sinasabi ko kanina. Hindi ko po sinabi kanina na I am invoking that because the rules of court are there. Hindi po yun. Kasi legislative department po ang sinabi ko doon. Kasi wala pong applicable rules. Pwede po yun, ma'am. Mr. President.
Kasi ang akin po, and I've tried all my life to be a dutiful citizen, and Alan knows I was a good daughter, a better daughter than he was a son, in terms of following our father's rules. Pag sinabing, hindi mo pwedeng gawin yan, wala kang karapatan na gawin yan, hindi ko gagawin yon. At kung ginawa ko yon, babawiin ko. Kasi nga sinabi sa akin na wala akong karapatan na gawin yon. So, yun ho ang iniintindi ko. I am one of 5, tama bang bilang ko, 5 lawyers here in the Senate. And I'm trying to do my job as a senator and as a lawyer. I am trying to listen carefully to our colleagues who have expressed their desire to constitute ourselves as an impeachment court. But I do not know how we can legally do that when the Supreme Court tells us we did not acquire jurisdiction to constitute ourselves into an impeachment court. We did not acquire it then, and we do not acquire it now. So how would we do that? And those of you who've worked with me know how hard I work to find a solution. I bend over backwards, I listen, I redraft everything para masaya tayong lahat. And of course, within the bounds of the law. How do we do that? How?
Mr. President, I think the good senator already provided the answer. By using the Senate's residual power. Kung titignan po niyo yung definition ng residual power, hindi po talaga nakasulat yung power per se. Ngunit inherent sa opisina yon, kaya tinawag pong residual power. Nung sabihin po ng Korte Suprema, this is immediately executory, wala pong ibang departamento, walang ibang opisina ang tinitingnan niya kung di tayo lamang. Kung hindi tayo gagalaw, wala pong iba na gagalaw. At mananatili pong nakahang ang isyong ito, Mr. President.
So yun yung first point, Mr. President, that I wanted to raise, and thank you for your response, Senator from Tarlac. And then with respect to the second phrase that I wanted to dive into, immediately executory. So sinabi to dun sa desisyon, and then I think the Senate President mentioned it also, that in their press briefing just yesterday, the Supreme Court stated that, to recall, on July 25, 2025, the Supreme Court granted the petition to dismiss the 4th impeachment complaint against Vice President Duterte. In a 13-02 decision with the justices present voting unanimously, and Associate Alfred Benjamin Kagiwa inhibiting, and Associate Justice Maria Filomena Singh on leave, the Supreme Court en banc ruled that the impeachment complaint was void for violating the 1-year ban and due process requirements. This decision is immediately executory. Inulit pa nila sa press briefing nila. So sa akin lang po, parang nahihirapan ako as a lawyer and a lawyer in the Senate to say that they did not intend it to be immediately executory, because they said this knowing that there already was a motion for recon, and knowing that we are going to have this discussion today because we made this date public, that on this day we will have this discussion. So again, I'm trying hard to see how, other than disposing of the case using our residual powers following the instructions of the Supreme Court, we can further debate this issue. That is my dilemma, dear colleagues, Mr. President.
May I offer an answer, Mr. President?
Of course.
Pasensya na po kayo kung gagamit po ako ng paghahalimbawa. Nung pong kayo po ay medyo bata-bata po, Madam Senator, meron pong lumigaw sigurado sa inyo. Yung
Huwag
unang
na ho
lumigaw
natin
sa inyo
pasukin yung
talagang...
diskusyon na yon. Hahaba ho ito, mas mahaba po sa debate ng impeachment.
Ganito po yun eh. Tinapat nyo talaga. Ayaw nyo magtagal pa yun eh. At tama naman po yung ginawa ninyo. Ipinakita nyo sa kanya, pinaramdam nyo sa kanya, talagang wala siyang maasahan kaysa mapagod pa siya.
Sino ho
Pero
yun?
ang sabi niya sa inyo, ang sabi po niya sa inyo, pwede bang ako'y kahit papano'y dadalaw-dalaw pa rin? Parang nag-MR. Nasa sayo yun, but that will not change my mind. Ganun din po yun eh. Ang Korte Suprema, sa ganitong, Mr. President, the very tenor of the decision, kahit na po sinabi niyang, oh sige, nasa sayo. Formality na lamang po yun, Mr. President. You are a trial lawyer too. Most of us here became trial lawyers. This is our experience. Huwag po nating pahirapan yun. Sana man lang kung ang decision po 8-7. Yun po pwede nating pagtalunan po Wala po talaga Mr. President.
If I may, Mr. President, and I think that was a good analogy. Thank you for that. Napaisip niyo ho ako doon. I think what's interesting with His Honor's analogy is there are people, there's the public, I don't know, millions of people would like to understand ano ba yung final na kasong yon, may evidence ba? And totoo yan, di ba? Hindi natin matatanggal yon. So in the same way, yung manliligaw na walang pag-asa, gusto din niyang malaman na ano ba yung chances, ano ba yung nangyari, bakit ba meron kang ganitong conclusion, can I convince you otherwise? I think that's what His Honor is trying to say. And I think the public really want to know. Let the record show na tawang-tawa po si Senator Bato sa likod. And we really want to know, sino ba namang may ayaw malaman kung merong isang public official na naakusahan ng katiwalian. Lahat po tayo interesado doon whether mahal mo yung taong yon, whether galit ka sa taong yon, you want to know the truth. Kasi kung naniniwala ka na innocent yung taong yon, gusto mong mapatunayan niya na innocent siya. At kung galit ka sa taong yon, gusto mong mapatunayan na guilty siya, hindi ba? But meron tayong kinikilalang Supreme Court na nagsasabing hindi nga dumaan sa tamang proseso. So kumbaga siguro sa example nyo, baka hindi dumaan sa tatay ko, hindi nagpaalam ng maayos. Di wala naman akong choice, kundi sabihin na wala kang pag-asa. Baka naman may pag-asa, pero I have to follow the rules of my father's house na hindi dumaan sa tamang proseso. So doon ho tayo babalik, and as a lawyer, I have to say this na yun nga, we are governed by laws. And in as much as gusto ko rin malaman, bothered ho ako sa mga gantong akusasyon. The other day, our colleagues, merong privilege speech tungkol sa kalokohan dun sa paggagawa ng mga flood control. Gusto natin malaman, di ba? Ngayon, pagka yun na-discuss sa sa media, okay na, media siya. Pero walang papupuntahan yun kasi it should go to the proper process. May process yan sa halls of the Senate. We have hearings in aid of legislation, and then magre-recommend tayo na ma-ombudsman yan. So may proseso tayo. So yun ho siguro yung pinapatunguhan. Doon ho papunta ang aking conclusion na in as much as the public deserves to know, because we all deserve to know, we also have to follow the process. And I share this with everyone kasi ang hirap lang talaga ng sitwasyon natin kung hindi tayo makikinig sa Supreme Court. Meron tayo in the Senate, Congress, we have our duties as co-equal bodies. Ang duties po namin kasama ang pagsiyasat ng budget ng lahat ng agency. So pati Supreme Court, budget niya, tinitingnan. Lahat ng Regional Trial Court, tinitingnan natin ang budget. That's our job as a co-equal. Sila naman, may job din sila na pagka may grave abuse of discretion, they have to also say it. They also have to make their position known, which they have. And I will repeat, ang sabi ng desisyon ng Korte Suprema, the Senate did not acquire jurisdiction, and this decision is immediately executory. So, I'm happy to listen. I don't know kung may magsasalita pa, pero I shared my views on this in the hope na marinig ko din yung views ng proponent. Nakikinig po ako sa mga kasamahan natin para ma-enlighten din po ako. But I'm guided also by my practice as a lawyer and my duty as a lawyer to also, I can disagree with the court. Wala tayong problema doon. We know that we have that personal right to disagree with the court, but we also have to in the end, follow the court's orders, whether we agree with them or not.
Very quickly,
Thank you, Mr. President.
With the permission of Senators Marcoleta and...
What is the pleasure of Senator Pangilinan?
Just a quick interjection.
The gentleman may proceed.
Maybe to add to either the enlightenment or additional bewilderment of Senator Pia Cayetano. Yes, the Supreme Court ruled that we did not have jurisdiction. Yes, the Supreme Court ruled that it is immediately executory, but it makes you wonder why the Supreme Court did not issue a writ of injunction. So
Did not, sorry, I didn't hear that. It makes
did
you
not
wonder
issue-
why.
Did not enjoin us, did not issue a writ. It could have, but it did not. So, yeah, your guess is as good as mine, because if they really wanted us to end this, then why didn't they enjoin us?
Just to add to the bewilderment and the enlightenment, what is there to enjoin when we never acquired jurisdiction according to them? What is the pleasure of the Honorable Ontiveros?
Thank you, Mr. President. Dalawang dagdag na punto lang para sa diskusyon natin. Precisely regarding the immediately executory na kababanggit lang ni Senator Pangilinan at inulit din kanina ng good gentleman from Tarlac at pati ng good gentlewoman from Taguig Pateros, immediately executory. Still, Mr. President, there is no defiance here dahil the ruling, hindi pa rin po final siya. And even if the ruling states that it is immediately executory, at kahit inulit po yon dun sa recent na anunsyo ng Korte Suprema tungkol sa MR, even if the ruling states that it is immediately executory, the court itself in many cases has explained that this does not mean self-executory. Immediately executory does not mean self-executory. Section 1, at ito kaugnay ng kasasabi ni Senator Pangilinan, Section 1, Rule 39 of the 2019 Rules of Court states that execution shall issue as a matter of right on motion. This means that a writ of execution issued upon a motion is necessary for the execution of a decision. At this point, Mr. President, wala pa pong iniuutos ang Korte Suprema sa Senado. And secondly, at this point, Mr. President, bukod pa po kasi sa yung first group of complainants, yung House of Representatives mismo sa pamamagitan ng Solicitor General at yung isang bayan, meron pang isang importanteng entity, institusyon sa ating lipunan na nagsalita tungkol doon sa Supreme Court ruling. At ito po ay isang entity sa mass media, ang ABS-CBN. Meron po silang anunsyo, ABS-CBN news statement on articles cited in the Supreme Court decision on Vice President Sara Duterte's impeachment. At gusto ko lang i-make of record dito, Mr. President. Sabi nila, ABS-CBN News respectfully clarifies that the article cited in the Supreme Court decision on the impeachment of Vice President Sara Duterte did not state that the House of Representatives transmitted the articles of impeachment to the Senate without a plenary vote. The ABS-CBN statement, Mr. President, calls into question the factual premises of the SC decision. Isa po ito sa binabanggit na numerous factual errors. If the very factual premises were wrong, the legal conclusion cannot be relied upon. With due respect, salamat po, Mr. President.
Majority Floor Leader.
Yes, Mr. President, last but not the least is a quick manifestation from the distinguished gentleman from Palawan, Senator Erwin Tulfo. I move that he be recognized, Mr. President.
Senator Erwin Tulfo is recognized. You may proceed, sir, if the gentleman will so yield.
Yes, Mr. President.
Ginoong Pangulo, bilang bagong senador, ako po ay nais ko pong maliwanagan dahil kanina pa po ako nagugulamihanan sa mga pangyayari. Dahil 3 motion po ang nakasala ngayon motion to dismiss, motion to table, motion to archive. Yung pagkaintindi ko po ngayong araw, dalawa lang po ang ating pagdidesisyonan. Kung tayo ay i-dismiss na natin ito, o tayo po ay magkakaroon ng trial. At nag-aantay po ang taong bayan. At lumalalim na po ang gabi. Kaya ang tanong ko po ngayon, are we actually going to vote later or sa ilang saglit? At ano po ang ating pagbobotohan, Ginoong Pangulo? Yan lamang po.
To answer the query of the good gentleman, there are only two pending motions. The motion to table by the distinguished minority floor leader, which has precedence over the earlier motion of Senator Marcoleta, supposedly to dismiss, but that he acceded to amend it accordingly, and he will state the motion before we put it to a vote after we dispose of the motion of the minority floor leader to table. So dalawa lang po yung pagbobotohan at dahil sabi ng kagalang-galang ng puno mayoriya na kayo na po yung huling magmamanifest, tutungo na po tayo doon.
Maraming salamat po.
With that, Mr. President, and no member wishes to interpellate. The minority leader is also seeking the floor. I move that
The
he be
minority
recognized,
leader
Mr.
is
President.
recognized. What is your pleasure, sir?
Thank you, Mr. President. Just one last push, so to speak.
The gentleman may proceed.
We're not saying that we defy the Supreme Court decision. We're simply saying, wait. Patience is a virtue. Yung analogy kasi na sa panliligaw, dismiss mo na kagad. Although merong mga matintimang birheng bumigay. Mas magandang analogy ito, Mr. President. In a basketball game, crucial, finals, world championship, merong review ng foul ang referee. Review muna. Dahil may foul eh. Ang gusto ng isang team, maglaro pa rin kahit nire-review. It's as simple as that. So, why not listen to the possibility of not dismissing but not accepting to table. And then we can bring it out anytime. Again, dun sa sinasabing Supreme Court has never considered a unanimous. It has. And the Supreme Court also spoke. Sabi nila, the immediately executory, they are not considered final until the lapse of the prescribed period without a so and so. Supreme Court din mismo may sabi niyan eh. Yun lamang po. Hopefully, kung speculation ang pinag-uusapan natin, stating that the Supreme Court will not reverse its unanimous decision is also speculative. So, pagbigyan natin to, Mr. President, sunod tayo, pero ilagay naman natin sa lugar. Medyo, ang Senado naman dapat itaas natin ang integridad, reputasyon. Hindi tayo, pag sinabing tumalon, tatalon. Pakinggan naman natin muna dahil maraming mali eh. Maraming error ang House, may error din yung Supreme Court decision, obviously. So you cannot right a wrong by another wrong. Thank you, Mr. President.
Noted. Senator Allen.
Mr. President.
Mr. President. Mr. President.
Yes, Mr. President.
So, I'm discussing with the minority leader, trying to pursue a wording that will articulate our collective intent of the Senate. May I just mention and have a few, maybe 2 minutes with what Senator Risa, the esteemed senator, said. Yung spirit kasi ng Constitution, once ka lang pwede ma-impeach sa 1 taon. At very clear po, pati po yung esteemed, I do recognize our the former chairman of the COMELEC who, if he did not qualify me, I would not have become a councilor. Christian Munsod, our esteemed legal luminaries are here po. Alam niyo po, in all the books nakalagay doon, bakit may 1-year ban? Kasi nga, hindi daw dapat guluhin ng guluhin yung impeachable officer all throughout the year. Dapat isa lang. So yung spirit ng decision, nung sinabi ng BARD na, bigyan mo siya hanggang 1 year, hanggang February 6. Pero lumabas tayo sa legal. Ipa-floating muna natin to. I-dribble muna natin, tignan muna natin. When is the soonest that the Supreme Court can decide? The next 15, 30 days? By September 1, simula na ng budget hearing sa House. By late September, simula na tayo sa Senate. Baha, DepEd, gamot, trabaho, lahat yan, inaasikaso natin. Kung walang choice at isasabay natin impeachment hapon, impeachment umaga, legislation, bakit hindi? Pero hindi ba dapat bigyan din natin ng katahimikan yung ating bansa at least until February 6? Na sinabi na ng Supreme Court, barred, mali ang proseso, tuldukan na rin natin sa Senado. So, ang isa na lang po ang pinag-uusapan natin, which I want to give honor and thank the minority leader na, pero may appeal. So, whether or not the Senate says tuldukan na natin, nandun pa rin sa Supreme Court yung appeal. Would it be acceptable both to Senator Marcoleta and to the minority? What if we word the motion that we move to adhere to the decision of the Supreme Court in Duterte versus period? Huwag na natin ilagay sa dulo kung dismiss, area. Merely adhering. Kasi nasa decision naman, nasa loob na naman decision na void ab initio and executory right away. So I don't know if that's acceptable. No? I'm trying to think of a word. Adhere, even obey kasi baka ma-misinterpret na because some of us say na wala tayong choice to obey, some think na wag tayo subservient, di ba? But adhere might be a good word. Senator Marcoleta, are we getting closer or medyo lumayo?
I think, Mr. President, we're getting closer, except that we should put some operative words there that would indicate the closure of this very issue.
Mr. President, what if it's we move to for the Senate to adhere to the Senate to the Supreme Court decision in Duterte versus House of Representatives and hereby terminate whatever unless or until certain time na may. Mr. President, may I ask the good sponsor, can we mention the appeal?
I don't think so, Mr. President. Yes. I think we can only
because
adhere.
It's immediately executory.
I think in obedience to the decision of the Supreme Court, the Senate adheres to it and put to rest.
Let me put it another way, Mr. President. If a motion is approved to act upon the decision and to adhere to the decision, am I correct, Mr. President, that that will be the decision, that will be in our journal, and then by operation of administrative process in the Senate, everything that has to do with the impeachment will be sent to the archives?
That is correct, Your Honor. That is the
I yield to
administrative procedure
Yes.
that will logically follow.
I yield to my colleagues, Mr. President. I'm just trying to
Senator
come up
Zubiri
with a
is
consensus.
Mr. President, I think the operative word today, if we do decide to act on the matters, to archive, as the precedents with former Ombudsman Gutierrez and former Chief Justice Davide. My question is,
former President Estrada.
former President Estrada, my apologies. Today, one of our Senate resolutions was archived. This is resolution number 35. And it's really simple, a simple amendment to the rules. But my question, Mr. President, is nothing can stop us from pulling it out of the archives and taking it
over once again in plenary. Is that correct, Mr. President?
That is correct, Your Honor. Besides, although the Supreme Court said that the Senate never acquired jurisdiction and that the articles of impeachment are void, null and void ab initio from the beginning, we cannot deny the fact that the articles of impeachment were in fact sent to the Senate, that the Senate convened and sent out certain orders and summons, and these are all part of the records. So it's but natural, although it was declared unconstitutional and that the Senate never acquired jurisdiction, for us to still include that as part of the records of the Senate, because it is part of the Senate's history.
Yes, and precedence tells us that we have done so in the past.
That is correct, Your Honor.
So, would it be proper to say that it will be archived without prejudice to the decision from the final decision of the Supreme Court from the motion for reconsideration? I mean, it's the same thing, without prejudice. We do that with the bills. We approve it on second reading without prejudice, but each and every one of us here questioning second reading approval, they have 3 days in which we can act upon it.
Well, Your Honor, whether you state that or not, we can bring it out of the archives by a majority vote anyway. So it's at the
Yes.
pleasure. It's with the pleasure of the body if
Yes.
the body will agree to include that phrase or not. But
Thank you
in
for the
relation to
clarity,
Senator
Mr. President.
Cayetano's suggestion, Senator Marcoleta, if we simply vote in your case, not the motion to table, to adhere, once that decision becomes final, meaning to say after the lapse of the period for a member who voted with the winning side, on the winning side, to seek a reconsideration, the natural effect, without being included in your motion today, would be to archive it. And by virtue of the manifestation of former Senate President Zubiri, if circumstances change, nothing prevents the body, plenary, from making the corresponding motion, putting it to a vote, and reflect the change in circumstances, if any.
That will be acceptable, Mr. President.
Thank you, Your Honor. Senator Soto?
Mr. President, somehow parallel to what you're discussing, perhaps we could consider, no, and I would like to call the attention of the original proponent of this position, Senator Alan Cayetano, who was former Speaker of the House, to adhere to the Supreme Court decision upon its final disposition. In meantime, table or archive upon whatever your pleasure would be. At least, maliwanag sa atin na upon its final disposition, na may motion for reconsideration, we're still giving that chance of a motion for reconsideration.
If I may, Your Honor, if you will indulge me. If I may state the working motion, to adhere to the July 25, 2025 decision of the Supreme Court declaring the articles of impeachment null and void ab initio, and that the Senate did not acquire jurisdiction over the same. We can stop there. And then, as I said, after the vote becomes final, on Monday or Tuesday, if no one will seek a reconsideration, to archive it. If there is no change, then it remains in the archives and nothing needs to be done. If the Supreme Court reverses itself, however possible or impossible that may be, then we will entertain a motion to bring it out of the archives. Bring it out of the archives and act accordingly again in obedience to the Supreme Court decision. So,
ang problema, Mr. President, when we say that the Senate has not acquired jurisdiction, ayon tayo sa sinasabi ng Supreme Court decision nilang ito, na maraming nagsasabi na hindi tama. Dahil tinawag nyo to ng June 9 nag-oath ang Senate President. Nag-oath yung iba ng June 10, nag-motion, nag-robe pa nga Hindi naman pwedeng pampelikula lang yun, pan-TV lang yung robe na yun. You convened So hindi pwedeng sabihin ng Supreme Court that you never acquired jurisdiction. February 5, 4:15 p.m., the Senate President's Office and the Senate Secretariat received the articles of impeachment.
I'm sorry, Minority Leader. Legally, when you say the Senate never acquired jurisdiction, it does not deny the fact that we convened. That is a totally different matter. It says that since the articles of impeachment violated the one-year ban, that we never supposedly acquired jurisdiction. Not that we never did when it was not yet barred by the Supreme Court. That factual situation still exists and is part of our records. As I said, that's why the better alternative is to archive it, because it was part of what actually happened, transpired, and it's part of the Senate's history. But having said that, without belaboring the point, if agreement cannot be reached, then we can proceed to dispose of the motion of Senator Soto, our distinguished Minority Floor Leader, to lay the motion of Senator Marcoleta on the table, and depending on the outcome of that vote, should it not be favorable to the movant, then we proceed to act on the motion of Senator Marcoleta. If it is favorable to the movant, the distinguished Minority Floor Leader, then there is no need to proceed with the motion of Senator Marcoleta. Senator Lacson.
Mr. President, we have to determine first if Senator Marcoleta has legal standing in filing his motion to dismiss.
He will amend this motion later. We will first decide on the motion.
So there's amendment to the motion.
Yes, and then let's hear his motion, Your Honor.
Yes. Mr. President, the lady from Antique is seeking the floor. I move the TB.
Senator Legarda is recognized. What is your pleasure, ma'am?
Thank you, Mr. President. It's been 3 hours and a half with the very enlightening discussions. I just wanted to clarify, and actually, may I convey that there is a sliver of a difference between the two motions, so I wanted to be clarified. The original motion to dismiss, I believe, has been amended based on the discussions to the motion to archive.
Yes.
And the motion to archive, in my understanding, based on all the explanations, would be without prejudice to the reopening of the possibility after the Supreme Court conveys its ruling on the motion for reconsideration.
Yes.
And therefore, in the possibility of the event that it reverses itself, then we would act accordingly.
That is correct.
On the other hand, there is a motion which takes precedence, and that has been the motion of the Minority Leader to lay on the table the motion. But when you see and interpret the amended motion of the original movement, Senator Marcoleta, and the Minority Leader's motion, it's similar because it lays on the table, or it somehow just postpones indefinitely until such time that the Supreme Court has decided on the motion for reconsideration. Is there any possibility that
May I
we can
explain the
agree so that we can amend it so that the body can actually vote as one? Because we are not putting it to a permanent halt, because we will be waiting anyway for the motion for reconsideration by the Supreme Court.
Yes, Mr.
The
President,
ruling on that.
may I have
Yes.
1 minute to explain the difference?
I know that there is,
Yeah.
let me state, I know there is a difference. I was just trying to bridge
Yes.
the difference so that there is no need for a painful vote.
Yes, I will just explain the
yes.
difference so that we know.
Senator Cayetano is
Yes.
recognized with the permission
Yes.
of Senator Intulfo.
Thank you. Mr. President, the reason why I want to explain the difference, para malaman natin bakit malapit pero malayo.
Yes, okay.
Because when you laid it on the table, ang ibig sabihin niyan, buhay pa yung impeachment. Samantalang sinabi ng Supreme Court, immediately executory. So pag lay on the table, buhay pa yan, pero mamamatay yan paglabas ng MR. Pag in-archive mo, baliktad. Patay na yan. Kasi sinabi na ng Supreme Court, immediately executory.
Void ab initio.
Pero mabubuhay yan pag binuhay ng Supreme Court. Now, ang ibinigay na po ni Senator Marcoleta sa atin, pumayag na siyang tanggalin yung word na dismiss. Because nga, even I question, we're going to dismiss, wala nga jurisdiction. Although there's a Supreme Court ruling saying na pag wala ka na magawa, walang jurisdiction, i-dismiss. So the proposal, which is accepted by Senator Marcoleta, is that we adhere to the decision and then archive it. So ang natural effect nun, sinunod natin yung Supreme Court na immediately executory. Wala tayong, we cannot say na tama to, malito, malito. You only have two choices. Do you follow the Supreme Court or you don't follow? You cannot say tama to, malito. Diba? So that's the, I think that's the level of disagreement.
Okay, I
Mr.
take
Chair.
note of that, and I was trying to have a unanimous vote and trying to bridge the two motions, which, based on Rule 31, there is actually no motion to archive, but actually every day we archive in our referral. So because of that practice, then that motion is therefore acceptable. Having said that, Mr. President, let me just summarize what we are voting on. We're actually, and I will just say it, the very, very short dispositive portion of the Supreme Court decision. And this is the article, and I quote it, the articles of impeachment are declared barred by Article 11, Section 3, Paragraph 5 of the Constitution. Likewise, they are unconstitutional and are deemed null and void ab initio. Consequently, the Senate did not acquire jurisdiction to constitute itself into an impeachment court, and this decision is immediately executory. I just wanted to summarize what we've been discussing for 3.5 hours. And while my attempt to bridge the two similarly worded motions did not succeed, then we will therefore have to put it into a vote. Thank you, Mr.
Majority
Thank
Floor
you,
Leader.
Mr. President. Mr. President, I think we heard enough, and I think it's about time that we dispose the motion of our distinguished minority
President,
leader
Mr.
to lay
President.
this on the table, Mr. President. So
Parliamentary
I move
inquiry.
for the previous
Parliamentary
motion.
inquiry, Mr. President.
What
Mr.
is
President, Senator Aquino is seeking the floor.
What is the parliamentary inquiry of Senator Aquino?
Mr. President, may I get, earlier Senator Cayetano talked about the differences between a motion to table and motion to archive. May I get an official response, Mr. President? Is that really the difference?
Your Honor, we have not yet heard the motion of Senator Marcoleta.
No, Mr. President, a motion to archive and a motion to table, for us laymen, it sounds similar. Sa totoo lang, Mr. President. Anong pinagkaiba niya, Mr. President?
Senator Aquino,
I mean,
what Senator Soto, that's why I prefer that we act on the motion. What Senator Soto is seeking to table is not the articles of impeachment nor the impeachment case, but the motion of Senator Marcoleta, which we haven't heard.
Okay.
So, when we decide on the motion to table, the motion of Senator Marcoleta, not the articles of impeachment.
Yes. And the motion to archive are the articles of impeachment, Mr. President.
Yes.
Yun yung pinagkaiba niya.
Yes, ma'am.
Thank you, Mr. President.
Senator Soto?
My motion to table was to table the motion of Senator Marcoleta.
yes.
The
That's
motion
exactly
to
what I said,
dismiss.
Your Honor.
Yes.
No,
That's exactly what I said.
that is
That
not,
the motion to table pertains to the motion of Senator Marcoleta,
to dismiss.
not
Correct.
the articles of
new one.
impeachment.
Articles.
The motion of Senator Marcoleta, if at all, would pertain to the articles of impeachment and/or the impeachment case.
And if I may add, Mr. President.
Senator Pangilinan?
Well, the motion to archive.
Senator Pangilinan, we're not yet there.
Well, okay, the motion to table, the motion, then frees us from the debate of whether or not we have the power as a Senate in plenary to address the impeachment complaint.
The chair said that earlier.
Yes, and therefore.
We will first
Okay.
put to a vote the motion to table of our distinguished minority floor leader, which under our rules has precedence over the motion of Senator Marcoleta, although made earlier. Depending on the outcome of that vote, then we will act on the motion of Senator Marcoleta accordingly. Senator Estrada.
Mr. President, we have been listening to all the manifestations of almost all senators who stood up. Mr. President, it has been 4 hours listening to several manifestations of our colleagues, and it is about time that we decide right away the pending motions before us. Mr. President, the Filipino people are watching. The Filipino people are listening. The Senate has to act, and the Senate has to act decisively. Thank you, Mr. President.
Thank you, Mr. President. I move for the previous motion, Mr. President. On the motion of the Minority Leader, Senator Tito Soto, to lay on the table the motion of Senator Rodante Marcoleta.
Is there any objection to the motion of the Majority Leader for the Senate? What is the pleasure of the Minority Floor Leader?
Mr. President, I move for a nominal vote.
The chair has every intention of doing that, Your Honor. There is a motion to vote on the motion of Senator Soto to lay on the table the motion of Senator Marcoleta pertaining to the articles of impeachment vis-a-vis and in light of the Supreme Court decision of July 25, 2025. To explain, a yes, affirmative, or aye vote supports the motion of the Honorable Minority Leader, and it therefore means that we will not act on the motion of Senator Marcoleta today. A nay vote, a no vote, means that the motion of Senator Marcoleta will not be laid on the table and that we will act and vote upon it today. Senator Lacson? Later on, we'll know the amendment. Senator Lacson, so that it's on the record, please.
So you're only referring, Mr. President, to the motion to dismiss? No, motion to table. Just the motion to table.
Just the motion to table, Your Honor, because we are not yet there. There being no objection, the motion is of the... Yes, Senator Zubiri.
Yes, Mr. President, being a former Senate President and being former Majority Leader, I'd like to ask the audience to restrain from commenting or laughing, please. Well, we are in a, for me, it's a sacred place. It is in the August chamber of the Senate that we have decorum. May we ask for decorum from those who are watching within the plenary, Mr. President.
Actually, they have been silent for the past 3.5 hours. Chair would like to remind the people in the gallery to kindly respect the processes and procedures of the Senate and to avoid any claps, any jeering or comments so that we can proceed with roll call vote.
Yes, with due respect, because I heard a lot of laughing after the poor gentleman from our good friend, Senator Lacson, asked only for a clarification of the vote that will happen in a few seconds.
The Sergeant at Arms is so directed.
Just proper decorum, because this is a very important vote, and it's a very serious vote that will be taking place. Thank you.
The Sergeant at Arms is so directed to kindly maintain order in the gallery. Acting now on the motion of the Majority Leader for us to divide the House and vote on the motion to lay on the table, Secretary is directed to call the roll for nominal voting.
Roll call vote. The Honorable Senator Aquino. Senator Cayetano Alan. Senator Cayetano Pia. Senator De La Rosa. Senator Ejercito. Senator Estrada. Senator Gatchalian. Senator Go. Senator Ontiveros. Senator Lacson. Senator Lapid. Senator Legarda. Senator Marcoleta. Senator Marcos. Senator Padilla. Senator Pangilinan. Senator Soto.
May I register my vote, Mr. President?
The Minority Leader may proceed.
Thank you. Mr. President, the Supreme Court decision is now pending appeal. It is prudent to wait for the results rather than prematurely archiving, if not dismissing, because I know for a fact, once it is archived, it is dead. So what happens if the Supreme Court reverses itself? Clear and blatant errors are present in the ruling of the Supreme Court. First, they misunderstood the legislative process in assuming that the 19th Congress adjourned sine die in February 5. Grave error. Thus effectively dismissing the first three complaints
paving the way for them to say na ano pala, yung 1-year ban binayolate. The archiving of the 3 complaints were done after the initiation of the 4th complaint. The 1-year ban did not set in. Second, the decision practically amended the clear mandate by the Constitution by placing a hierarchy on the modes to initiate an impeachment complaint. Parang wala na yung third option. Third, the Supreme Court retroactively applied the new definition to the present case in the violation of the doctrine of operative facts, thus voiding as well the impeachment proceedings of former President Estrada and Chief Justice Corona. They did not interpret the Constitution, Mr. President. They amended the Constitution. So lastly, the Supreme Court now has the chance to rectify these errors in its decision. So I was hoping to table the motion so that we can let us afford them this opportunity for the benefit of future impeachment processes and to uphold the clear mandate of the 1987 Constitution. All we needed to do was wait a little. And so I will have to register a yes vote. I know it will be a vote in the minority, but I have always voted in the minority in many issues in the Senate since 1992 up to the present. Always prayed I was wrong. Unfortunately, I was always right. My God, have mercy on your decision. I vote yes.
Noted. Secretary will please continue.
Senator Tulfo Erwin, Senator Tulfo Rafi, Senator Villanueva, Senator Villar Camil, Senator Villar Mark, Senator Zubiri, Senate President Escudero.
No.
Pwedeng mag-explain ng boto.
Before the explanations of vote, Chair would first like to make of record the result. With 5 affirmative votes, 19 negative votes, the motion to table the motion of Senator Marcoleta is lost. Lost. Soto. Sorry, Senator Soto is lost. No, he said the motion to table the motion of Senator Marcoleta is lost.
Yes.
Pati tuloy ako, nalito dito siya.
Mr. President,
Senator Villanueva.
if I may, Mr. President, and to go back to the first motion raised by Senator Marcoleta, if I may be allowed, Mr. President, to amend, Mr. President, the motion, Mr. President.
The gentleman may proceed with the permission of Senator Marcoleta.
Mr. President, adhering to the immediately executory decision rendered by the Supreme Court en banc on 25 of July 2025, which held, among others, the articles of impeachment are null and void ab initio, and that the Senate did not acquire jurisdiction over the same, I move to transfer the articles of impeachment in relation to case number 002-2011 entitled in the matter of the impeachment trial of Vice President Sara Zimmerman Duterte to the archives. I so move, Mr. President.
What does Senator Marcoleta say?
I accept, Mr. President.
There is a motion as enunciated by the minority floor leader. What is the pleasure of Senator Zubiri?
Yes, thank you, Mr. President. Mr. President, instead of a viva voce vote on that motion, may we be allowed to manifest our votes with a short manifestation, Mr. President, each and every one of us.
This,
Yeah, through nominal voting, Mr. President, with the permission of the body, of course.
no, I think, Senator Soto, the motion of Senator Zubiri is to conduct nominal voting and allow the members to explain their votes after casting their vote, not after everyone has voted. I think that is the tenor of the motion of Senator Zubiri.
Correct.
Ang binobotohan muna natin, amendment mo di ba? Tinanggap niya.
Hindi, yung motion na.
Tinanggap niya. So, Mr. President, the Majority Leader, Senator Marcoleta accepted the amendment of the Majority Leader. So, what are we voting on now? May we now
The motion
hear-
as amended
Yes,
by
a motion
Senator
as amended.
Villanueva.
May we hear the motion as amended, please?
May the gentleman,
Yes.
the distinguished majority leader,
Yes,
kindly
Mr.
state
President.
once again for the record and benefit of our colleagues, the motion as duly accepted by Senator Marcoleta.
Thank you, Mr. President. Adhering to the immediately executory decision rendered by the Supreme Court en banc on 25th July 2025, which held, among others, that the articles of impeachment are null and void ab initio and that the Senate did not acquire jurisdiction over the same, I move to transfer the articles of impeachment in relation to case number 002-2011 entitled In the Matter of the Impeachment Trial of Vice President Sara Zimmerman Duterte to the archives. I so move, Mr. President.
May we register, would anyone from the minority or those opposing the motion would like to make of record their objection before so that we can divide the House?
Yes, Mr. President,
Yes,
I
please.
object and
Thank you.
ask for a nominal vote.
Thank you. With the understanding, Senator Soto, that it is in accordance with the request of Senator Zubiri, that upon the name is called, the explanation of vote may be made, should they so desire. There is a motion duly objected to, as stated by the minority floor leader, to place into to transfer to the archives the impeachment articles of impeachment in relation to the impeachment complaint against Vice President Sara Duterte. Secretary is directed to call the roll and proceed to nominal voting.
Roll call vote. The Honorable Senator Aquino. Senator Cayetano Alan.
Mr. President, sabi po ng preamble ng Philippine Constitution, we, the sovereign Filipino people, imploring the aid of Almighty God in order to build a just and humane society and establish a government that shall embody our ideals and aspirations, promote the common good, conserve and develop our patrimony, and secure to ourselves and our posterity the blessing of independence and democracy under the rule of law, a regime of truth, justice, freedom, love, equality, peace, do ordain and promulgate this Constitution. Nanumpa po tayo na susundin natin tong Constitution na to. Madali pong sumumpa, mahirap to pa rin. Madali pong sumumpa na susundin kung naniniwala tayo sa desisyon. Paano kung hindi tayo naniniwala sa desisyon? Paano kung ang tinatanggal ngayong hapon na to ay si President Marcos at ayaw kong maging presidente si Vice President Sara Duterte? Will I have the courage to follow the same decision? That is the test I apply to myself today. Tinignan ko po ang Supreme Court decision, solid po. Hindi nito inaalis ang kapangyarihan sa House to initiate impeachment. February 6 po, sigurado yan. In fact, before February 6, may quadcom na, magiging glorieta na yan soon. Tuloy-tuloy po yan, yung mga investigasyon na yon, kasi ganun ang politika sa Pilipinas. I hope yung sa baha, imbestigahan din. I hope yung sa corruption, sa smuggling, sa karami-rami nating utang, not only this administration, last administration, 10 administrations. We in this room are all for accountability, but tama yung Supreme Court sa tamang panahon, tamang proseso. Jeremiah 29:11 tells us, "For I know the plans I have for you, plans to prosper you and not to harm you, plans to give you hope and a future." Plano ng Diyos, pagpalain tayo. pero plano ng Diyos, durugin tayo. So, I remember this episode, I think it was in Twilight Zone, and it was also many, many times portrayed on television. What if nakilala mo si Hitler when he was 6 years old or when he was a baby, papatayin mo ba siya? I think even sa psychology or philosophy classes, tinatanong to ng mga professors, what if you had that unique opportunity, nakatabi mo si Hitler nung 6 years old siya, papatayin mo ba siya? Ang hirap sagutin nun. Of course, for us who believe that thou shall not murder, ang sagot madali. But what if you could have prevented the worst human rights violations in the world, the Holocaust? What if you could have prevented such fire of fascism that it actually swept, kung hindi ako nagkakamali, nag-Time Magazine of the Year pa si Hitler. I wonder what our answer is. But I know my answer here today. If you kill Hitler when you are 6 years old, if you justify the ends by the means, you will create more Hitlers. So if the Vice President is guilty, dapat po siya ay i-impeach. Pero sa tamang panahon at tamang proseso. Nagsalita ng Korte Suprema na mali ang proseso, mali ang panahon. But yun po, Mr. President, sana kung ano ang discussion since February 5 dito na nakatuon kay Vice President Sara Duterte, sana kung sino ang guilty sa mga baha, ganun din tayo. Hindi naman siguro si Sara ang gumawa ng mga baha. Sana po kung ano ang cause ng pagkabansot or stunting yung corruption, ganun din. Araw-araw talagang wag natin tantanan. Lastly, Mr. President, may I make an appeal to the media, our friends, the vloggers, yung iba nandito, political analysts, advocates, school deans, etc. Nakalagay kasi dito, we all agree on a regime of truth. Parati na lang ang vloggers ang nasasabihan na fake news. Alam nyo po, marami tayong political analyst ngayon, di naman sila analyst eh. Ang ibig sabihin ng analyst provides objective, non-partisan, data-driven explanation of political events, systems, and trends. Ang ibig sabihin naman ng advocate, champions a specific cause, policy, or interest group to influence public opinion and policy decisions in favor of their positions. Wala namang masama dun eh. So kung ikaw ay advocate, sabihin mo na lang. Pero mag-a-appear ka sa TV, magpapa-interview ka, sasabihin mo political analyst. Pero gusto mo lang, bata mo maging presidente, nililito mo pa ang tao eh. Ganon din po, ilan beses kami binugbog dito nung iba, na ang sabi, bawal daw ang isang senator judge na mag-move to dismiss. Pero sila din ngayon ang nagsasabi sa mga senator judge, mag-MR kayo sa Supreme Court. Saan ka kayo nakakita na hindi pwede mag-motion to dismiss? Judges dismisses cases because of no jurisdiction. Ang CA, 3 sila o 5. Hindi nyo lang nakikita sa publiko at hindi sila mag-move kasi sila lang nag-uusap. Ang Supreme Court, hindi ba dinismiss nila? Hindi ba sinabi nila no jurisdiction? Tayo kasi dito nag-usap sa hall na to. So natural, hindi naman pwedeng si Senator Batorni ay tumingin lang sa akin tapos maisip niya, dismiss. Walang manifestation dito na hindi sinasabi. My point, Mr. President, is that yung sinabi ni Mahatma Gandhi nangyayari na sa Pilipinas eh. Sabi ni Mahatma Gandhi, if it's an eye for an eye, the whole world will go blind. Let's make our stand. Ilang beses ko narinig dito sa hall na to, ang taong bayan, ang taong bayan, ang taong bayan. Hindi ba naman lahat naman tayo halal ng taong bayan eh, di ba? Hindi ba pwedeng sabihin ko na lang ang opinion ni Alang Cayetano? Isa lang naman ako eh. Ang opinion ni Joel Villanueva. Ang opinion ni Mocha Uson. Isa lang naman siya eh. Pero yung sabihin ko sa inyo, guys, ang opinion ng civil society, ang opinion ng masa, ang opinion ng taong bayan, dapat makonvict. Are we not overstepping and are we not confusing rather than enlightening our political processes? Yes, you might think this is a different Alang Cayetano from the impeachment of President Estrada, impeachment of President Arroyo, impeachment of yung hindi natuloy na impeachment kay CJ Davide, sa impeachment ni CJ Corona. But aren't we supposed to be wiser? At hindi ba tama naman yung sinabi ng Supreme Court? Dapat may impeachment pero hindi dapat gamitin ito ng magkalaban lang sa politika. Ayaw natin maging presidente si Vice President Sara, talunin nyo na lang sa 2028. Ngayon, kung talagang may ginawa siyang masama, edi impeach pero sa tamang paraan. I apologize if I'm emotional on this issue, but hindi tayo makawala eh. Ang daming mas importanteng issue, pero nakapako tayo sa issue na to. Thank you, dear colleagues, and thank you to the Filipino people for the opportunity to share my thoughts on this. So I vote for the motion of Senator Marcoleta.
Secretary will proceed.
Senator Cayetano Pia.
I vote yes, Mr. President, and I will explain my vote.
The lady may proceed.
Thank you. Why are we here today? Why do I have to cast my vote? It is because a group of citizens, including the members of the House of Representatives, exercised the right to impeach an impeachable officer. Under the Constitution, there are two ways to file a verified complaint for impeachment. Article 11, Section 3.2 by any member of the House of Representatives or by any citizen, and Article 11, Section 3.4 by one-third of all members of the House of Representatives upon a verified complaint or resolution. There were 4 impeachment complaints filed. December 2, December 4, the third on December 19th, and the 4th complaint was endorsed by 215 members of the House on February 5, the last day. On February 18, 2025, Vice President Sara Duterte filed a case with the Supreme Court to question procedural and substantive due process. Her arguments: the House of Representatives circumvented the constitutional one-year ban rule on initiating impeachment proceedings. I won't go into the details, Mr. President, but I will submit my full speech into the record. Vice President Sara's prayer was for the Supreme Court to issue a TRO as well as a writ of preliminary injunction to enjoin all respondents from proceeding with the impeachment trial. After proper proceedings, issue a final injunction, nullify and set aside the 4th impeachment complaint, declare the one-year bar to be applicable from the filing of the 1st impeachment complaint, declare the 4th impeachment complaint to be violative of the one-year bar under Section 3.5, Article 11 of the Constitution. Sa madaling salita, ang prayer po ni Vice President Duterte ay pigilan ang impeachment proceedings dito sa Senado. In the comments of the HOR, they argued the complaint is not barred for the following reasons. None of the first 3 impeachment complaints were referred to the House Committee on Justice, which effectively ended the initiation process. And 2, Petitioner Duterte is stopped from questioning the freezing of the first 3 impeachment complaints for not immediately assailing it. Ano naman ang sinabi ng Supreme Court? The Supreme Court said the articles of impeachment transmitted by the HOR to the Senate based on the 4th impeachment complaint is barred by the one-year rule under Article 11, Section 3.5. It is also constitutionally infirm and therefore null and void ab initio. Ang ibig pong sabihin, hindi na dapat ituloy pa ang impeachment proceeding na ito dahil ang impeachment complaint na isinumite ay labag sa one-year bar rule na nakasaad sa Constitution. Ang probisyong ito ay naglalagay ng limitasyon na isang impeachment complaint lamang ang maaaring maisulong sa loob ng 1 taon. Dahil sa paglabag na ito, ang impeachment complaint na ito ay itinuturing na labag sa konstitusyon at walang bisa mula sa simula o tinatawag na null and void ab initio. Mahaba po yung diskusyon ng Supreme Court dyan, makikita ho yan dun sa kaso, dun na lang ho sa isusumite ko, mababasa po doon yung ine-emphasize ko na provisions. So in final, sabi ng Supreme Court, the Senate did not acquire jurisdiction to constitute itself as an impeachment court, and this decision is immediately executory. Ano ho ba ang ibig sabihin ng immediately executory? Ibig sabihin po nito na notwithstanding the filing of a motion for reconsideration by the House, the Supreme Court's decision is immediately executory, such that the MR will not stay the decision. Katulad po ng sinabi ko kanina, dun sa press briefing ng Supreme Court, after mag-file ng motion for reconsideration ang House of Representatives, inulit pa rin ng Supreme Court na immediately executory po ito. Ano ba talaga ang karapatan ng Supreme Court na makialam dito sa impeachment case na ito? Well, ito po yung tinatawag na judicial powers ng Supreme Court. The Constitution expressly grants judicial power to our Supreme Court. Article 8, Section 1 of the Constitution provides that judicial power includes the determination of whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of government. Sinabi po dito, any branch, kasama po dyan ang Senado. Pwedeng sabihin ng Supreme Court na may grave abuse ang Senado. Pwedeng sabihin yon. Pwede niya ring sabihin sa House yon. Pwede niyang sabihin sa kahit anong branch of government. Yan po ang nakasulat sa ating Constitution. In Francisco versus House of Representatives, the Supreme Court ruled that, and the judiciary in turn, with the Supreme Court as the final arbiter, effectively checks the other departments in the exercise of its power to determine the law, and hence to declare executive and legislative acts void if violative of the Constitution. So sinabi talaga dito, possible na ang Executive Act, ang Legislative Act ay maging void. In case of conflict, the Judicial Department is the only constitutional organ which can be called upon to determine the proper allocation of powers between the several departments and among the integral or constituent units thereof. The House of Representatives urged the Supreme Court to exercise judicial restraint. Sabi ng House, hinay-hinay lang, Supreme Court, so that you can avoid encroaching upon the powers of the legislature and violating the principle of separation of powers. However, the Supreme Court in Duterte versus HREP held that there is a clear and demonstrable textual commitment in the Constitution for the court to act on any grave abuse of discretion of any branch or instrumentality of government. This includes the House of Representatives or the Senate in their exercise of their prerogatives with respect to the process of impeachment. Grave abuse of discretion from the provision does not mean actions without jurisdiction. It includes acts which originally may have been within their discretion, but subsequently the subject of a violation of a constitutional right. This is what is meant by excess of jurisdiction. This court does not decide whether and when to initiate a case of impeachment. However, the court has the power to decide how the provisions which limit the exercise are to be interpreted. On due process, numerous Supreme Court decisions expound on procedural due process in various contexts. These cases underscore the Supreme Court's enduring commitment to uphold procedural due process as a safeguard against arbitrary government action. Bakit po pumasok itong issue na due process? Kasi sinabi ng Supreme Court, hindi naman nagkaroon ng pagkakataon ang Vice President na makita ang complaint sa kanya, hindi rin nakita ang mga ebidensya. Due process exists kahit saan daw pong parte ng paggogobyerno natin. Based on the decision, in order to proceed with the impeachment proceedings, the House prosecutors must show not only a valid ground thereof, but also that procedural due process has properly been observed. As this safeguards individuals from the arbitrary exercise of government power by requiring adherence to fair procedures. As such, when there is a violation of due process as enshrined under the Constitution, the case must be dismissed. Kailangan ba ng Senado sumunod sa Korte Suprema? Sinabi ko po at uulitin ko na ang sabi ng Korte Suprema, void ab initio nga po ang kaso. Walang bisa. In Latin, void ab initio means void from the beginning. Sa umpisa pa lang, void. It indicates that something was never valid or legally effective from its inception, rather than becoming invalid at a later point in time. So sa umpisa pa lang, invalid. Hindi siya naging invalid later on, invalid siya sa umpisa pa lang. Absolutely non-existence from the very beginning. Yan ang ibig sabihin ng ab initio. Null and void. It produces no rights, imposes no duties, and affords no protection. It has no legal effect. It is, in legal contemplation, inoperative, as if it has not been passed. As such, it cannot justify an official act taken under it. Yun po ang basihan ng aking desisyon. It cannot justify an official act taken under it. Hindi ho pwede nating pasukin. Gustuhin man natin alamin. Kapareho ho ako ng napakaraming kababayan natin na gusto nating alamin kung ano ba ang mga issue na to. Pero sabi ng Supreme Court, hindi ho natin pwedeng gawin yon. We have to follow the rules. At idadagdag ko, nang sinabi nga ng Supreme Court, ay ito ay immediately executory. Again, the decision stated the Senate did not acquire jurisdiction to convene itself as an impeachment court. As such, there is no constitutional authority to even convene as an impeachment court. I am a member of the Senate and I am a lawyer. I am bound by my solemn oath. Nag-oath po tayo last week lang. Ang sabi dun sa oath, I will well and faithfully discharge to the best of my ability the duties of my position. Ginusto ko ba to? Do I want to be a judge here? Hindi po. Nung nag-aral po ako ng law, sabi ko, Lord, wag niyo akong gawing judge. I hate being a judge. Malambot po ang puso ko. Kung pwede, lahat innocent. Yun ho ang gagawin ko. Kasi napakahirap humusga ng ibang tao. But this is my solemn duty. It is my duty. I took an oath. And therefore, gustuhin ko man o hindi, I have to make a decision. And binabase ko ang aking desisyon kung ano ang sinabi ng Supreme Court. Yun naman po aming lawyer's oath. I do solemnly swear that I accept the honor, the privilege, duty, and responsibility of practicing law in the Philippines as an officer of the court in the interest of our people. I declare fealty to the Constitution of the Republic of the Philippines. Idudugtong ko yung oath na yon dun sa sinabi ng Supreme Court na kailangan sundin ang Constitution. At siya ho ang magpapaliwanag kung paano i-interpret ang Constitution. My duty as a senator and as a lawyer is to be guided by evidence, by the rule of law, and by the principles enshrined in our Constitution. For these reasons, Mr. President, I cast my vote as yes. Thank you.
Thank you, Senator Pia Cayetano. Secretary.
Senator De La Rosa.
Senator Ronald Bato de la Rosa is recognized.
Mr. President, I vote yes to the motion of Senator Marcolita, and may I be allowed to explain my vote? Thank you, Mr. President. Last June 10, a day before the 19th Congress adjourned sine die, I stood on the same spot conveying my serious concerns on the constitutional infirmities surrounding the articles of impeachment that the 19th Congress of the House of Representatives transmitted to the Senate. I pointed out that the circumstances surrounding the filing of articles of impeachment seem to violate the one-year bar rule enshrined in Article 11, Section 3, Paragraph 5 of the Constitution, among others. Given this patent violation of the Constitution, I made a motion to dismiss the articles of impeachment against Vice President Sara Duterte. After a long discussion with the members of this chamber of the 19th Congress, I listened and I learned my motion for dismissal was amended by Senator Alan Cayetano and became a motion to remand. The impeachment court then ordered the remanding of the articles of impeachment to the House of Representatives. This chamber also requires the 20th Congress House of Representatives to communicate whether or not they are willing and ready to pursue the impeachment complaint, a requirement which until now has not been complied with. In a sudden shift of events, before the opening of the 28th Congress, the Supreme Court took all by surprise when it promulgated their decision on petitions challenging the validity of the articles of impeachment against Vice President Duterte. When the Supreme Court released their decision to the media, many people expressed their views. There are those who celebrated and commended the Supreme Court. Others voiced out their disappointments. Some criticized the decision. The mixed reactions seem to suggest that the decision promulgated lacks clarity. And yet, Mr. President, after reading the decision, I ask myself, is it long? Yes, 97 pages to be exact. Is it vague? No, Mr. President, it is clear as day. According to the plain meaning rule or verbal leges, if the statute is clear, plain, and free from ambiguity, it must be given its literal meaning and applied without interpretation. Now, even though the decision of the Supreme Court is not a statute, it still forms part of the legal system of the Philippines as mandated by Article 8 of the Civil Code of the Philippines. Since the decision of the Supreme Court is clear, plain, and free from ambiguity, applying the plain meaning rule, it should be given its literal meaning. That is, the articles of impeachment are unconstitutional. The Senate did not acquire jurisdiction, and the decision is immediately executory. Plain and simple. Kaya naman, Ginoong Pangulo, nagulat ako nung ako'y tanungin, susunod po ba ako or tayo sa desisyon ng Supreme Court? Hindi po ganon kataas ang tingin ko sa aking sarili. I honestly do not place myself in a position so high, too high, that I will be the one to be asked if I will obey the Supreme Court's ruling. Ang nakasaad sa ruling na yon, immediately executory. Wala namang postscript or PS sa baba na nagsasabing subject to your review and further evaluation. As a member of the Senate and as a citizen of this republic, I submit to the authority of the Supreme Court and respect its decision. Perhaps in shedding light on the highest court's duty, the Integrated Bar of the Philippines said it best, and I quote, "As the final arbiter of constitutional questions, the Supreme Court bears the solemn duty to interpret the law, determine its bounds, and clarify its implications, even when it revisits past doctrines or addresses new contexts. This authority is rooted in checks and balances, the very design that guards against the excesses of any branch. Mr. President, the rule of law is the foundation of our democracy. And if we are to be models of upholding the law, then it behoves us to listen and heed those who have been tasked by the Constitution to interpret the Constitution. The interpretation of the law remains lodged with the Supreme Court, and we must abide by its decision. What message would we send out to our people if we, legislators, will not honor the wisdom of the highest court in the land? Are we not, in effect, promoting anarchy? I want to believe that indeed we are men and women of the law, that we live by rules and perform our mandate as elected officials within lawful means. Our people rest easy and feel a sense of security because their Senate has remained to be guardians of democracy. Looking back, the Senate has accepted several Supreme Court decisions in the past. Why should the ruling in this current impeachment case be any different? Is our concept of respect for and acceptance of Supreme Court decisions selective? If that is the case, are we not playing with fire? Fire, mind you, does not always intend to enlighten or illuminate. It can also burn and bring a house down. Much has been said about where I stand, and I understand that my positions on certain matters have always been consistent and transparent. But while the public and this chamber may be familiar with my views, all that is simply driven by what is in my heart. And I say this with humility. My heart has always been guided by what is right, not only when it is easy, not only when it is convenient, but even and especially when it challenges my comfort zone, when it no longer serves our side. Because at the end of the day, it is a matter of principle, not popularity. Perhaps sometimes We ought to protect our democracy, even from ourselves. Of course, the Senate is not a mere follower of the Supreme Court, but a co-equal branch, meant to respect the powers and functions of the latter in its decisions. I trust that the Senate will continue to peacefully coexist with the Supreme Court. Let us not allow this impeachment trial to become a venue and opportunity to disrupt our system of government. I hope this is not the time when we dance differently, when clearly the same song is playing. We must follow the Supreme Court ruling, not because it is the most convenient thing to do, but because it is what is right and just, no matter how unacceptable or painful it may be. And this is why, Mr. President, I vote yes to adhering to the Supreme Court decision. Thank you, Mr. President.
Thank you, Senator De La Rosa. Mr. Secretary.
Senator Ejercito.
Senator Ejercito is recognized.
Yes, Mr. President, I likewise vote yes to adhere to the Supreme Court.
Thank you, Senator Ejercito. Secretary.
Senator Estrada.
Senate President.
Senate President Escudero.
The Senate President is recognized to explain his vote.
Thank you, Mr. President. Distinguished colleagues, sa mga minamahal nating kababayan. For many of us, the past 2 weeks have proven to be an exasperating, mentally and emotionally exhausting experience. Both sides have fought bitterly at the electoral struggle to articulate what they respectively believe to be the correct position or view on the issues involved. Passions had run high as demonstrators, whether for or against impeachment, took to the streets armed with their familiar slogans and chants to air their voice on the matter. Various sectors of society, from business, retired military, academe, denominations of faith, offered suggestions for a return to a state of normalcy in the official relations of governmental branches. Through all these, and as early as the time when the articles of impeachment had been constituted, the court was specifically asked, told, urged, and argued to take no action of any kind and form with respect to the prosecution by the House of Representatives of the impeachment complaint. When the present petitions were knocking, so to speak, at the doorsteps of the court, the same clamor for non-interference was made through what are now arguments of lack of jurisdiction, non-justiciability, and judicial self-restraint, aimed at halting the court from any move that may have a bearing on the impeachment proceedings. The court did not heed the call to adopt a hands-off stance as far as the question of constitutionality of initiating the impeachment complaint is concerned. What lies in here, is an issue of genuine constitutional material which only the court can properly and competently address and adjudicate in accordance with clear-cut allocation of powers under our system. The claim, therefore, that the court, by judicially entangling itself with the process of impeachment, has effectively set up a regime of judicial supremacy is patently without basis in fact and in law, because it is not at all the business of the court to assert dominance, judicial dominance, over the other two great branches of government. Rather, the raison d'etre of the judiciary is to complement the discharge by the executive and legislative of their own powers to bring about ultimately the beneficent effects of having founded and ordered our society upon the rule of law. Mr. President, distinguished colleagues, the institution that is the Supreme Court, together with all other courts, has long held and been entrusted with the judicial power to resolve conflicting legal rights regardless of the personalities involved in their suits or actions. The court has dispensed justice over the course of time, unaffected by whomsoever stood to benefit or suffer therefrom, unafraid by whatever imputations or speculations could be made to it, so long as it rendered judgment according to the law and the facts. No one is above the law or the Constitution. This is a basic precept in any legal system which recognizes equality of all men before the law as essential to the law's moral authority and that of his agents to secure respect for and obedience to its commands. Perhaps there is no other government branch or instrumentality that is most zealous in protecting that principle of legal equality other than the Supreme Court, which has discerned in its meaning and ramifications through its application of numerous cases, especially the high-profile kind in the annals of jurisprudence. The Filipino nation and its democratic institutions have no doubt been put to a test once again by this impeachment case. Accordingly, the court resorted to no other than the Constitution in search for a solution to what many feared would ripen to a crisis in government. Sa muli, magandang gabi po sa ating lahat. Hindi ko po salita ang mga sinambit ko na ilang minuto. Yun po ay paraphrase at halos eksaktong quotation ng salita ni dating Justice Conchita Carpio Morales sa Francisco ruling na kinatigan ng mayoriya ng mga miyembro ng Korte Suprema, kabilang na si dating Chief Justice Puno, dating Justice Carpio, dating Justice Ascuna, dating Justice Panganiban. Ano nga ba itong Francisco ruling na pinag-uusapan natin ito? Ano nga ba ang pinagkapareho, pinagkaiba nito sa kasalukuyan nating hinaharap? At bakit ko ba ito tinatanong? Ginoong Pangulo, bahagi ako ng Kongresong nagtangka na i-impeach si dating Chief Justice Davide. Bakit ko sinabing tangka? Dahil pinigilan po kami ng Korte Suprema. In-enjoin at nag-issue ng TRO ang Korte Suprema at ito yung desisyong yun. Francisco, case na palaging sinasite po natin. Ano bang pinagkapareho? Ang aligasyon laban sa nasasakdal noon na si Chief Justice Davide, kaugnay din ng corruption. Daang milyon din. Ang pinag-usapan, initiation of impeachment, na dapat sole prerogative din ng Kamara. Ang pinag-usapan, ano bang definisyon ng initiation na dapat sole jurisdiction din ng Kamara? Ang tanong ko po ay simple. Noong mga panahong yun, nasaan po lahat na nagrereklamo ngayon at nagko-question sa desisyon ng Korte Suprema? Yung mga mahistradong nagko-question ngayon na retirado na, bumoto sila pabor doon. Subalit ngayon, tila nag-iba ang posisyon. Ano nga ba ang pinagkaiba kung meron man? Klaro ang pinagkaiba. Iba ang pangalan ng nasasakdal. Today, Mr. President, distinguished colleagues, the very supremacy of the Supreme Court is being called into question, and with it, the very foundation of the rule of law. As Senate President and as a member of this chamber and as a member of the bar, I will not sit idly by and allow this. At stake is the very idea that justice should be governed by laws that apply to all, equally to all, rather than the whims and caprices of public opinion. As Justice Frankfurter once said, if one man can be allowed to determine for himself what is law, every man can. That means first chaos, then tyranny. Legal process is an essential part of democratic process. Whether it's a mob or a minority, bias and prejudice blinds, divides, and destroys. Former U.S. Supreme Court Justice Sandra Day O'Connor also said it best. The law provides necessary continuity amidst our constantly shifting political landscape. It guarantees everyone will be treated equally, whether they are in today's or yesterday's majority, so they know what to expect, whether what they do is popular or unpopular at that time. The courts, Mr. President, with the Supreme Court at the helm, are the guardians of the rule of law, making sure everyone plays by the same rules and receives equal justice. For the rule of law to prevail, the High Court must act as a compass, not as a political cheerleader, impartially applying the law by calling out violations, not swayed by public opinion or political allegiance. Respect for the rule of law, Mr. President, requires all of us to adhere to final or immediately executory decisions of the court, even when there is a winner and a loser, to avoid deadlocks and maintain legal order. Respect for the rule of law does not bar disagreeing with court decisions, nor from forming our own opinions on the meaning and intent and letter of the spirit of the Constitution. However, we must also have the humility to accept when we are wrong once the Supreme Court has already decided. Respecting the court only when you win or when it aligns with your belief is not respect for me. It is plain arrogance, or if at all, a power play. Cherry-picking court rulings destroys the judiciary's purpose. Disobeying the High Court's decision is a violation of the law because under our Constitution, decisions of the Supreme Court form part of the law of the land. I made these remarks, Mr. President, amidst recent calls for this august body to disregard the Supreme Court's recent ruling in Duterte v. HOR. These calls for judicial disobedience have been aided and abetted by so-called legal luminaries and experts who fancy their wisdom and knowledge of the Constitution as better, higher, more supreme than that of the Supreme Court. Miyembro po ba sila ng Supremist Court? Miyembro po ba sila ng Super Supreme Court? Sa pagkakaalam ko po, iisa lamang ang Korte Suprema. At ayon sa ating konstitusyon, Korte Suprema ang bukod tanging pwedeng makapagsabi kung ano ang kahulugan ng ating saligang batas. Walang iba. Allow me to demonstrate, for example, Mr. President, the legal gymnastics these people have been undertaking. In the past, and I have borne the brunt of this, sabi nila, forthwith ang sinabi sa Senado, ibig sabihin yan agad-agad. Despite the rulings of the Supreme Court that say it is within a reasonable time. Pero doon na tayo sa agad-agad. Sabi ng rules ng House, dapat i-refer ng SecGen immediately sa Speaker. 2 buwan bago niya ginawa yon. Oh, okay lang sa kanila. Hindi naman sila nagreklamo. Immediately po ang gamit, ha? Hindi forthwith. Sabi naman ngayon ng Korte Suprema, immediately executory. Ay, teka lang. Hintayin muna natin. Hindi ba final? Kapag ka-convenienteng gamitin yung mga salita pabor sa posisyon nila, edi okay lang. Kapag ka hindi naman, ay hindi rin. Hindi po ganun dapat yon. Hinihiling nila ngayon sa Senado na ipagpaliban muna ang anumang aksyon para intayin ang anumang desisyon ito kaugnay sa motion for reconsideration na inihain ng Kamara sa Korte Suprema. Subalit tulad ng naipaliwanag na kanina kaugnay ng motion na pinagbobotohan natin ngayon, kung magbago man ang Korte Suprema sa kanilang desisyon na unanimous noong July 25, 2025, meron pong paraan at proseso pa ang Senado para sundin ang bagong desisyon yan ng Korte Suprema kung sakasakaling mangyayari po yan. In the past, it was also said, nauna nagsalita si Senator Bato, bawal daw at walang karapatan mag-motion ang sino mang senator judge dahil trabaho daw ng depensa yon. Eh bakit yung mga parehong tao yung pinag-uusapan? Dapat maghain tayo ng motion for reconsideration. Hindi ba trabaho din ng prosecution yon? Hindi naman po pwede na pwede lang pag kayo, hindi na pwede pag iba. Now the prosecution has actually filed a motion for reconsideration, and rightfully so, and not by this chamber. Noon kapag nung bumoto kami para i-remand ang impeachment complaint sa Kamara, pinapaboran daw namin yung nasasakdal. Sinabi ko na rin yan, na yung kontra sa impeachment at pabor sa impeachment, hindi ko didinggin. Na yung kontra at pabor kay Vice President Sara Duterte, hindi ko didinggin. Dahil may rason kung bakit babaeng nakapiring ang mata ang simbolo ng ating hustisya, na humahawak ng espada sa kabilang kamay at panimbang sa kabilang kamay. Dahil wala po dapat kinikilala ang hustisya na personalidad. Sino man ang nasasakdal, dapat pareho lamang po ang ating mga magiging desisyon. Sabi din nila, will of the people daw ito. Eh sino ba si people? Balikan po natin ang naging desisyon ng Korte Suprema. Ayon sa desisyon ng Korte Suprema sa panunulat ni Justice Malcolm sa Alejandrino versus Manuel Quezon, pinag-aaralan po ito ng mga first-year law students. Quote, the judiciary under its powers to interpret the Constitution and the laws has the duty and the right to declare what the will of the people is as expressed in the fundamental law of the land. Hence, where the acts of the executive or legislative departments violate the will of the people as expressed in the organic law of the land, it is the sworn duty of the judiciary to interpret and to declare that will of the people and the right of the citizen has been violated and or transgressed. Allow me to answer a few more, Mr. President, Your Honor. As I stated earlier, sabi ng ilan, hintayin natin na maresolbahan ang motion for reconsideration. Pero dun sa parehong araw na naghain ng motion for reconsideration ng Kamara, nagsalita ang tagapagsalita ng Korte Suprema at sinabing immediately executory pa rin ang desisyon. Sinahid ko rin kanina ang Section 1, Rule 16, AM number 10-4-20 ng Supreme Court na nagsasabi na ang resolusyon ay magiging executory lamang kapag ka ito'y nagkaroon ng entry of judgment maliban na lang kung sinabi sa desisyon na ito'y immediately executory na siyang nangyari sa kasong ito. Binanggit din kanina ni Senator Cayetano ang Section 4, Rule 39 ng Rules of Court na nagsasabi na immediately executory na mga desisyon ay hindi kailangan maghintay na maresolbahan anumang apela o motion for reconsideration na nakabinbin. Ginagamit din ang operative fact doctrine. Ang operative fact doctrine po ay exception sa rule ng null and void ab initio. Ito po ay hindi rule, ito ay exception sa rule. Gamit po ang sinulat na desisyon ni Justice Tony Carpio sa League of Cities versus Comelec. Ito ang sinabi po niya. The invocation of the operative fact doctrine is an admission that the law or act is unconstitutional. Bago po natin sabihin, gamitin natin to. Aminin niyo muna. Illegal at bawal ang ginawa ng Kamara. Sa parehong desisyon, sinabi din ni Justice Carpio, it will open the floodgates to wanton enactment of unconstitutional laws and the commission of unconstitutional acts and a mad rush for their immediate implementation before the court can declare them unconstitutional. This view, according to him, is an open invitation to serially violate the Constitution and be quick about it, lest the violation be stopped by the court. Sinabi din po ni Justice Carpio sa desisyong Aralio versus Aquino, those who acted in bad faith with gross negligence cannot invoke this doctrine. Hindi po pwedeng pakinabangan nung taong gumawa ng unconstitutional at illegal act ang doktrinang ito. Pwede lamang po itong gamitin ng mga partidong walang kinalaman dun sa ginawang mali, masama o di naaayon sa saligang batas. Ika nga, he who comes to equity must come with clean hands, and he who seeks equity must likewise do equity. Mr. President, distinguished colleagues, kinondina din ng ilang legal luminaries tulad ng Felconsa na dating pinangunahan ng nanguna sa impeachment complaint na si Speaker Romualdez, ilang taon lamang ang lumilipas, na hindi daw, bagong requirement daw ang due process. Dagdag daw ito. Mr. President, Your Honors, they should read Francisco again. They forgot that lack of due process in the impeachment process had been raised and in fact was specifically mentioned in the separate concurring opinions. And allow me to quote the concurring opinion of Justice Panganiban. The due process clause enshrined in our fundamental law is a condition sine qua non that cannot be ignored in any proceeding, administrative, judicial, or otherwise. It is deemed written into every law, rule, or contract, even though not expressly stated therein. Hence, the House rules on impeachment, insofar as they do not provide the charged official with number 1, notice, and number 2, opportunity to be heard prior to being impeached, are also unconstitutional. Needless to say, the due process limitation on the impeachment process was already discussed in Francisco. May pumalag ba nun? Wala. Yung nagre-reklamo ba ngayon kaugnay sa bagong requirement yung due process, nag-react nung sinulat ito at naging bahagi ng Francisco ruling? Hindi ko rin po napansin. Sinabi din po ng ilang legal luminary, partikular binanggit din ito ni Speaker Romualdez, when the court begins to create rules on how it and other high officials may be impeached, it risks writing the terms of its own immunity. This point was also discussed in Francisco. Ang sabi ng korte nito, illogical ito at non-sequitur. Alalahanin po natin. Hula lamang yung gagamitin din ito pabor sa kanila. Sa kaso ng Francisco, nakaupong Chief Justice ang nasasakdal. Pero sinabi mismo ng korte, hindi bali yan. Hindi namin pinapaboran ang kabaro namin sa pagbaba namin ng desisyong ito. Mr. President, the Constitution establishes a system of checks and balances, not a system of retribution. Threatening the Supreme Court with impeachment simply because one disagrees with the ruling is a dangerous assault on our constitutional order. The Senate, Mr. President, stands ready to uphold the integrity of the Constitution as well as the institutions created under it. My dear colleagues, we are told that to honor the court's ruling is to betray the truth, that by choosing fidelity to the law, we somehow abandon accountability, but nothing for me could be further from the truth. To disregard the ruling would not only defy the Constitution, it would drag the nation into a crisis it can ill afford. It would erode the authority of our laws, embolden those who believe they are above it because they know it all or simply know better. To those seeking to disregard the Supreme Court's decision, I ask these simple questions, Mr. President. Again, in light of the Francisco ruling on former Chief Justice Davide, and it was okay then because they did not want then Chief Justice Davide to be impeached. Are you truly for accountability or simply anti-Duterte? Do you truly respect and want to preserve the Constitution or you simply hate the Vice President? Are you serving the nation's interest or protecting and pursuing your own personal ambitions or agenda? Are you fighting for truth or are you simply after revenge? Do you really want a trial or do you just want a conviction? Do you really believe that we are wrong or do you simply think and feel entitled and believe that you are always right? Remove the name, Mr. President, of the Vice President in this case. Apply the decision of the High Court, as Senator Cayetano said earlier, to another impeachable official. Would our positions, would your positions be the same? When I was faced with this situation, Mr. President, I respected the court's decision, even if I disagreed with it. I am still voting to respect that court's decision. As quoted at the start of my speech, Mr. President, the dispensation of justice over the course of time should be unaffected, whomsoever stood to benefit or suffer therefrom. The courts should be unafraid of whatever imputations or speculations could be made against it by those disagreeing. I will not cast a vote that says complying with the Supreme Court ruling is optional. Anyone who will say, I will respect the Supreme Court today and condemn it tomorrow, is not showing fidelity to the Constitution. It is submission to the passions of the day, to the shifting winds of public sentiment that may or may not be just. Fidelity to the Constitution, Mr. President, must prevail even when it is unpopular, inconvenient, or misunderstood. In fact, Mr. President, distinguished colleagues, it must prevail especially when it is unpopular, when it is inconvenient, and misunderstood. Finally, Mr. President, let today's verdict be a stern and unequivocal warning to anyone who would dare use the Senate for their personal battering ram to further their personal political ambitions. To the House of Representatives, I say, do not allow yourselves to be used for the blind hatred and ambition of a few who did things haphazardly, gravely abused their discretion, and violated due process rights under the Constitution as found by the High Court itself. In spite of all these, you expect everyone to roll over in obedience. When we did not, you moved hell and high water to destroy personalities, malign reputations, and tarnish institutions. To these people, I say this: the Senate is not your playground to run after your political enemies. We are not an accomplice in any grand scheme. While others may be willing to play your game, I am not. I will never bow to a mob. I will never cower to the shrillest of voices. Let history, Mr. President, record that in this moment, We chose the Constitution. We chose the rule of law by defending the integrity of the Supreme Court and maintaining the system of checks and balances under our Republican system of government. Let this chamber be remembered, not for the passions we inflamed, but for the principles we upheld. I vote yes to the motion, Mr. President. I vote yes to the rule of law, yes to the Constitution, yes to the supremacy of the Supreme Court in interpreting it. Thank you, Mr. President.
Thank you, Senate President.
Secretary will please continue to call the roll
Senator Estrada.
for nominal voting. Senator Estrada is recognized.
Thank you, Mr. President. Mr. President, esteemed colleagues, more than 190 years ago, Justice Joseph Story warned that impeachment requires a lofty sense of duty, a deep responsibility to future times, as well as to God. His words remind us that we serve not only the present, but generations yet unborn, and that our actions must be anchored in constitutional fidelity and historical consciousness. With that solemn duty in mind, may I address the decision of our Supreme Court. Mr. President, the decision of the Supreme Court is very clear, that it left no doubt nor space for any other interpretation. Accordingly, I place on record my position in adhering to the Supreme Court's ruling, a decision that declared that the Senate did not acquire jurisdiction over the impeachment case against Vice President Sara Duterte because the complaint transmitted to us was null and void ab initio. Bakit natin ipinipilit ang isang bagay na malinaw na wala sa ating kapangyarihan? Nagsalita na po ang Korte Suprema. Hindi saklaw at walang jurisdiksyon ang Senado. Tapos na ang usapin. Patay na ang kaso. Mr. President, we must never forget that the Supreme Court is the final interpreter of our Constitution. It is not merely one of three co-equal branches. It is the guardian of the rule of law. If we, the very makers of law, choose to defy its authoritative interpretation, then we commit an unforgivable assault on our democratic institutions, and we undoubtedly invite a constitutional crisis, a breakdown of checks and balances where anarchy replaces order and chaos becomes the norm. Mr. President, let us be clear. No one is above the law. Not the President, not the Vice President, not even the Senate when it sits as an impeachment court. The Constitution is not just an ordinary law. It is the supreme law of the land. And if we betray to serve political passions or popular sentiment, then we betray the Republic itself. The Integrated Bar of the Philippines, in a statement, said that defying the High Court's ruling would, in effect, erode the very foundations of the legal order. And I agree with this, Mr. President. At the expense of sounding like a broken record, I would like to say again that the Supreme Court is the final interpreter of our Constitution. Tagapagpaliwanag ang Korte Suprema ng saligang batas. At kapag may hindi pagkakaintindihan kung paano dapat ipatupad, unawain ang batas, kabilang ang proseso ng impeachment, ang interpretasyon ng kataas-taasang hukuman ang siyang mananaig. Kaya naman, kapag nagsalita na ang Korte Suprema, dapat itong igalang at sundin ng lahat. Ginoong Pangulo, batid natin na isang mahalagang mekanismo ang impeachment upang mapanagot ang pinakamatataas na opisyal ng pamahalaan na lumalabag o umaabuso sa kanilang posisyon at kapangyarihan. Sa ilalim din ng mekanismong ito, ay may pagkakataon para may pagtanggol ang kanilang sarili. Kaya naman dapat na magamit at maisagawa ng tama ang proseso at masiguro na ang mga naatasan ng saligang batas na magsagawa nito, ang House of Representatives at ang Senado, ay tumupad sa kanilang tungkulin ng may integridad at walang pagmamalabis sa kapangyarihang ipinagkaloob sa kanila. Hindi na sana dapat maulit ang pagkakamaling nasaksihan natin mahigit 2 dekada na ang nakalipas sa kaso ng aking ama, si dating Pangulong Joseph Estrada. Kung inyong natatandaan, noong impeachment trial ng aking ama, pinagkaitan siya ng pagkakataon harapin ang mga paratang sa kanya dahil pinairal ang pansariling interes at hindi tumalima sa kanilang tungkulin ang mga prosecutors mula sa mababang kapulungan sapagkat nag-walk out po sila. Nakakadismaya, Ginoong Pangulo, na ganyan din ang nangyayari ngayon. Muli na naman nananaig ang pansariling interes. Matinding emosyon at inunang pamumulitika dahilan upang humantong tayo sa sitwasyong sinabi ng Korte Suprema na may malinaw na paglabag sa ating saligang batas. Had we decided to ignore the Supreme Court ruling and proceeded with the impeachment trial, we risk undermining the judiciary's role as the final arbiter of constitutional issues, and this will definitely create a dangerous precedent where future legislatures could just bypass court rulings they deem unwarranted. Mr. President, my dear colleagues, there should be a balance of power among the 3 branches of government, and this representation does not wish the Senate to be in a direct collision course with the Supreme Court amid calls for us to proceed with the trial. I refuse to be a part of the Senate. I refuse to be part of a Senate that defies the law, disrespects the courts, and undermines the very system of justice we claim to uphold. To my colleagues who insist on pressing forward, I ask these questions. If we cannot obey the law, do we still deserve to be called lawmakers? If we cannot respect the Constitution, do we still deserve the privilege of serving in public service? At kung ang Senado ay magmamatigas at hindi tutup din ang tuntunin ng batas, hindi ba tahasang pagtalikod ito sa ating sinumpaang tungkulin? Kung hindi natin kayang igalang ang batas na tayo mismo ang nagtatanggol, hindi na po tayo nararapat dito. Mr. President, political will, however passionate or burning within us, is not always the path we should take. There are moments when even our deepest convictions must kneel before the altar of the Constitution, when our desire for action must bow to the rule of law. Our strength as senators lies not in bending institutions to our will, but in bending ourselves to the will of our constitutional framework. Our true power is revealed not when we flamboyantly get our way, but when we gracefully accept outcomes that defy our preferences. Our honor rests in respecting and embracing decisions that contradict our personal beliefs. And our legacy is a democracy that works, preserved by our willingness to submit to something greater than our feelings, our pride, our ego, our very selves. Mr. President, let history show that I chose principle over pressure, law over lawlessness, and country over partisanship. We are not shirking from our responsibility, but to fulfill our highest duty, to uphold the rule of law and to preserve the legitimacy of our institutions in accordance with the Constitution. Mr. President, let us act not with haste, but with honor. Let us preserve our republic, not fracture it. I did not swear an oath to defend emotion. I swore an oath to defend our Constitution. Thank you, Mr. President.
Senator Gatchalian.
Senator Gatchalian is recognized.
Thank you. Thank you, Mr. President. Mr. President, esteemed colleagues, I rise today to cast my yes vote. Respecting the unanimous decision of the Supreme Court, which has declared the articles of impeachment filed by the House of Representatives unconstitutional. The Supreme Court has decided, and as public servants sworn to protect and defend the Constitution, our duty is to respect the Court's decision and abide by the ruling. Napaka-specific po ng sinabi ng Korte, void ab initio, ang articles of impeachment. O sa madaling salita, as if walang nangyari at immediately executory ang desisyon. Alam naman nating lahat, dapat nating sundin ang saligang batas. Hindi natin pinipili kung kailan natin gustong sundin. Hindi ito usapin ng opinyon o sariling interpretasyon. Ito ay obligasyon, pananagutan at tungkulin natin sa bansa at sa ating mga kababayan. From the very beginning, malinaw at consistent ang posisyon ko sa impeachment. Follow the law. Nung nagtipon tayo bilang impeachment court noong June 10 para magdesisyon kung ang articles of impeachment ay dapat bang ibalik sa mababang kapulungan, I voted no. I voted this way dahil importante po sa akin na mapag-usapan ng articles of impeachment sa konteksto ng isang legal, maayos at malinaw na impeachment trial. Ito ay naaayon sa mandato sa atin ng konstitusyon. Ayon sa Article 11, Section 3, Paragraph 6 ng ating saligang batas, the Senate shall have the sole power to try and decide all cases of impeachment. There is no room for ambiguity. Ito ang proseso ayon sa batas at ito ang ating tungkulin. Ang isang pundasyon ng konstitusyon ay ang separation of powers o ang pagkilala na ang bawat sangay ng gobyerno ay may kanya-kanyang kapangarihan at tungkulin. Ang executive, legislative at judiciary ay may kanya-kanyang mandato. At pagdating sa usaping konstitusyon, the final authority is the Supreme Court. Mr. President, esteemed colleagues, this representation knows and respects that we have different perspectives on the verdict of the High Court and on the impeachment itself. Alam ko na marami tayong iba't ibang paniniwala at pagtingin sa batas. Pero alam ko na alam din nating lahat kung ano ang sinasabi ng konstitusyon tungkol sa mandato ng ating mga korte. Malinaw sa Article 8, Section 1 of the Constitution na judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on any part of any branch or instrumentality of the government. Sa isang desisyon ng Korte Suprema noong 2003 sa kasong Francisco versus the House of Representatives, sinabi ng Korte Suprema na the Constitution did not intend to leave the matter of impeachment to the sole discretion of Congress. Instead, it provided for certain well-defined limits and, in the language of Baker versus Carr, judicially discoverable standards for determining the validity of the exercise of such discretion through the power of judicial review. Sinabi rin ng Korte Suprema sa Angara versus Electoral Commission na the judiciary in turn with the Supreme Court as the final arbiter effectively checks the other departments in the exercise of its power to determine the law and hence to declare executive and legislative acts void if violative of the Constitution. Maraming iba-ibang halimbawa, pero iisa ang mensahe. mandato at responsibilidad ng ating mga korte na tingnan at i-review kung nagkaroon ng pang-aabuso, grave abuse of discretion o di tamang pagsunod sa proseso na itinakda ng konstitusyon. At gaya ng paggalang ng judiciary sa tungkulin ng ibang sangay ng gobyerno, it is our duty to respect the decision of the Supreme Court. Hindi dahil sinabi lang nila, kung hindi kinikilala at nirirespeto natin ang tungkulin nila. In this instance, following and protecting the process of the law means respecting the decision of the Supreme Court. Hindi ito simpleng pagsunod. We do not follow for the sake of following. Ang pagsunod sa batas at sa mga prosesong tungkol sa batas ay isa sa mga susi ng maayos na lipunan at pagbigay ng hustisya. Kapag malinaw ang ating proseso, madaling gumalaw, walang nasasayang na panahon, at mas madaling makita ang katotohanan. Law and order ensure consistency, and they preserve our way of life. Napaka-importante ng panahong ito. Ingatan at alagaan po natin ang saligang batas. It is not just any document or an ordinary set of rules. It is an expression of our collective vision as Filipino people. Defending and preserving the Constitution is not only our duty, it is the right thing to do. Thank you, Mr. President, esteemed colleagues.
Thank you, Senator Gatchalian. Mr. Secretary.
Senator Go.
Senator Christopher Bongo is recognized to explain his vote.
I vote yes, and I will explain my vote.
Please proceed.
Mr. President, I want to register my affirmative vote to adhere with the Supreme Court decision and to archive the articles of impeachment. The Supreme Court has already spoken in a crystal clear language. The court unanimously ruled that the articles of impeachment against the Vice President are unconstitutional. That the Senate did not acquire jurisdiction to constitute ourselves as the impeachment court, and that the decision of the High Court is immediately executory. The ruling is clear. Wala na dapat tayong impeachment na pag-uusapan sa ngayon. This principle of checks and balances of the co-equal branches of our government is the very foundation of our democratic and republican way of life. The separation of powers allocates to each branch certain powers and prerogatives that other branches may not question or interfere with. Disrupt that delicate balance and we shake, if not threaten, the foundation of our democratic system. When that happens, the people's faith in the various institutions of our government will be lessened. God forbid, we do not want to come to a point when our people no longer trust our courts. Sa ngayon, meron na pong unanimous decision ang ating Korte Suprema, igalang po natin ito. That is why I voted in favor of the motion to adhere with the Supreme Court decision. But let me be very clear. Hindi ko sinasabi na hindi tayo sang-ayon sa accountability. Sa pagkakakilala ko sa mga Duterte, hindi sila tumatakbo sa kanilang responsibilidad. Haharapin at harapin nila ang anumang hamon ng panahon basta ginawa lamang po ito sa tamang paraan. Nabanggit din ni Vice President Sara Duterte na handa niyang harapin ang impeachment case laban sa kanya. Ang sabi ko nga noong nagsalita ako rito last June para isuggest na ibalik ang articles of impeachment sa House of Representatives upang matingnan at masigurong nasusunod ang tamang proseso. I said that justice done the wrong way is not justice at all. Marami namang mekanismo upang mapanagot ang kahit sino mang opisyal ng gobyerno na may pananagutan. Kung meron mang pananagutan, ang mahalaga ay nagagawa ito sa tama at legal na paraan. Mr. President, mag-move on na tayo upang mas magampanan natin ang ating pangunahing mandato at ito ay ang magpanday ng mga batas. Batas na makakatulong sa mga mahihirap nating kababayang Pilipino. Napakarami pa rin sa ating mga kababayan ang walang maayos at disenteng trabaho. Napakaraming pamilya ang natutulog sa gabi na walang laman ang tiyan. napakarami pa rin sa mga mamamayan nating mga nagsasangla ng kalabaw, nagbebenta ng ari-arian sa oras ng tinamaan sila ng sakit, at napakarami pa rin Pilipino ang hirap makakuha ng mga serbisyo at tulong mula sa gobyerno. Kaya magtrabaho na lang muna tayo. Nabibigyan na po ang Pilipino dahil sa ingay ng politika. Politikang hindi naman masasaing sa umaga, politikang hindi naman pwedeng magamit pambayad sa tuition sa paaralan, politikang hindi naman makapagbibigay lunas sa may mga sakit. Let us buckle down to our work. The people expect nothing less from us. Ever since, I am for peace and unity. Nakikiusap po ako na magkaisa na tayo para makapagserbisyo na tayo sa ating mga kapwa Pilipino. Maraming salamat, Mr. President.
Thank you, Senator Christopher Bongo. Mr. Secretary.
Senator Ontiveros.
Senator Risa Ontiveros is next to explain her vote.
Salamat po, Mr. President. Mr. President, I vote no. The 1987 Constitution entrusted the duty to try and decide all cases of impeachment to the Senate. Today, we are voting to abandon this mandate. I reiterate that the Supreme Court decision is not yet final. Kahit paano mo baliktarin. So, make no mistake, this was an act of the Senate. It is our institution which, in the words of colleagues, killed the articles of impeachment. Ang pinanggagalingan ko lamang po dito, pananagutan. Our people must have the power to make the highest rulers accountable. The process of impeachment is meant to question the powers that be and whether they deserve that power. In short, karapat-dapat ka ba? Hindi po dapat mahirap at teknikal ang impeachment. Taliwas ito sa intent ng framers. It should not be taxing to hold power to account. Anything that will make it easier for a public officer to evade accountability should be opposed. Ang hangad ko sana ay matulungan natin ang isa't isa. Tulungan natin ang ating mga kababayan na sagutin ito ng buo, ng may tapang at ng walang paligoy-ligoy. Ma-dismiss man natin ngayon o ma-archive ang articles of impeachment, mas mahirap i-dismiss o i-archive ang daing ng mga tao sa pananagutan at katarungan. Salamat po, Mr. President.
Thank you, Senator Risa Ontiveros. Secretary.
Senator Lacson.
Senator Panfiloping Lacson is recognized to explain his vote.
Thank you, Mr. President. Without the words immediately executory and the phrase on 25 July 2025, which held, among others, that the articles of impeachment are null and void ab initio and that the Senate did not acquire jurisdiction over the same, I would have voted in favor of the amended motion because I have always maintained that we must respect and not disobey the Supreme Court. But since there's still a pending motion for reconsideration filed by the House of Representatives through the Solicitor General, I believe that the July 25 ruling is by no means final until it rules on the motion for reconsideration with finality. That being said, I would rather wait, not preempt, the final ruling of the High Court. It is for these reasons that I abstain, Mr. President.
Thank you, Senator Lacson. Mr. Secretary.
Senator Lapid.
Senator Lito Lapid is recognized.
Mr. President, rinirespeto ko po at ginagala ko ang kataas-taasan hukuman. Ang boto ko po ay yes. Salamat po.
Maraming salamat, Senator Lapid. Secretary.
Senator Legarda.
Senator Lauren Legarda is recognized to explain her vote.
Mr. President, distinguished colleagues, the Supreme Court has ruled with clarity. It declared the impeachment complaint not only constitutionally barred, but void from the beginning, and further held that the Senate did not acquire jurisdiction over the matter. This decision, by express pronouncement, is immediately executory. We in the Senate are stewards of the Constitution and the rule of law. Our fidelity must be strongest precisely when institutions are under strain or pressure. To proceed as though the ruling were uncertain or optional would be a departure from our constitutional duty. This manifestation is a commitment to respect the present authority of the court's decision while remaining open to its final word. I cast my vote without prejudice to the Supreme Court's disposition of the pending motion for reconsideration. The court speaks, and at times it speaks again. But until it does, the Senate must not act contrary to what it has already said. For these reasons, I vote yes. I honor the decision of the Supreme Court. Thank you, Mr. President.
Thank you, Senator Legarda. Mr. Secretary.
Senator Marcoleta.
Senator Rodante Marcoleta is recognized to explain his vote.
Ginoong Pangulo, noong ang ating Panginoong Diyos ay nilalang po niya yung unang dalawang tao, pinagsabihan niya rin po meron siyang isang sinabi sa kanila na para na rin po sa kanilang kapakanan. Ang sabi po niya, kayong dalawa, lahat ng nakikita ninyo na bunga ng halamanan sa inyong paligid at lahat ng mga hayop na nakikita nyo na gumagala riyan, pwede ninyong kainin para sa inyo lahat yan. Ngunit yung natatangi na puno na nandiyon sa gitna, ay huwag ninyong gagalawin. Matatagpo ang kabawalan ng ating Panginoon Diyos. Kaya lang po, meron pong isang ahas na biglang nakialam. Sabi niya dun sa babae, sinabi ba ikaw ng Panginoon Diyos na pagka kumain kayo dyan sa bunga nung nasa gitna na yun, ay kayo mamamatay? Oo, sabi ng babae. Eh, hindi totoo yun. Ang totoo niyan, pagka kumain kayo dyan, mas lalo kayong tatalino. Ito naman si babae, Mr. President, nakinig. At nung makinig siya, pinuntahan pa niya yung asawa niya. Yun po yung kauna-unahang under desire po, Mr. President. Napakain din po yung asawa. Ano po ang ibig ko sabihin? Bakit ko po nilalahad ang pangyayaring ito? Meron na pong kapasyahan Ang dami pong gustong sumausaw, ang dami pong gustong magsabi ng kaibayong pananaw at paniniwala doon sa kapasyahan na iginagalang nating lahat. Nang ibig ko po sanang sabihin, magpakaingat-ingat naman tayo kung sino-sino na lang ang nagpapayo sa atin. Kung mapapansin po ninyo ang karamihan ng nagpapayo na yan, may pagkakatulad po silang lahat Una, lahat po sila hindi nila binasa ng kumpleto yung rules of procedures ng impeachment proceedings sa House of Representatives. Sapagkat kung binasa po nila yon, malamang hindi po ganun ang kanilang ibinubulong. Pangalawa, lahat po nung yun ay puro paborito po ng mainstream media. Sila na lang po yung tinatanong Pangatlo, lahat po ng yun, walang pagmamahal sa mga Duterte. Ngayon, kung yung kalipunan po ng mga tao na yun, ng karamihan po sila, sa kanila ay nagsasabi, sila po yung mga legal luminaries. Tingin ko po sa kanila, yung iba ay legal mercenaries, Sir President. With all due respect to the word. Kaya po kung minsan, imbes na po malinawan ang marami po nating kababayan, nagkakaroon po ng pag-aalinlangan. Yung iba po ay naililigaw, nalilinlang sapagkat iba't iba Kaiba yung mga paniniwala, pinipilit at gustong ipilit na yung pa yung mananaig kesa doon sang kapasyahan na po na ibinaba ng Korte Suprema. Kung sa bagay nga po, sa una ko pong paghahalimbawa, Panginoon Diyos na nga po yun kinontra pa ng ahas Ginoong Pangulo, sa mga abogado po, palaging may biruan Kasi po, sa lahat ng pagdidiskusyon ng ating korte, lalong-lalo na po ang kataas-taasang hukuman, hindi naman po lahat ay agreeable. Merong partidong aggrieved siya, merong partidong masaya siya. Ngunit, sa katapos-tapusan wala po tayong magagawa kundi tanggapin ang kapasyahan. Minsan po sinasabi nga natin kahit pabiro, alam mo ninyo basta desisyon ng Korte Suprema ay nagiging bahagi ng ating mga batas, maliman o tama. Yun po ay nasa Article 8 Civil Code na binanggit na po kanina ni Senator Bato. Nang sinasabi po, judicial decisions applying or interpreting the laws on the Constitution shall form part of the legal system of the Philippines. Wala na po tayong magagawa doon. Batas na po yun Sa akin pong naunang talumpati kanina, Ginoong Pangulo, hindi ko na po ulitin. I will just request that my entire speech, Mr. President, be incorporated by way of preference to be included in this explanation in my voting yes for my own motion. Thank you very much, Mr. President.
Thank you, Senator Marcoleta, for your explanation. Madam Secretary.
Senator Marcos.
Senator Amy Marcos recognized to explain her vote.
Thank you very much, Mr. President. I vote a resounding yes. Sa hinaba-haba kong pagsisilbi sa Kongreso, sa 12 taon na nanilbihan kami, ang trabaho ng kongrestista, sa pagkaalam ko, ay maging kinatawan ng kanilang distrito o kanilang sektor. Bakit naman ngayon ay naging tagabantay na lamang sila ng humihiyaw na dambuhalang sanggol? Ginawa ng bonjing na armas ang impeachment. Ang dating para sana sa kaayusan ng sistema, ginagawang pampagulo, panakot at sandata laban sa mga kinaiinggitan, kinaiinsecuran ng mga lulong sa kapangyarihan. Galangin naman natin ang Korte Suprema. Huwag tayong umastang Supremer Court, Supremest pa. Wala namang ganun Sa mga kapatid kong senador, paano tayo magiging dakilang mambabatas kung tayo mismo ay hindi susunod sa batas? Ang boses ng Korte Suprema ay boses ng konstitusyon. At kung sino man ang sasapaw sa boses na ito ay isa lang ang tono, ambisyon. Kaya naman, mag-move on na tayo. Magtrabaho at huwag konsintihin ang isang spoiled na bonjing. Huwag nang busugin ng pabor. Huwag nang pumayag dahil may pabuya. Huwag tayo magpalaki ng buwaya, baby pa nga ang tawag, lulong na. Sa mga mahal kong kongresista, may suggestion po ako. Ito suggestion lang naman, Huwag niyong masamain. Kesa inaatupag ninyong palitan ang pinili ng taong bayan, binoto at minahal. Bakit di nyo nalang palitan ang tao, kayo naman lang ang pumili? Ayaw paawat ng iba sa kaka-flex. Ano kaya kung yung speaker nyo na lang ang paltan nyo? Kaya nyo yan. At dahil dito, bumuboto ako ng malakas na oo. Maraming salamat po.
Thank you, Senator Amy. Before the Secretary recognizes the next Senator, who are these people almost creating trouble there? Can you please trace their identities and send them out of this building? Secretary.
Senator Padilla.
Senator Robin Hood Padilla is recognized to explain his vote.
Maraming salamat po, Ginoong Pangulo.
A'udhu billahi minasyaitanir rajim. Bismillahirrahmanirrahim. Alhamdulillah rabbil alamin. Bismillahi wassalatu wassalamu ala rasulillahi. Assalamualaikum warahmatullah. Alam niyo po, ito na po siguro ang pinakamaligayang araw sa buhay ko sapagkat makasaysayan. Ako po ay nagpupugay at malalim na paghanga sa isinagawang paliwanagan ni Senator Marcoleta, Senator Soto, Senator Ontiveros, Senator Lacson, Senator Pangilinan, Senator Aquino, Senator Pia and Alan Cayetano, Senator Rafi Erwin Tulfo, Senator Mig Subiri. Ang palitan ng mga paniniwala sa plenaryo ay simbolo ng humihinga at buhay na Senado. Nagagawa natin ang kalayaan at kasarinlan. Isang demokrasya na naririnig ang bawat naratibo. Tagahanga po ninyo ako lahat. At alam naman po ninyo, sa maiksing panahon ko rito, ako ay pro-Westminster. At ngayon, system po, system. Yan po yung parang sa UK. At yan po yung nakita ko ngayong araw na ito. Ang lahat ng mga senador ay gising, ang lahat ng mga senador ay nandito, ang lahat ng mga senador ay nagtatrabaho sa ayon sa kagustuhan kong makita ko ang bawat debate at ang bawat opinion ng bawat isa. Kaya nagpapasalamat po ako. Napakagandang araw po nito sa inyong lahat at sa ating lahat. Ngayon, mga kababayan, gusto ko pong malaman ninyo na ako po ay nagbibigay-pugay sa lahat ng nanonood sa atin ngayon. Malamang, ang sasabihin ninyo, siyempre si Robin Padilla, ang boto niyan, alam na natin. Eh, mabuti po, alam nyo na. Ang gusto ko lamang pong liwanagin ay ito. Ang nais ko, sana, ay katapusan na nito. Dismissal. Una pa lang po, bago pa lang po kami na-convene, labag na po sa kalooban ko na matuloy ito. Nakita niyo naman po, noong nagkasumpaan, talagang ipinaglalaban namin na politika ito. Politika ito At kailangan ng due process. Pero natuloy pa rin po, nag-convene pa rin. Pero hindi pa rin po ako nagsuot ng robe dahil para sa akin ay protesta. Dahil ayoko po talagang matuloy. Bakit? Sa loob po ng matagal na panahon ni Bonifacio, ni Aguinaldo, panahon ni Aguinaldo, ni Quezon, panahon ni Marcos Sr., ni Aquino Sr., ni Aquino Jr., ni Arroyo, Marcos Jr., PRRD Duterte, HOR ngayon, at Vice President Duterte. Hindi na po tayo natapos sa usapin ng politika at yaan po ay pinagtibay ng Supreme Court sa kanyang desisyon na sinabi niya mismo, oo, politikal ang impeachment, pero hindi kailanman dapat masagasaan nito ang karapatan ng tao. Malinaw at yun po ang pinaglalaban natin at kailangan dumaan sa tamang proseso. At yan po ang pinaglalaban natin. Ngayon, mga mahal kong kaibigan, pagkatapos po natin marinig ang bawat punto ng bawat isa, sana po matapos na po ito at harapin na po natin ang mga tunay na problema ng bayan. Katulad po ng sweldo, katulad po ng agrikultura, pagkain, kaguluhan sa West Philippine Sea, sa buong mundo. Ang dami po nating dapat pag-usapan. Total, meron pa naman pong Pebrero. Ang sinabi naman po ng Supreme Court at ang Supreme Court naman po, ang siya naman po dapat na sinasabi ng saligang batas. Malinaw po. Matagal po akong ginawang chairman ng constitutional ni dating Pangulo Mig Subiri. Pinagkatiwalaan niya po tayo, pinag-aralan po natin yan, at malinaw sa konstitusyon na ang magpapaliwanag ng saligang batas ay Supreme Court. Kaya sana po, ako'y malungkot talaga dahil napunta tayo sa archive. Yung archive, binasa ko pwede pala yan hukayin anytime, kung ano man. So, hindi pa rin tayo natapos. Kaya sana po, bagamat ang boto ko ay yes, aray. Gusto kong malaman at mailagay po sa lathalan ng Senado na ako'y may reserbasyon dyan. Malaking reserbasyon ko dahil gusto ko dismissal. Tapusin na natin to. Hindi pa tayo natapos eh. Total, nasabi na lahat. Oh, ilang oras ang banatan. Pero hindi pa rin natapos. Kaya po, mga mahal kong kababayan, bago po ako umupo, nais ko pong malaman ninyo na ang inyong Senado ay tumatakbo. Huwag po kayong malungkot sa mga hindi pabor sa amin o sa mga pabor naman. Isa lang po ang masasabi ko. Tigilan na natin ang politika at mahalin natin ang bawat isa, magkaisa na tayo, pag-usapan natin ang mga totoong problema. Maraming salamat po.
Thank you, Senator Robin Hood Padilla. Madam Secretary.
Senator Pangilinan.
Senator Francis Kiko Pangilinan is recognized to explain his vote.
This representation votes no. Unang-una, ang boto na no ay hindi nangangahulugan na hindi natin nirerespeto ang pasya o kapangyarihan ng Korte Suprema. Lalo-lalo na't hindi pa ito pinal. Wala sa hanay ng mga senador na bumoto ng no ang nagsasabi na hindi dapat respetuhin ang pasya ng Korte Suprema. Hintayin lang ang final decision. Kung tutuusin, kung hinintay lang natin ang final decision, hindi tayo nagpasya at wala tayong ginawa na mga hakbang out of respect dahil nga pending pa. Wala tayong nilabag sa pagiging immediately executory ng desisyon. Kaya kataka-taka kung bakit kailangan magkaroon ng archiving. Pero pasya ito ng mayorya. Mr. President, bumoto tayo ng no dahil naniniwala tayo. Mas mainam sana na hintayin nga ang resolusyon ng motion for reconsideration. Dagdag siyempre dyan ang pagkilala ng prinsipyo ng co-equality sa House of Representatives. Yung interchamber courtesy, yung pagbibigay galang sa isang co-equal, respeto sa isang co-equal. Kaya nais po sana nating i-lay muna yung matter on the table. To vote to archive the complaint despite the MR still pending, I believe, Mr. President, and I believe the others who voted no share this position, is premature, as the ruling may still be reversed or modified. In addition, at ito nga ang isang contention, to vote to archive the impeachment complaint, if at all, is to give the Senate the powers which are only reserved for the impeachment court, deciding, trying, and deciding impeachment cases. Precedents were cited in that the Senate and not the impeachment court acted on the impeachment cases of former President Estrada and Merceditas Gutierrez. But we submit, iba yung facts nung mga kaso na yun. In the Estrada case, supervening events led to the termination of the trial. In the case of Gutierrez, the Senate did not convene as an impeachment court. Kaya iba, apples to oranges, ika nga. We believe archiving the case is a matter exclusively within the powers and jurisdiction of the Senate Impeachment Court. Kaya lay on the table sana ang maayos na proseso under our rules. Allow me to reiterate that the final decision of the Supreme Court, yes, must be respected. the Supreme Court ruled that the impeachment court did not acquire jurisdiction, and its ruling rendered the official acts of convening as a court, of taking the oath, issuing of summons, and remanding the complaint as, for all intents and purposes, nullified. Kaya tinanong natin kanina, ano na ang nangyari sa constitutional duty and constitutional power as sole power to try and decide impeachment cases? We took an oath to uphold and defend the Constitution, and that includes our own determination whether or not the nullification of the acts of the impeachment court, an exclusive sole power to try and decide impeachment cases, if the ruling was based on the facts and not on a misappreciation of the facts. Kaya nga, sana hinintay ang motion for reconsideration. The impeachment court, being ousted of its jurisdiction by the Supreme Court, is unprecedented, based, and sadly, as we read the ruling, the decision, based on the wrong facts. It is disturbing. The distinguished minority leader pointed out, point for point, in his interpellation and manifestation, the errors in the facts that the Supreme Court based its findings of grave abuse. I reiterate, one cannot be right with the law if one is wrong with the facts. And that's why napakahalaga nung motion for reconsideration. There is still an opportunity for the errors to be corrected, kaya nandyan ang MR. And this is the reason why we voted no. Napaka-precedent setting nitong nawalan ng jurisdiksyon ang impeachment court, nawalan ng kapangyarihan o isinantabi ang kapangyarihan, sole power of the House of Representatives to initiate proceedings, at naway sa pamamagitan ng motion for reconsideration, mabalik yung ating kaninang nabanggit na ma-harmonize yung lahat ng mga constitutional provisions na hindi nag-aaway kung hindi lahat ay mabibigyan ng legal at binding effect. The power of judicial review, the sole power to initiate impeachment proceedings, and the sole power to try and decide cases of the Supreme Court, of the House of Representatives, and of the Senate. Maraming salamat.
Thank you, Senator Pangilinan. Mr. Secretary.
Senator Soto.
The minority leader is recognized to explain his vote.
Mr. President, I have more than expressed myself on this issue. Just in addition, a lingering question. How can the Senate archive something that is not before it? The articles are before the impeachment court. Therefore, I cast a negative vote.
Thank you, Minority Leader. Senator Soto.
Senator Tulfo Erwin.
Senator Erwin Tulfo is recognized to explain his vote.
Ginoong Pangulo, mga kapwa kong senador at sa sambayanang Pilipino, bumoto po ako ng yes sa mosyón na sumasang-ayon sa desisyon ng Korte Suprema sa impeachment case laban kay Vice President Duterte. Ito po ay hindi sa gusto kong iligtas ang Vice Presidente, kundi dahil malinaw ang sinasabi ng ating batas at mas malinaw pa ang desisyon ng Korte Suprema na ito po ay labag sa konstitusyon. Alinsunod po sa one-year bar rule, hindi maaring magsampa muli ng impeachment complaint ng 1 taon matapos ang naunang reklamo. Ayon po sa kataas-taasang hukuman, ito ay nalabag. At bilang mambabatas, hindi ako pwedeng pumikit na lang sa harap ng isang tahasang paglabag sa ating saligang batas. At para saan o ano pa ang saysay ng panunumpa natin noong nakaraang linggo sa tungkulin na nakasaad doon na that I will protect and defend the Constitution kung ito ay susuwin lang naman natin. Ngunit, linawin ko ito. Ang boto kong ito ay hindi para i-absuelto si VP Sara Duterte. Sa totoo lang po, gusto ko siyang humarap sa paglilitis upang maipaliwanag ang mga issue upang sumagot sa mga tanong ng taong bayan at upang harapin anumang pananagutan kung ito'y nararapat. Dahil ang paninilbihan sa taong bayan ay hindi po pribilehiyo, kundi isa ring pananagutan. Public service is not just a privilege, rather it carries also huge responsibilities. Sa loob po ng mahabang panahon, nasanay na ang ilang matataas na opisyal kapag may kapangyarihan, may lusot. Kapag mataas ang posisyon, immune sa tanong o investigasyon. Tama na, panahon nang baguhin ito. Kung tunay po na walang kasalanan si VP Duterte, dapat siya mismo ang manguna sa pagbubukas ng lahat ng dokumento, paggamit ng budget at mga hakbangin niya bilang pangalawang Pangulo at kalihim ng DepEd. Walang dahilan para umiwas kung malinis po ang konsensya. Ang boto kong yes ay hindi pagtatanggol sa kanya, kundi pagtatanggol sa legalidad ng proseso. Hindi po ito ang wakas. Kung may basehan at sa tamang panahon, hindi po ako magdadalawang isip na suportahang muli ang isang lehitimo at makatarungang impeachment. Dahil ang pamahalaan po ay para sa taong bayan, hindi po para sa iilang nasa puder. Maraming salamat at mabuhay po ang sambayanang Pilipino.
Maraming salamat, Senator Erwin Tulfo. Ginoong Sekretaryo.
Senator Tulfo, Rafi.
Senator Rafi Tulfo is hereby recognized to explain his vote.
Mr. President, my vote is yes. Let me explain my vote. My dear colleagues, in our Constitution, the sovereign Filipino people agreed to establish a government that will run our country. Malinaw dito kung ano ang kapangyarihan ng bawat sangay. Ang legislatura ang tagagawa ng mga batas. Ang ehekutibo ang tagapatupad ng batas. On the other hand, ang Korte Suprema naman ang taga-interpret o tagapaliwanag ng batas kapag may hindi malinaw dito o may pagtatalo kung paano ito ipapatupad. Kaya naman, ang respeto ng bawat sangay ng gobyerno sa isa't isa ay mahalaga upang tuloy-tuloy ang maayos na pagpapalakad ng ating gobyerno. Under the Constitution, it is the House of Representatives that shall have the exclusive power to initiate all cases of impeachment. Wala po tayo papel sa proseso na yan. Our role only comes when a valid articles of impeachment complaint is filed before us. Mr. President,
The case before the Supreme Court is about the impeachment initiation procedure before the House of Representatives. Whether a case of impeachment has been initiated according to the text and spirit of the Constitution. Of course, I will not delve into the correctness of the decision of the Supreme Court, but I believe it is within their authority to interpret the Constitution and declare whether the actions and processes before the House is constitutional. And so, we must accord the decision of the Supreme Court the same respect that they give the laws that we enact as the legislative. That is the scope and limitation of our powers. Having said that, allow me to go to the clear, dispositive portion of the decision. Sa dulo po ng 97-page decision, ito po ang sinabi ng ating Korte Suprema. Una, the articles of impeachment are unconstitutional and are deemed null and void ab initio. In other words, walang bisa nung simula pa lang. Second, the court said, the Senate did not acquire jurisdiction to constitute itself into an impeachment court. Ibig sabihin, hindi nagkaroon ng Senado ng kapangyarihang maglitis bilang impeachment court. Mr. President, I agree that we should abide by the decision of the court to avoid any constitutional crisis. And if I were to take the duty to my heart, I believe the decision is very clear. No impeachment court was validly convened. That's my vote. With that said, however, there are concerns raised regarding the decision. So it is important for the Supreme Court to address these concerns. I have faith in the Supreme Court that it will perform its mandate. That's all. Thank you, Mr. President.
Thank you, Senator Rafi Tulfo. Secretary.
Senator Villanueva.
The Majority Leader recognizes Senator Villanueva.
Thank you very much, Mr. President. Mr. President, esteemed colleagues, this representation stands today not just a senator judge, but as a member of this institution who took an oath to uphold the Constitution. And I'm here, Mr. President, to explain my vote. But more importantly, to stay true to that oath, to serve with integrity and give life to the spirit of the law. Article 11, Section 1 of our Constitution provides that public office is a public trust. Ang isang katungkulan sa pamahalaan ay isang tiwalang ipinagkakaloob ng mamamayan. This underscores one of the core principles of democracy, that ultimate political power resides with the people. And thus, the preamble starts, Mr. President, we, the sovereign Filipino people, because the government's authority and legitimacy emanates from the people. Thomas Jefferson encapsulated the expectation from a person holding public office in one sentence. When a man assumes a public trust, he should consider himself as public property. Close quote. Kapalit ng tiwalang ipinagkakaloob ng bayan sa isang tao ay ang paglilingkod ng may katapatan sa saligang batas at sumasalamin sa mithiin ng bayan na nakapaloob dito. Ginoong Pangulo, pag-aari ka ng publiko dahil ang bawat galaw at desisyon mo ay hindi para sa sarili, kundi laging para sa bayan. While due process protects life, liberty, and property, public office is not private property. As Justice Malcolm wrote in Segovia versus Noel, a public position is not owned by its holder. Ang posisyon sa gobyerno ay hindi premyo o personal na karapatan. Ito po ay pananagutan at pagtitiwala ng taong bayan. During the July 26, 1986 discussion of the Constitutional Commission, it was noted that, and I quote, a violation of an oath of office is itself a violation of the Constitution because a public official's oath is in the Constitution, close quote. Thus, accountability is not only a moral imperative, it is a constitutional duty. Public officials are answerable to the people at all times, and the mechanisms of impeachment and oversight exist precisely because no one can claim a vested personal entitlement to office. Where accountability is demanded, due process must still be observed. Ngunit Ginoong Pangulo, hindi po ito dapat maging panangga laban sa makatarungan at lehitimong pagsusuri o gamitin upang gawing pagmamay-ari ang isang tungkulin pampubliko. Higit po sa lahat, hindi ito dapat maging kasangkapan upang takasan ang pananagutan. Wala po ni isa ang nakatataas sa pananagutan, nakakatakas sa pananagutan. Lalo na po ang mga nasa pinakamataas na posisyon ng ating bayan. Mabigat po ang papel natin dito sa Senado, Ginoong Pangulo, lalo na sa impeachment. Hindi po ito simpleng usaping legal. Desisyon po ito na nakabatay sa batas at nagmula rin sa ating prinsipyo at konsensya. The framers of our Constitution knew this. That's why impeachment decisions are ultimately acts of political and moral judgment, not just strict legal analysis. Kaya po malinaw ang disenyo ng ating saligang batas. Ang House ang may eksklusibong kapangyarihan para magpasimula ng impeachment, at ang Senado ang tanging may kapangyarihan na lumitis at magdesisyon. This is a sui generis role, unique, exemptional, and deeply rooted in our democratic system. That is also why both chambers of Congress were given the authority to craft their own rules of procedure in impeachment cases. May mga bumatikos po sa atin noon, Ginoong Pangulo, sa pag-remand natin ng articles of impeachment sa House. At sabi nila, ng mga bumabatikos, pag-iwas daw po ito sa tungkulin. Pero kung susuriin pong mabuti, Ginoong Pangulo, hindi po ito pag-atras sa ating tungkulin. It was a necessary and prudent step towards ensuring that the proper procedure was followed so that our decision as a court will not be marred by legal and constitutional infirmities. Now we are faced with the High Court's decision that tackles precisely that which we hope to avert when we remanded the articles of impeachment, Mr. President. So clearly today, the Supreme Court's decision in GR 278353 is a vindication of the Senate's action. We have been called so many names, Mr. President, and ridiculed in the digital court of public opinion. I'm sure the Senate President would likely agree with this representation that the allegations thrown at us regarding the impeachment and even the decision of the Supreme Court, a matter that we have no participation in, are extremely preposterous and absurd. But this exercise, while political in nature, is not about personalities. It's not about revenge. It's not about prevailing sentiments or personal biases. It is about upholding what is legal and constitutional and what will hold true in the years that follow. Let me make one thing clear to our kababayans, mahal nating mga kababayan. We in the Senate have never abandoned our mandate in this impeachment proceeding. Ang bawat hakbang po na ating tinahak ay nakaangkla sa kaluluwa ng ating bayan, ang ating inaalagaan at pinoprotektahan sa ligang batas ng Republika ng Pilipinas. But as they say, Mr. President, dissent is not a threat to democracy. It is essential to its survival. Kaya doon po sa mga pumuna, sa mga nagsabing mali ang naging pasya ng Senado, hindi tama ang ginawa po natin dito, naintindihan naman po natin sila kung saan sila nanggagaling. And in that same democratic spirit, I now take this opportunity to respectfully air my own dissent to certain portions of the Supreme Court's decision. While we respect the court's authority, I believe there are portions of the ruling that may have inadvertently made the already difficult process of impeachment even harder. Agree po ako doon, Ginoong Pangulo. Impeachment was never meant to be easy, but neither was it designed to be impossible. The framers of our Constitution deliberately relaxed the rules to empower the people and lower the barriers to initiating accountability against high-ranking officials. The Constitution even allows any ordinary citizen to file a verified complaint. Ang mababa at mataas na kapulungan ng Kongreso ang nagsisilbing takbuhan ng mamamayan sa mga pagkakataong wasak na ang tiwalang ipinagkaloob ng publiko sa mga iniluklok nito. And yet, Mr. President, with this decision, we now see new procedural hurdles that were not explicitly required by the Constitution, including the rigid interpretations of due process at the preliminary stage. These add layers of complication to a process that is already politically and institutionally fragile. Natin iingatan, tama po yun. Baka po mawalan ng saysay ang impeachment. Buhay sa papel, ngunit patay sa proseso. This was no accident of drafting, Mr. President. The framers of the 87 Constitution intentionally relaxed the requirements for initiating impeachment, lowering the vote needed from 2/3 as required in the past constitutions to just 1/3 of all House members. As explained by the framers of our Constitution, this was meant to I quote, make it easier, not harder, to hold high public officials accountable, close quote. They had lived through a time when power went unchecked and accountability was elusive. Kaya siniguro po nila na ang kapangyarihan ay laging may akaakibat na pananagutan. Mr. President, this representation did not come to this decision lightly. We understand and value the necessity of public accountability. Naiintindihan po natin yan. Napakahalaga po niyan. Walang sino man po ang dapat mailagay sa pedestal na hindi kayang abutin ng batas. Pero ang pananagutan po ay kailangan dumaan sa tamang proseso. Isang proseso na hindi lamang makatarungan, kundi naaayon at tumatalima sa saligang batas ng Republika ng Pilipinas. Sa mga ganito pong sitwasyon, hindi po naaalis sa aking isipan. Kung may mga meron po bang pagkakataon na maaaring labagin ng Senado ang mga ipinag-utos ng Korte Suprema? Maaaring halimbawa po nito ay kung may klarong panghihimasok sa internal rules o procedure ng Senado, ang Korte Suprema. Ngunit, Ginoong Pangulo, sa pagbibigay kahulugan sa nakasaad sa ating saligang batas, tanging Korte Suprema lamang ang may kapangyarihan bilang pinal na tagapagpasya. Article 8, Section 1 of the 87 Constitution expands the Supreme Court's scope of judicial power by mandating it to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. In the case of Angara versus Electoral Commission, Justice Jose P. Laurel, who later became the third President of the Republic, wrote, and I quote, "When the judiciary mediates to allocate constitutional boundaries, it does not assert any superiority over the other departments. It does not in reality nullify or invalidate an act of the legislature, but only asserts the solemn and sacred obligation assigned to it by the Constitution." Close quote. Noong pong tinatalakay ng ating mga constitutional framers ang probisyon sa Konstitusyon patungkol po sa proseso ng impeachment, binanggit po ng kagalang-galang na Commissioner Dodong Maambong ang isang sipi mula sa isang kaso sa Amerika. Ang sabi po niya, and I quote, "Ang impeachment ay ang unang hakbang sa isang proseso ng pagwawasto. Ang layunin po nito ay hindi personal na pagpaparusa sa nasasakdal, bagkos ang pangunahing layunin nito ay panatilihin ang pamahalaang naaayon sa konstitusyon." This quote captures the heart of what impeachment is meant to be, Mr. President. It is not about personalities or punishment. It is about protecting the very structure of our constitutional democracy. And sometimes protecting that structure means accepting limits, even when we disagree with how those limits are drawn. In this case, the Supreme Court, as the final interpreter of our laws, has spoken unanimously, and I will say it again, spoken unanimously, decisively, and with finality. It ruled that the impeachment complaint violated the one-year bar rule. The Vice President was denied due process, and that this Senate, as of the moment, had not acquired jurisdiction. Mr. President, in closing, again, I would say we may not agree with every word of that ruling. But the rule of law is not a matter of convenience. It is the foundation of our democracy. Upholding it, even when it is difficult or unpopular, is what gives this institution its credibility and our democracy its strength. To ignore it, no matter how justified we may feel, is to risk eroding the very foundation we are sworn to defend, our beloved Constitution. Kaya po, Ginoong Pangulo, sa liwanag ng ating saligang batas at bilang paggalang sa pasya ng Korte Suprema, habang kinikilala po natin na may nakabinbing motion for reconsideration na sinampa ng House of Representatives, and in adhering to the immediately executory decision rendered by the Supreme Court, I vote to transfer the articles of impeachment to the archives. Thank you, Mr. President.
Senator Villar Camil.
Senator Camille Villar is recognized. You may proceed, ma'am.
Mr. President, my dear colleagues, I vote yes to the motion to archive the articles of impeachment against Vice President Sara Duterte, respecting the decision of the Supreme Court. It is undeniable that the Supreme Court has the power under the Constitution to declare an act of a co-equal body as unconstitutional, a power known as judicial review. The power allows the Supreme Court to ensure that all branches of the government act within the bounds of the Constitution, and it should be respected. The three main branches of our government, the legislative, executive, and judicial, each is vested with distinct powers and functions by the Constitution, none superior to others. Each operates independently with its own sphere of authority and serves as a check and balance on the others to prevent abuse of power. This is the foundation of our democracy, and it ensures the rule of law, accountability, and protection of rights of all Filipinos. In this case, the Supreme Court has spoken. By a unanimous vote, the Supreme Court declared in clear and unequivocal terms the articles of impeachment against Vice President Sara Duterte unconstitutional and null and void ab initio for violating the one-year bar rule and due process clause. As a result, the Senate did not acquire jurisdiction to constitute itself into an impeachment court. This decision, finally, is immediately executory. Mr. President, we have heard many good arguments in the recent weeks from both sides. Just today, being the youngest member of this robust body, I have learned so much from our esteemed and distinguished colleagues. But to me, it is simple. The opinion, or the most important opinion, is that of the final arbiter of our Constitution, and that is the Supreme Court. I have faith that the Supreme Court has done their duty and fulfilled their mandate. Being a legislator and a public servant, it is my duty to abide by that decision. Not too long ago, I took my oath of office as a senator, and I swore to support and defend the Constitution, and I adhere to that today. To do otherwise can lead to uncertainty and chaos, and even a constitutional crisis. This is what the rule of law expects from each and every one of us. And to respect the rule of law is to respect our democracy. And that is why I vote yes to the motion before us. Mr. President, dalangin ko sana na marisolba na natin ngayon ito upang mapagtuunan na natin ng pansin ang mga tunay at malalaking problema na hinaharap ng ating bansa at ng ating mga kababayan, katulad ng mataas na presyo ng bilihin, pagkaroon ng wastong hanap buhay, kalusugan at kaligtasan ng bawat Pilipino. Maraming salamat.
Thank you, Senator Villar.
Senator Villar Mark.
Senator Mark Villar is recognized. You may proceed, sir.
Thank you, Mr. President. I rise to vote yes and explain my vote on the matter before us, and to explain why we compromised today on archiving this very important topic But of course, we must always remember that the status quo is that the Senate has no jurisdiction. So in legal speak, this complaint is null and void. Last July 25, the Supreme Court rendered a unanimous decision declaring the articles of impeachment against Vice President Sara Duterte unconstitutional, noting that it is barred by the one-year rule under the Constitution and then it violates due process. The merits of this decision are not an issue before us. The sole question we need to answer is whether the Senate should respect the decision of the Supreme Court. And I say clearly and emphatically, yes. The Supreme Court has the ultimate authority to interpret what the Constitution is. No one, including the Senate, can substitute its opinion over the courts in any matter concerning the Constitution. And the Constitution itself, in Article 8, Section 1, entrenches the court's role in interpreting the Constitution and determining whether there has been a grave abuse of discretion amounting to lack or excess of jurisdiction by any branch or instrumentality of the government. This includes the Senate, even when acting as an impeachment tribunal. Justice Laurel laid down the doctrine in the Supreme Court as the final arbiter of constitutional issues in Angara versus Electoral Tribunal, where it was stated that when the judiciary mediates to allocate constitutional boundaries, it does not assert any superiority over the other departments. It does not in reality nullify or invalidate an act of the legislature, but only asserts the solemn and sacred obligation assigned to it by the Constitution to determine conflicting claims of authority under the Constitution. At dahil nagdesisyon na po ang Korte Suprema, tungkulin po ng Senado na sundin ang desisyon na ito. Sumasangayon man tayo o hindi, dahil nangako tayo, bawat isa sa ating mga senador, that we will support and defend the Constitution of the Republic of the Philippines, that we commit to obeying all laws and legal orders issued by the duly constituted authorities. Nasa oath of office po natin ito. In staying true to our oath of office, we must abide by the order of the duly constituted authority in matters of the Constitution, the Supreme Court. We must uphold the Constitution. Thus, the Senate cannot acquire jurisdiction to proceed with the trial, much less issue a verdict. Tulad ng sabi ni Senior Associate Justice Leonen, the impeachment process is a constitutional process. And although it is also a political process, it is not isolated from the requirements of the Constitution as a whole. Kailangan obserbahan ang due process, ang tama at makatarungang proseso bago matanggal sa posisyon ang isang individual. Habang iginagalang natin ang opinyon at pananaw ng bawat isa sa mga importanteng usapin, kailangan natin igalang, kilalanin at bigyang halaga ang kakayahan at kaalaman ng mga maestrado ng kataas-taasang hukuman na binigyan ng kapangyarihan ng ating konstitusyon bilang huling hukom na ipaliwanag kung ano ang batas at kahulugan nito at magdesisyon ng pinal sa isyung ukol sa konstitusyon. By recognizing the authority of the Supreme Court on the matter, the Senate does not abandon its mandate and its wisdom as an independent political body, nor does it concede or submit to a co-equal branch of the government. We are simply upholding the rule of law. At kung susuway tayo sa desisyon ng Supreme Court sa isang isyung konstitusyonal, binabaliwala natin ang konstitusyon. Ito ay magdudulot ng isang krisis sa ating saligang batas at lipunan na hindi makakabuti para sa taong bayan. As a functional society governed by the rule of law, we must accord our democratic institutions with respect, value their guidance, recognize their competence, and cherish their independence. Mr. President, pinapatunayan ng desisyon na ito na makakaasa ang tao na ang due process ay hindi lang guni-guni o kasabihan walang katuturan. Na ang due process ay para sa lahat at hindi lang para sa mga kakampi. Isang patunay na mapabisi presidente man o ordinaryong Pilipino, makakasigurado tayo na ang mga institusyon, ang Korte Suprema at ang Senado ay handang ipagtanggol, pahalagahan at bantayan ang ating mga karapatan. Without the rule of law, people may act without accountability, government leaders may act on personal interest, individual rights can no longer be guaranteed. Without the rule of law, there can be no justice, no order, and no real democracy. To end, I would like to quote Supreme Court Senior Associate Justice Leonen, who penned the decision. There is a right way to do the right thing at the right time. This is what the rule of just law means. This is what fairness or due process of law means, even for impeachment. Maraming salamat po.
Thank you, Senator Villar. Before recognizing Senator Zubiri, I'd like to thank him for his patience because he's always last whenever we do nominal voting. At some point in time, you might want to make a motion, Senator Zubiri, for us to draw lots on which letter of the alphabet we will start voting.
Thank you,
The
Mr.
gentleman
President.
may proceed.
Maraming salamat, Mr. President. Alam mo po yun, Ginoong Pangulo, dahil magkasama po tayo sa Kongreso ng 3 termino. At dun sa 3 termino, na alam ko yung bilang po natin ay 265, 268 congressmen, napakahirap po pag ang iyong pangalan ay nagsisimula sa letrang Z. Kasi ako po ay palaging huli. Minsan po, wala na pong tao nakikinig sa akin. Yung janitor na po, mga page ang nag-aayos ng mga upuan. Pero, subalit na yung araw na ito, nagpapasalamat ako at napakarami pang senador na nandito po na yun. Nandito si Senator Bato, Senator Bong, Senator Robin Padilla, Senator Amy, Senator Erwin, Senator Mark Villar. Our Senate President Pro Temp, who's not listening, but he's here with us today, together with the movant, Senator Marcoleta, and all the rest, no? Nandito ang 2 Cayetano na kaibigan natin. Yung mga seatmates nandito and minority. Pero Mr. President, honestly, it pains me to vote against my minority floor leader. It pained me and Senator Lauren. But what we are called to do here today goes beyond a simple vote. We all know that, Mr. President. It goes beyond a simple vote. Rather, for me, it's a test of our commitment to our Constitution and the rule of law. When the House of Representatives transmitted the articles of impeachment to us in February 5, 2025, my position was clear. We must go ahead with the trial, as this is our constitutional duty. In many interviews, that's what I said. It doesn't matter how I feel about it, because many people already said that I was on the other side. But I've said it doesn't matter what my personal feelings are. What matters is that we proceed with our constitutional duty. When the motion to remand the articles of impeachment came up on June 10, 2025, it was also my position, again, clear, that we must remand the articles for this, not for the sake of dismissing the trial, Mr. President, but for the purpose of ensuring that the House of Representatives had not violated the impeachment process as laid out in the Constitution. I have always upheld the principles of rule of law and the primacy of the Constitution. And I've consistently shown the highest respects for the Supreme Court as the final arbiter of all constitutional questions. So today, again, my position is clear. We must respectfully adhere to the Court's ruling that the current impeachment complaint is unconstitutional. Our Constitution expressly empowers the Supreme Court to review even the article or the actions of political branches. In Francisco versus House of Representatives, that case which has been mentioned by almost all my colleagues here, the court affirmed that it is the final arbiter for constitutional questions with authority to strike down acts that violate the Constitution. Thus, I vote to support the Supreme Court on not to proceed with the trial of the articles of impeachment as it violates both the Constitution and the guarantees of due process, rendering the current complaint unconstitutional and void ab initio. The grave denial of due process only magnifies its fatal defect. Without jurisdiction, any trial would be meaningless and any verdict null and void, Mr. President. To disregard the court's unanimous ruling would be to invite a constitutional crisis and to break our oath to support and defend our Constitution. The power of impeachment is not without limits, Mr. President, my dear colleagues. It must be exercised within the boundaries set by the Constitution as interpreted by the Supreme Court. And let me be clear for those listening tonight. The court did not place the Vice President beyond scrutiny. It simply required that any future impeachment follow constitutional safeguards. As simple as that. A new complaint may be filed by February 6, 2026, lawfully and with due process, at doon na po natin magagamit, Senator Kiko Pangilinan, yung ating mga gown at robe. Kasi sigurado, as the day will shine tomorrow, there will be an impeachment case filed against her. And we will be ready. This time, we will be prepared and follow the due process that was mentioned by the Supreme Court. I speak, Mr. President, as someone who's been a legislator for over 2 decades now, together with the Senate President, long enough to know that our fragile democracy rests on the strength of our laws, that our freedoms are given shape by our rules and traditions. And you all know me as a stickler for rules and traditions, together with my minority leader. I have served in both houses, House of Representatives and the Senate, and here in the Senate, being formerly a majority leader, the Senate President, and now your Deputy Minority Leader. In all these roles, Mr. President, I've been conscientious in adhering to the rules and traditions that protect the integrity of our beloved institution. It is in this spirit that I adhere to the court's decision. My vote today is based on the Supreme Court's decision last July 25, 2025, without prejudice to whatever resolution it may later render on the motion for consideration. That's why I thank the good movement, Mr. President, to allow me to amend or to allow the amendment of his motion to make it a mere archiving of the document, because that will never stop us from being able to pull out that document from the archives. Maraming salamat sa ating mahal na movement, si Senator Marcoleta. Let me just say this, Mr. President, to end my manifestation and my vote. Restraint is not weakness. It is obedience to constitutional order. Let us act not in defiance of, but in deference to the Constitution, to the Supreme Court, and to the people who have entrusted us these powers in this very chamber. Daghan kay salamat sa akong mga kaigsunan, and may God bless us all. Maraming salamat, Mr. President.
Thank you, Senator Zubiri. With 19 affirmative votes, 4 negative votes, 1 abstention, the motion of Senator Marcoleta, as amended by Senator Joel Villanueva, adhering to the immediately executory decision rendered by the Supreme Court en banc on July 25, 2025, which among others held that the articles of impeachment are null and void ab initio, and that the Senate did not acquire jurisdiction, and to move to transfer the articles of impeachment in relation to case number 002-2011, entitled "In the Matter of the Impeachment Trial of Vice President Sara Zimmerman Duterte," to the archives. The same is hereby approved. Majority Leader.
Mr. President, Senator Bam Aquino would like to insert his explanation of vote into the record.
So inserted as requested by Senator Bam Aquino
And
into
together
the
with
records,
Senator J.V. Ejercito, Mr.
as well as that of Senator J.V. Ejercito. What is the pleasure of the Honorable Pangilinan?
Yes, just a parliamentary inquiry, Mr. President. If I recall, in previous votes, we first get the results of the vote before we go through an explanation of the vote. It seems like we have changed the process of voting.
That was upon the motion of Senator Zubiri earlier, which the chair explained before we put the matter to a vote.
But I raised this question because, well, the reason why, at least the practice was, the votes first before the explanation is that at times when there are contentious voting, the quorum may suddenly disappear, or there will no longer be a quorum because of the long process of voting. So
The gentleman is correct unless a member asks that the procedure we just adopted is instead followed, and in this particular instance, the Honorable Zubiri moved without objection from any member, hence the procedure that we adopted.
Mr. President.
Senator Zubiri.
Therefore, that motion that I made was only for today.
Okay.
We can
That
go
is-
back to traditional practice.
That is the understanding.
Thank you very
are
much,
correct,
Mr.
Senator Zubiri.
Thank you for the clarification, Mr. President, Mr. Majority Leader.
Majority Floor Leader.
Yes, Mr. President, some administrative matters, Mr. President. May I move, Mr. President, that we dispense with the reading of the journal of the 5th session, Tuesday, August 5, 2025, and consider the same as approved. So move, Mr. President.
Any objection? Hearing none, motion of the Majority Leader is approved.
Mr. President, with the consent of the body and noting that for some measures, this shall lead to a third committee referral, and upon consultation with the minority and conformity of the chairperson of the Committee on Games and Amusement, I move for the secondary committee referral and or change of secondary committee referral as the case may be on the following measures concerning anti-online gambling to the Committee on Banks, Financial Institutions, and Currencies, while the prior secondary referrals will now be third committee referral. This is in view of the measure's implications on the financial and banking system, particularly with respect to fund transfers and other financial transactions associated with online gambling platforms. These are Senate Bill number 30, 47, 57, 142, proposed Senate Resolution number 12, proposed Senate Resolution number 19, and the privilege speech of Senator Zubiri delivered last July 30, 2025. I so move, Mr. President.
The understanding is the lead committee will still be the Committee on Games. The Majority Leader simply changed the secondary
Yes,
committees.
Mr. President,
But
that is correct.
May we know if there is a third committee being referred to?
Majority Leader.
Sorry, what's the question?
If the third committee is Ways and Means, we have no problem with that. But if the third committee, as I read it, is the banks, that does not fall in the Rule
It's the
10,
second.
Section 15.
That's the second, Mr. President,
Second, not the third.
not
Your
the
Honor.
third.
So there are only two committees. Referral.
Three, Mr. President.
Three. What is the third?
The third is the Ways and Means, Mr.
Yeah,
President.
no problem with that. What about the others? I have a list here of your PS 19 and the privilege speech of Senator Zubiri referred to 4?
Including the privilege speech, Mr. President, of Senator Mig Zubiri.
You are referring it to 4 committees?
Three
committees
only, Mr.
and not
President.
Ways and Means and
Banks and
not Ways and
Games
Means
and
or
Amusement,
Finance.
Mr. President.
Yeah,
Games
but
and Amusement
if
being
it's
the
not
lead
Ways and
committee,
Means
Mr.
or Finance and you go beyond 2, you refer it to the Committee on Rules. That's the procedure.
That's why, Mr.
Yes,
President,
not the
we
banks,
are.
not the committees.
Yes, Mr. President, that's the reason why we are asking the consent of the minority, Mr. President. If it is not okay with the minority, Mr. President, I will.
Your Honor, the reason why it's the Majority Leader that's making the motion with the consent of the body is precisely because the request for additional committees was referred to the Committee on Rules, and it's the Committee on Rules now acting on that request with the permission of the body first.
It is now the Committee on Rules asking for the permission
Yes,
because it was
that is
originally referred to you already.
Yes, Your
Mr.
Honor.
All right,
President.
and, we were not informed.
Thank you for your understanding, Your Honor.
I told you.
Any objection
I told you.
to the motion of the Majority Leader? There being none, motion is approved.
Mr. President,
Before recognizing the majority floor leader, Chair would like to correct the case number it mentioned earlier. The record should reflect that the motion pertained to case number 003-2025. The correction is so ordered to be reflected into the records. Majority Leader.
yes, Mr. President. Mr. President, at this juncture, I move that we adjourn the session until 3 o'clock in the afternoon of Monday, August 11, 2025.
Before
moved,
acting
Mr.
on the motion of the Majority Leader, Chair would like to take this opportunity to thank the members of the Chamber, both majority and minority, for your presence, patience, forbearance, and magnanimity that we were able, in such a way that we were able to dispose and vote on this difficult matter of national interest in the most pleasant manner, form, shape, and size. Thank you very much. Is there any objection to the motion to adjourn? Hearing none, session is hereby adjourned until 3 o'clock in the afternoon of Monday, 11 August 2025. Thank you once again and good evening.
Thank you, Mr. President.